Right, it is now 9:30, so it's time for the inquiry to resume. First of all, just the usual announcements. If you could turn your mobile phone to silence, please. And again, no fire practice programme, so if we do hear the fire alarm, we go out of one of the two doors at either side, down the stairs, congregate at the council's car park, and don't obviously come back in the building until we're told it's safe to do so. Everyone all right with stairs? Yep, good. All right, thank you very much. Now, a few days ago we had the applicants put in those two court cases on the Oxford Law Conference paper, didn't they?
We did.
So I'm happy to accept those.
Thank you.
So we'll give those an ID number, all right?
Thank you.
And obviously they can be, questions can be asked about them to Mr. Bashforth if people wish to do so.
Thank you.
I think you were going to talk about the plans, so
You're quite right. I've been asked to ask you
yes,
a question to do with the extent to which committed developments elsewhere,
yes.
other
Yep.
committed developments,
yep.
should be or need to be reflected in our not updated parameters plans. The parameters plans aren't changing, but the context around them is
Yes.
changing. And I suppose, to be fair, so obviously the function of the parameters plans is very much to govern what is consented, obviously within our red lines. Obviously, that's what they're for. They're not there to reflect what appears to be a sort of evolving, not surprising given the length of this inquiry, evolving baseline position with other consented schemes. There can be, of course, there will be a context plan, not a consented drawing, but a context plan that explains how our scheme sits as against other schemes that are being consented. But I suppose the concern of my team who are in the middle of updating the parameters plans is that we want to make sure that the parameters plans that end up before the Secretary of State are solid and sound and not requiring of any amendments, etc. And of course, if something else gets consented in 6 months' time or whatever, we don't want to have to do a new parameters plan. So what the suggestion would be is just that we strip out consented developments from the parameters plan and we show them in non-consented drawings.
I was having a look at the plans earlier, and in fact they're not just on the parameter plans, they're on quite a lot of other plans as well.
Yeah, that's a good point.
So it would be a big task to keep changing them. I can understand that, and it's a waste of resources, really.
Yeah.
So I'm not adverse to what you're saying, as
Okay.
long as we have. But on that plan with the purple, they're the solar farm permissions, I think, the commitments. And we've heard that Pit Stop Farm has been approved now, and I think Vigo Lane as well has. But what about the others? Does anybody know about the other? I think there were about 4 of them on there, weren't they? We were trying to find the plan and didn't succeed in finding it.
We'll have a look. We think there's only 2, but we'll.
Oh, if there's only 2.
We think that's what we think.
Yeah.
But yes.
It is quite useful to see the commitments in the context of something.
Oh, definitely.
And I would have thought that they could be taken off all the other plans, but it would be useful to have them on the parameter plan.
That was the one I was suggesting taking.
I know you were, but
what if we did just a general context plan with all of them on?
Which was the parameter plan?
Which?
Well,
What if we did? We could do parameter. We could have a parameters plan without
Yeah.
them on,
All right.
and then we could do something called a context plan or whatever. But we could show
as
the
long as they've got
parameters.
it's got the site
It's got the same. We could have all the site parameters and the consent, but as long as that's not a consented drawing sort of thing, I think,
Right, I
and we
see,
call it something
okay.
different for information purposes only, then I think we're okay, and we wouldn't have to keep changing every time something changed.
No, I do understand that. I mean, to be quite frank, that obviously if things change between the inquiry and the Secretary of State's decision, the normal protocol is that we just send anything straight to the Secretary of State. However, it depends really what it is, and I would take a view, and if it, I might sort of deal with it in the report.
Of course.
Or I might not, depending on what it was.
Of course, of course.
So, you know, things do change. I do understand that. But would that, I'm just going to ask the council and the Mr. Barnes. Mr. Barnes, you start. Would you be content with that? Because that does seem a pragmatic.
It does seem
Isn't it?
pragmatic, Mama. I don't have Councillor Bonney here today, and I think she was the one who was particularly concerned about consented
You don't
schemes.
need to do anything
but,
today, so
no.
why don't you?
Yeah.
Why don't we just raise
Happy
this
for
again?
it to. We
Yeah.
could come back to it tomorrow once she's had
Yeah.
a chance to have mull it over, perhaps.
Thank you.
Yeah. Councillor Speed, you're for the action group. Do you think that's quite a good idea? Are you happy with that? Yeah. Mm-hmm. We'll reserve Councillor Bonney's view till tomorrow then. Councillor Speed, you say, and Councillor Miss Pereira, are you all right with that?
Whatever's going to be most helpful to the inquiry, really.
Well, I just think yeah.
Thank you.
So,
All right.
I mean, obviously, if there are other planning permissions, the Secretary of State will want to know about them.
They should be notified to the Secretary of State.
Yes. Well, notify through pins.
Through pins, of course,
Yes.
yeah.
And you know, we would want to know where it is.
Well, then it could just be a case of notifying and sending in an updated version of
It
the
could, yes.
for information only.
I mean, it depends what it
context
is.
plan.
I mean, you know, what implications there are. So, you know, that's always.
No, of course. No, I appreciate
But
it.
let's just deal with that when we come to it.
Yeah. We should just
Okay.
tell the Secretary of State to turn it around quickly. That's all we need to do. No problem.
Well, yeah.
And that was a
That's
joke.
out
That was a
of my
joke.
hands,
just to
I'm
be clear.
afraid.
No, I know. That was tongue in cheek.
Okay, that's fine. Thank you.
Exactly. Be careful what you wish for. Exactly.
Well, yeah, that's true.
Yeah.
Anyway, so anything else anyone wants to raise before we start?
Not from us. Thank you. Thank you very much.
Right, so let's try and see if we can finish Mr. Diamond.
Okay.
Let's see.
do it.
So we're on DM8.
We
I
are,
think,
and
at
we're
the
gonna-
moment, aren't we?
We are.
Should we just get?
Well,
that
should we go
up?
back to DM8? Exactly. Yes. Thank you.
Start.
So, if we're on, morning, Mr. Dygan. Do you want to turn your
morning.
microphone on? We left yesterday afternoon, having discussed a bit of DM8. So that's in the local plan. That's core document 13.1, and DM8 is to be found on PDF page 241.
Yes,
Thank you. I'll just let you. Are you there?
I have that up.
Thank you very much. Now, I've asked you a fair bit already about that section, paragraph 1 and what it says, and the table and what that says. And I'm sure the inspector now has a pretty clear sense as to where some of these dividing lines are between us on the interpretation of this policy. I was asking you about, do you remember interpreting the plan as a whole and the extent to which one should do that and how one should do that and all of that? Remember?
Yes.
One thing we certainly do is interpret the policy, if there is any ambiguity. I've got a feeling we might just have stumbled across a bit of ambiguity. If there is ambiguity, we look sometimes, don't we, or planners look to explanatory text to try and resolve it if we can.
Supporting text.
So, but that's what I meant. Supporting
Yes.
text that the plan doesn't include in the policy box, but that was
Yes.
there to explain, supporting text or whatever. And in this case, the supporting text for DM8 precedes it.
Yes, it does.
If we just turn to it, so it's just a couple of pages up on PDF 239.
I'm there.
Thank you very much. You're very, very quick on the documents. Very good. Now. There's a reference, so 7.3, and then the heading affordable housing, and 7.3.1 and following.
Yes.
This is the explanatory text that supports the policy. And it's familiar themes because the examining inspector talked about this policy and how it was designed and what it was intended to do. But we see, don't we, at 7.3.5, about halfway down, the reference to a SHMA from 2015.
Yes.
We see at 7.3.6 the first reference to PBA work, Peter Brett and Associates work, that was specifically doing some viability testing that, as the inspector had explained, was the sort of evidential foundation for the approach taken in this policy, the sort
Yes.
of zonal approach. This is the local plan viability testing document at 7.3.6, which recommended affordable housing percentages having considered viability for the borough, etc. You see?
Yes, I do.
And then we're told at 7.3.7 that DM8 aims, as far as possible, to meet the recommendations in the SHMA. The evidence base shows that affordable housing targets are not viable above a minimal level, and this has been demonstrated by a viability assessment. That's the Peter Brett work, obviously. Policy DM8, it says, sets out the affordable housing percentages, which will be sought on proposals in different market areas. Do you see?
I do.
So just to, I know we've obviously been over this at some length yesterday.
Yeah.
This is the text in the plan explaining that policy DM8 sets out different percentages differentiated by market areas.
Yes.
And if that's correct, as we discussed yesterday, if the table really is seeking to set out different housing market areas, as defined by the table in the plan that describes housing market areas, then actually you and me agree on the way that this policy operates.
I don't think we do.
No, it's an if. Do you remember? I know you don't accept that when it talks about local housing market areas, that's what it means. But if the table in DM8 is in fact talking about market areas, housing market areas, then we've agreed already that there's only one place that those are defined in the plan. And we've also agreed yesterday that if that's the approach to the table, then in fact we agree on its interpretation. You don't think that the table refers to housing market areas. That's the difference between us, isn't it?
No. So when we go to DM8, which we can do in a moment, it clearly talks about housing market areas.
Right.
And then, slightly confusingly or unhelpfully, what it talks about is a subset of the Sittingbourne housing market area.
Oh, I see. Right.
That's the only thing that if it is a housing market area as defined, in the earlier section that talked about Sittingbourne encompassing a number of communities.
Yeah.
Then the policy refers to only Sittingbourne Town, Iwade and extensions, which can only be a subset of the overall local housing market.
I'll just show you one more sentence in here before we go to the policy again. But your take, just to be clear then, and I've not understood this yesterday, which is my error. Your take is that in fact, when we get to areas in the box in the policy, it's trying to adduce subsets of a wider local housing market area as defined elsewhere in the plan.
Yes.
Is that correct?
Yes, it is. That's the only way I can explain it.
Right.
Because it, as we know, the wider housing market area includes lots of communities, a broader area.
Yeah.
Then the policy, the policy actually refers to quite specifically Sittingbourne Town and Iwade.
Right. Okay. Thank you.
Which is which I take the point. There is a disparity between what's in the policy and the broader definition of local housing market areas.
Yeah, we don't think there is, but you think there's a disparity. We think that it's talking about local housing market areas, like it says. But so the difference is that we think there's being a reference to the entirety of the Sittingbourne local housing market area in the table, and you think that it's a reference to a subset of the Sittingbourne local housing market area.
Yes.
Okay, that's the difference. Okay, at least obviously the inspector's to decide, but at least if she's clear on where we're coming from. Just next sentence in this explanatory text begins: viability is most affected in the housing market areas of Sheppey, Sittingbourne and Iwade, and hence, I'm so sorry, back in the explanatory text. So we were in 7.3.7 of the explanatory text on page 239. So it's 5 lines down. We just read the bit that says DM8 sets out affordable housing percentages which will be sought in different market areas. That's 4 lines down. And the 5th line begins, viability is most affected. Just to check. Thank you. Viability is most affected in the housing market areas of Sheppey, Sittingbourne and Iwade, and hence a lower percentage of affordable housing will be sought in those areas. Now, let's just see if that logic might reveal anything about the policy. When it says viability is most affected in the housing market areas of Sheppey, Sittingbourne and Iwade, that's a reference to the local housing market areas. isn't it?
So Iwade's not singled out in the housing market areas. It's a subset of the housing market area.
When the phrase housing market area in that sentence
Yes.
is synonymous with local housing market area, isn't it, or not?
So no,
You don't think so?
and I'll just explain why I don't think that.
Okay.
So Sittingbourne, in terms of its housing market area, is quite broad. If you were to say the housing market areas of Sheppey and Sittingbourne,
Right.
then this sentence makes sense because Sittingbourne encompasses all of those things that are defined in the earlier part of the local plan.
Right.
Why then, I question myself, like, why then does it single out Iwade, which is actually part of Sittingbourne? You wouldn't need to mention Iwade separately because
see.
it's already part of Sittingbourne.
I see. So let me just test your thesis in this way. If Iwade weren't specifically mentioned in this sentence, would you and me actually be agreeing on the interpretation of DM8? Because then you'd have a specific text that's telling you, that I think you'd accept would be telling you, that a lower percentage of affordable housing would be sought in the local housing market areas of Sheppey and Sittingbourne. Wouldn't you?
No.
You'd be interpreting 7.3.7 the same way I would if Iwade wasn't referenced.
So no, I'd be
No.
So just to clarify, I would be then interpreting 7.3.7 in
Yeah.
the way that you've described. Then when I get to the policy, I'd have to ask myself again, why does it mention Sittingbourne Town separately and Iwade separately, when clearly, if they're part of the Sittingbourne housing market area, they don't need to mention them separately.
All right. Okay. Thank you very much. Now, one thing I think we do agree on is that the intention of the Peter Brett work and then this policy that flows from the Peter Brett work was to differentiate affordable housing targets with reference to values in different parts of the area. By values, I mean sales values.
Viability, yes. Yeah.
Flowing from sales values.
Yes, I agree.
And I suppose costs as well, infrastructure costs as well. So as you say, viability.
Viability.
That was the
which
point. So it's
yes.
taken this disaggregated approach across, zonally, as it were, or by housing area or whatever it is, by different area. That was the purpose of the policy.
Yes.
And so we have to try and apply it and understand it with reference to that fundamental purpose, because that is literally what it's for.
Yes.
And Mrs. Dickinson explains in her evidence, which you were here for?
I was.
Just to check, yeah. What that picture, that's the right word, actually looks like. If you could just turn to her proof of evidence, please, which
CD.
is, just get you the reference, which I can't currently find.
37.
Yes, there it is. Mrs. Dickinson's proof of evidence is core document 37.10.2. And it's the main proof, if you would.
I'm there.
Thank you very much. And the section where she goes into the background to DM8 begins on page 47.
I'm on page 47.
Thank you. Hopefully, are you there? Yes, everyone's there. So towards the bottom, there's a heading, Assessment Against Local Plan Policy.
I see that.
And this is over a fair few pages, is Mrs. Dickinson's assessment of DM8. I'm not going to go through all of it. Obviously, she sets out what her view is. It's different from your view. She thinks it's an extension to Sittingbourne. You explain why you don't think it's all as an extension to Sittingbourne, but only some of it is, etc. She goes over her approach, but I want to ask about yours. But she says at 7.20 over the page that DM8 provides a methodology for varying proportions of affordable across the borough to reflect differentiations in house prices that intentionally is able to be applied flexibly to ensure that its purpose, which is not to put development at risk in lower value areas of the borough, is applied. Now that analysis, I think you would accept. I mean,
I do.
It marries with what you just said. And it's also that reference to flexibility. I don't know whether she was doing it deliberately, but exactly the same word was used by the examining inspector when talking about DM8. It's supposed to be pragmatic. It's supposed to be flexible, all of that. But you accept that.
I do.
And the point about this is not to put development at risk. It's because we know, do you remember all that stuff about not doing a viability first growth strategy within the Thames Gateway? We know that this is a plan that seeks to facilitate development, particularly in the growth area.
Yes.
Okay. And it doesn't want DM8 to... DM8 does not intend overly restrictive or overly, what's the word? Ambitious affordable housing targets, particularly in lower value parts of the borough, to depress the delivery of development. That's its purpose, is to avoid that depressing effect.
Yes.
At 7.22, Ms Dickinson explains that the basis of the zonal approach that undermines this bit of the policy that we're talking about was differences in values that Peterborough adduced in their viability work to inform the local plan preparation, which is obviously what we've been talking about.
Yes.
Peterborough, as she explains, 5 lines down in this proof, to illustrate this, she says Peterborough produced a heat map, and it was done by postcode area.
Yes.
Now, just to pause there, the evidential basis for this policy was adduced on the basis of a postcode map. Remember?
Yes.
And the local housing market areas, as defined in the local plan and the table that we looked at yesterday, those are also done on the basis of a postcode districts, aren't they?
They are.
So my approach, not yours, but my approach to applying the policy with reference to those local housing markets, which marry with postcodes, that approach is consistent with the evidential foundation for DM8, which was also postcode by postcode, wasn't it?
Yes.
So there's a consistency in my approach to the policy that's not, because you asked the inspector to look at the policy and start getting into areas that don't have to do with postcodes, that are areas that you're sort of, well, not mapped anywhere. They're just areas that you're seeking to interpret from the words themselves. But that such an approach is not consistent with the Peterborough evidential foundation for the policy.
I would disagree with that.
Right.
When you read the policy and it refers to Sittingbourne Town, it doesn't provide a postcode.
Yeah.
But Sittingbourne Town does have a geographic boundary.
Listen to the question. I didn't ask you whether you could define where Sittingbourne Town is. We've been over that yesterday. We know where the urban boundary, the built-up area boundaries are. I'm asking you about the evidence base that supports DM8. The evidence base that supports DM8, to which it was seeking to give voice as a policy, was an evidence base that was predicated on postcode areas.
Yes.
And my interpretation, which is one that's predicated on local housing market areas, which is what it says, is also an interpretation that's predicated on postcode areas.
Yes.
But your interpretation takes an evidence base that starts with postcode areas and seeks to apply it to areas that have nothing to do with postcode areas.
Correct. Correct. Now, the policy is quite explicit. When you read it, it talks about Sittingbourne Town and Iwade.
I know, that's what you say. All right, thank you. So anyway, that's the postcode point. And what Mrs. Dickinson has done through her evidence, she's spoken to this obviously at some length, so I'm not going to go through it all. But if we just skip ahead to page 52. I'm sorry, page 52 of Mrs. Dickinson, just to get the most up-to-date picture that we can. What she's done, do you have figure 7.4?
I do.
What Mrs. Dickinson has done, as she explained, is she's tried to update the picture, because we all agree, don't we, that the Peterborough work that informed the extant local plan and DM8 is all out of date.
Yes.
Thank you.
Yeah.
So Mrs. Dickinson has therefore tried to
refresh,
refresh, exactly. And she's used I suppose it's a more detailed approach to mapping that involves colours dependent on sales prices and, well, you can see what it's done. She's differentiated it by pounds per square foot in the most recent data period that she could adduce. Do you see?
I do.
Before we start getting into the sort of detail, this distinction between broadly the sort of north and I suppose the centre and the north maybe of the borough, and the south and the east of the borough. I'm being very crude here, but you can see what I'm talking about. The sort of Faversham and its surrounds,
yes,
if you like. Faversham and its environs versus Sittingbourne, and obviously the Isle of Sheppey as well. It is there to be seen. It's not some sort of theoretical construct. This distinction in Swale is real, and it shows up in a number of metrics, but one of them is just house prices.
Yes, I can see that.
And part of the reason that DM8 is so focused on Faversham, I say focused, part of the reason that DM8 is saying Faversham and its surrounds are up at 35% or 40% is to reflect that, whereas Sittingbourne's at 10 and the Sheppey's at 0, is as a response to this major disparity that exists in Swale across its different, the two different areas that the plan is predicated on. That's correct, isn't it?
Yes.
Thank you.
But as you'll see, red being the higher values, and you can see areas of blue, and as you say, Isle of Sheppey, Sittingbourne Town, for example, and I'm pretty sure that the other blue area is Tenham, are showing lower values. But
Yes,
then
that's right.
not as concentrated towards the east around, as you can see around Faversham.
Yes.
There's a lot of red, particularly even further to the east of Faversham.
That's right.
But I'd sort of say that indeed close to the site and in other areas,
Yes.
there are red areas representing, higher values.
Yes, there are. But overall, Mrs. Dickinson's correct, isn't she? To say what she says, 7.29, that the site's situated in a lower value part of the borough and in an area that overall is more aligned for sales values for Sittingbourne.
No, I'd disagree with that.
You disagree with that? You
Yes.
disagree that the site is situated in a lower value part of the borough?
Yes, and just to explain why. So at the moment, within the site, so that this is obviously, to come up with this information, what you look as
House prices.
House prices from sales, for example. If someone
Right.
sells a house, that then gets recorded and you're able to look up what people are selling their house for.
Yeah, but she's done it on a per square foot basis.
Yes, that's right. She's done it on a per square foot basis.
She has, yeah.
Now, within the application sites at the moment, there are very few houses. In fact, just when I turn my mind to it, there's 2 or 3 in the northern application along Hempstead Road, and I think there's only 1 or 2 in the southern application.
Uh-huh.
So it's not surprising that within the sites you don't see areas of red, because there haven't been any sales within that area.
That's absolute. That doesn't make any sense, Mr. Dygan. What about in Sittingbourne, literally next door? There have been hundreds of sales, and it's
Yes.
blue. The reason it's blue is because, albeit there have been loads of sales, obviously, this is a lower value part of the borough. There have been lots of sales over at Faversham. They're all red, and the reason is because the house prices over there are a lot more expensive. Don't you get? I mean, the whole foundational structure of this plan delineates 2 very different areas with very different characteristics. I know you missed that when you were doing your case officer's report and your statement of case, but we've agreed that that's the situation. And Mrs. Dickinson's correct that this is, the growth area bit, is the lower value part of the borough.
So this map doesn't show that, what it depicts.
Why not? Look at the colours. I mean, I'm colourblind.
Would you like
but
me
I
to
can
explain? If you'd like me to explain why I think that it is in an area where there are higher values. And just if you turn your mind to the southern site,
See, yeah.
and I can actually see right next door to the, it's potentially areas of Robmisham Green,
Yeah,
and I see that they're actually coloured red.
yeah.
Now, indicating that it's either second from the top or at the top, depending on how dark a red you look at it.
Yeah, yeah.
Now,
yeah.
that represents a community which is adjoining the site, achieving high sales values.
But it's not
the reason that it
remotely
doesn't.
similar. Come on, like
But can you let him finish? Thank you.
So, if you're achieving higher sales values in Robmisham Green, for example, I would say that it would logical if you had properties. There aren't any, but if there were residential properties for sale within the site, close to Robmisham Green, why wouldn't they be achieving something of the same value as in Robmisham Green?
you genuinely can't think of any answers to that rhetorical question. You're asking the inspector then to approach this analysis on the footing that a major new community of 8,500 homes right next to Sittingbourne is going to be achieving sales values at the level of a tiny village with a conservation area and a church and all the rest of it. You honestly can't see any answer to the question you've posed. Is that right? You think we're going to we'll be selling at the same levels as Robmisham Green? That's your take.
Well, it's within the. Now, if you're taking the red areas as being higher value, and they're right next to the site.
Yeah.
From my perspective, I don't understand why a new dwelling, which is in an area which is achieving high values, wouldn't potentially achieve high values.
Seriously, you're even though the houses in Robmisham Green, some of them have been there for hundreds of years, it's a completely different characteristic to a new community that's coming forward. It's going to be associated with Sittingbourne. Do you really see? Oh, but anyway, I'm going to stop.
Well,
you obviously see no difference between likely sales values that can be achieved for a new build housing scheme and those in a village in a historic conservation area. That's the situation?
So on that logic, if you were to
answer the question before you start critiquing my logic. Is that your position that you
yes, it is. So,
right.
And the reason for that, if you take your approach and you were to develop new housing within Faversham, which has high values and is very red, you'd be saying, well, you're not going to achieve those sorts of high values. It might be in Faversham, but it's a new dwelling, not an existing, in which case you'd be saying any new dwellings should be deflated in terms of their values and attract less of a requirement for affordable housing. That doesn't seem logical to me.
Have you checked to see? Sorry, I thought you finished.
So the northern site, and if I just look at the eastern armature of that, which is quite close to Tenham, and admittedly there aren't any properties for sale within the northern site, so it's very difficult to gauge whether you're achieving high or low sales values within the northern site. But I would say that is an area near Tenham where they're achieving lower values. I'd contrast that with the south of the southern site, and it's difficult, I'm saying I think that's Robmisham Green, which is achieving the high sales values. So, yeah, I do think that this map is showing that there are portions of the site that could well be achieving high sales values. They're close to the red part of the heat map.
Have you sought to take any specialist advice on that assumption? Have you compared it to the viability work that the council did to see what values your own team were assuming could be delivered, or is that just your take?
Well, I'm just looking at this map that you've presented me
not
from
asking that.
Ms. Dickinson.
No, I'm asking you. You've said that your assumption when you're approaching this is that we'll be achieving sales values at the level of the existing sales in Robmisham Green, etc., for the reasons that you've just explained, because you think that's the logic of this.
That's certainly the logic of
I've
this
not asked
map.
the question yet. I've not asked the question. You're asserting that. My question is whether or not you've actually sought to test it with reference to any specialist valuation advice, including, of course, from the council's own viability position that's agreed.
Yeah.
through.
So
Have
no,
you
I
or
haven't.
not?
No, I haven't.
Right. Okay. Well, that's the end of that. Thank you.
Sorry, you were talking about the northern site.
Yes.
And you said that looks as if it was could achieve lower values. So would that be a? Because I think you said that should also.
Yeah.
Be 40%,
Well,
wouldn't you?
Well, that's the way that the policy reads. the difficulty here, so we've got an updated heat map, and whilst I can see in the southern portion of the site that actually there are areas quite close to the southern area of the site where there's lots of red, the higher
I
values,
was just wondering about the north.
and then when we come to the north,
Yeah.
I don't see the same situation where there is lots of red.
Yeah,
What
so
does that mean then? Do you think that should be a lower?
Well, so this is an update to the map, but we don't have an update for properties close to Tenham. It doesn't suggest that
what do you
properties
mean by
next to Tenham should be.
I thought
It's
that,
got the map shows Tenham. I don't understand.
based on the most recent.
Yes,
Andrews
that's
Square
right. So then there's a disconnect between this map and policy DM8.
Okay. So you're saying that is your approach to the inspector that, notwithstanding the fact, just focusing on the north now, on the north, you're accepting that the northern scheme is in lower value parts of the borough in full. Is that right? I think
No, so
you're not. Which bits?
That's what you said.
That's what you just said. The northern scheme, just for a moment, you're accepting that. I put to you that Mrs. Dickinson said that the whole site's in the lower value part of the borough, and
Yes.
you disagree. And that, I think we're just going to have to leave that one there. But on the north, I think even you're accepting that the northern site, north of the A2, is in the lower value part of the borough, as this map makes obvious.
well, it's in the second lowest.
Oh boy. Lower.
Lower.
Okay. So,
No, I can't then reconcile that with the policy. The policy doesn't make an allowance for properties that might be adjoining Tenham.
No.
It doesn't mention Tenham
one
separately.
nice, easy way of doing it would be if you read the policy as referring to local housing market areas, because then the policy would then reflect the reality of the evidence base that sits behind it, which is to say 10%. So your approach asks the inspector, as a backstop, obviously, this is only under the review mechanism, that's what we're talking about, but to impose a 40% target on the northern scheme, which the whole purpose of which was to reflect the highest of the high rural, high value parts of the borough, which we agree the northern scheme doesn't sit within. Your approach is flatly inconsistent, not just with the evidence base of this policy, but with its express purpose, repeated like ad nauseam in the explanatory text, in the evidence base, in the inspector's report. Forget about flexibility and pragmatism. Don't you see this obvious problem? You're saying 40% for one of the lowest value parts of the whole borough. Do you see the problem?
No, I don't see a problem.
No. Okay, well that's good. Well then maybe the...
Ma'am, the policy sets out where lower amounts of affordable housing are required, such as Iwade and Sittingbourne Town. What the policy also does, but that then sets the target, and if the scheme is not able to meet that target, the policy provides for viability testing to allow a lower level of affordable housing to be provided. So if it turns out that a site is in an area that has a target of 40%, it's able to demonstrate that it can't meet that, that's acceptable, subject to a viability review mechanism.
I suppose, though, the thing is that if it were to be in the sort of 10% or whatever, and we know that I can't remember what the proportion that the northern site actually achieves, but it's certainly above 10%, isn't it? Mm-hmm. It wouldn't need to be viability tested at all, and there wouldn't need to be a review.
So the council's position, and this obviously relies on whether the Secretary of State considers acute care to be required or not. If acute care is required, it would be delivering less than 10%. There's just a second point in terms of another rationale, not the only rationale for understanding viability. So there is, as part of the applicant's argument, a need for revenue generating development to help cross-subsidise infrastructure. And the council wanted to understand whether that was accurate. In other words, do you need this quantum of development to cover the costs of infrastructure? So a slightly different rationale for viability testing than simply the level of affordable housing. So
Hang on,
there's an
where's that
affordable
come
housing question, but it also answers another question.
Well, no. Where have you explained that the Swale is interested in using viability testing to test this scheme's ability to pay for its infrastructure?
Sorry, describe for me what you mean.
You've just said that you want to use viability. Use Swale. I know Mr. Young wants to do it, but I've asked him, not him, but his witnesses about that a lot a few months ago, whenever it was. You've just said that Swale is interested in testing the scheme's ability to pay for infrastructure through viability testing.
And we have been
No,
since...
not and. Where in your proof is that explained?
So it's not on my proof because that is not the reason that we required the viability testing.
We'll find that.
However, it was one of the rationales for it was when members ask why do we need this quantum of development, the developer is saying it's needed to help fund infrastructure. To answer that question, the viability testing was very useful.
But that's not a utility that you've touched on in your officer's reports, your statement of case, your proof of evidence, or orally until about 20 seconds ago. And we've been going for, you wrote your reports last November. We've been going almost a year. You, Swale, have never sought to bring viability evidence to bear on the question of can this scheme afford its own infrastructure. That's totally new, Mr. Dygan.
Sorry, I don't understand what your objection is. I'm just explaining to the inspector that in addition to understanding the level of affordable housing, it also answers another question in relation to the quantum of development.
It's not an objection. It's a question to you that you've never said this before. This has never been part of Swale's case until the last minute and a half in writing or indeed orally anywhere in this inquiry, has it?
Mr. Simons, that's quite unfair. He's been asked a question by the inspector about viability, and he's explaining something that happened a long time ago in the course of processing the application. He's not suggesting it's part of the council's case now. So for you to suggest that he is and then criticise him for it is not fair.
Is it part of the council's case or not that viability in this inquiry is relevant to whether the scheme can afford its own infrastructure? I'll turn your microphone on.
Sorry, so we weren't refusing the application because of that. I've certainly been asked questions by the public and by members as to, the applicant is saying that this quantum of development is required. Is that the case? And the viability testing was able to answer that question.
So just to be one more, I appreciate you won't.
This doesn't go to the decision-making process or the recommendation.
Fine.
This goes to answering difficult questions from people that believed that, in actual fact, the promise in terms of delivery of infrastructure was a hollow promise, and then it's to answer that, it's like, well, actually, do you need this quantum of development? And the viability testing essentially showed that the schemes weren't able to meet the full amount, the 40%. Quite clearly, the quantum of development was necessary to cover the cost of the infrastructure.
Gotcha. I think so. I did go off on a wrong foot, for which I'm sorry, because it's not part of your case to the inspector or the Secretary of State that the viability evidence in this inquiry should indeed be employed to test its ability to afford infrastructure.
No, it's more a case of why would this quantum of development be needed?
Yeah.
Could a smaller quantum of development deliver all of this infrastructure? And the viability testing was very useful to be able to explain that.
And it's useful in as much as it proves that you couldn't deliver, and on your assessment, the infrastructure that's required through the scheme with a smaller quantum.
Yeah, and I think that's evident. So if the target is 40%, and I know we don't agree on that, even if it's 27%, it's not achieving that. Ergo, it certainly needs that quantum of development to cover the costs, and even then we have to accept less than the target level of affordable housing.
Yeah. So if the highways imperative of delivering the roads, the northern and southern strategic roads, is to be met, as we talked about last week, and if that's to be paid for privately, which we also talked about last week, accepting that there's no public funds available for either road to come forward, and if that's got to be done through revenue generating development, the council's accepting that that something smaller couldn't do it, that the scale of this scheme is commensurate with achieving those strategic goals. That's basically what you're saying.
If you had a smaller scheme with less revenue and you were still able to deliver it but not achieve the full level of affordable housing through open book viability testing, then it's likely we would accept a lesser amount of affordable housing in order to maintain the viability of the scheme.
Okay. All right. Okay.
There would come a point where there would be no affordable housing, like the quantum of development would not cover the costs of any of the planning obligations.
Yeah. Okay. All right. Last couple of bits on DM8, and then we leave it for now for the inspector to tease out in her report. The assessed. There's a reference to the assessed level of need in the plan. Sorry, if you turn back to DM8 itself. Sorry, you can put aside Mrs. Dickinson's.
Can I close that?
You can. Thank you very much. Excuse me. We'll go back to DM8 itself if you've got that handy.
I'm there.
Thank you. So, DMA1 we've been over. We know that the Faversham town and urban extensions is at 35%, all other areas at 40%, and so it goes. You think that's where we are, we think we're in 10%, and that's the debate for the inspector to resolve.
Yes.
And then we get to point 5 in the policy. In exceptional circumstances and in accordance with a SPD to be prepared by the council, there's a point about commuted sums off-site. The B is about commuted sums also, and C is the one that A and B not relevant here, but C, where an applicant can demonstrate that providing full affordable housing provision would result in the scheme becoming unviable, a reduced requirement may be considered, ... and should land values rise prior to the commencement of development or any subsequent phases, an adjustment made for the split. There's a reference to a legal agreement to ensure full provision if things go up. And then 6, if evidence demonstrates that economic... I'm sorry.
Shall we just read C in full, please?
I didn't mean to skip over it. Yeah, just because of the page. Where an applicant can demonstrate that providing the full affordable housing provision would result in the scheme becoming unviable, a reduced requirement may be considered that will be subject to a legal agreement to ensure that full provision of affordable housing is reconsidered should land values rise prior to commencement of development or any subsequent phases, or an adjustment made to the 10-year split. So that's the policy basis, you say, for the review mechanism in the 106.
Yes.
To which we will return in a couple of weeks.
Ma'am, if I just draw your attention to the viability review, should land values rise prior to commencement of development?
Yeah, all right then. Thank you. And then 6, if evidence demonstrates that conditions, etc., have positively changed the impact of viability, the council will seek a proportion of affordable housing closer to the assessed level of need or higher if development viability is not compromised.
Yes.
Just so we're clear on what the assessed level of need actually is. So there's all these different policy targets in the box in section 1 of the policy, and then there's reference to the assessed level of need. And the assessed level of need is an assessment that flows out of a SHMAR exercise, isn't it?
Yes.
And
but
I'm sorry, go on. Yeah, sorry.
You can interpret that one of two ways. So the assessed level of need, ma'am, you could go back to the housing market assessment and you look at, say, the borough-wide average.
Yeah.
I think at the time this was adopted, it was about 25% in the 2020, so it's not exactly brand new, but the more up-to-date housing market assessments talks about 27.7%.
Correct.
Now, the other way that you could interpret this, the assessed level of need, as in what's set out in DM8, in the right-hand column.
But that doesn't say that. Those aren't assessed levels of need. Those are affordable housing percentages or ranges that will be sought as a matter of policy. They don't reflect assessments of need. They reflect a balanced approach to not wanting to depress deliverability. All of that is explained ad nauseam in the evidence base. There's a SHMAR that tells you what the need is. The Peter Brett work wasn't looking at need, it was looking at viability. There's no basis at all for using that table as an assessment of levels of need in different bits of Sittingbourne or different bits of Swale, because that's not what the table does, is it?
No, I agree.
Okay, great. So we agree then, don't we, that the assessed level of need comes out of the most recent SHMA, and the assessed level of need is therefore 27.7%.
Yes, and then just that last portion, and I've got a couple of comments too. This is or higher if development viability is not compromised.
Yeah.
So if, for example, the assessed level of need, if the inspector thought that was 27%, and it's clear from the viability testing that it could do 30%.
Yeah.
Now, that's certainly what the policy says.
Yeah.
And I'm just mindful of what the MPPF also says. So I think there's just a degree of caution or pragmatism that needs to be taken in relation to that.
Well, on that we agree, Mr.
Part of
Daigan.
sense those last half a dozen words.
That language or higher is not consistent with the MPPF, because the MPPF would not suggest that you should be pushing contributions or requiring contributions that actually exceed the assessed levels of need in an area. If so, where?
I'd need to look at the MPPF wording. I'm happy to do that if you want to
do you
bring it up.
accept that the or higher, or you don't have a view on at the moment as to whether or not the or higher bit is actually consistent with the MPPF?
I'd need to look at the MPPF.
All right. Well, at some point maybe do that, but I don't want to pause to. I mean, it's more. I mean, hang on.
It will be in the housing section.
I mean, I suppose 59 would be one.
Para 59.
Yeah.
Has the framework changed in relation to these provisions since?
That's a good question. I would need to check.
2019.
I'm not sure. I don't think it's materially changed on this topic.
Because it was considered sound.
It was. That is
framework
true.
At the time,
That's
wasn't it?
true. But on the other hand, that's true, and obviously there's no, that's a fact. But DM8 is out of date, and it's a question of its weight, as Mr. Daigan explained, was it yesterday or last Friday? Depends on its degree of consistency with the current MPPF.
I don't think it's 59.
Is it not? Sorry.
And I apologise. I shouldn't have raised it because I can't now put my finger on exactly which part of the MPPF I should be going to.
Okay. Well, that's fine. I thought it would be 59 that talks about. Anyway, but that's fine. Fine. So at the moment, as we sit here, you've not got a view on the degree of consistency with the or higher bit with the current MPPF.
No.
Okay. But what we do agree on is that by imposing a higher limit in the affordable housing review mechanism of 40%, which is what you're suggesting, you'd not only be going higher than Faversham, higher than all the other rural areas in the dark red and all the rest of it, you would also be going higher than the assessed level of need in Swale.
So I don't think you'd be going higher than all the other red bits which are shown in Miss Dickinson's diagram.
Sorry, you're going higher than Faversham.
That's 35,
which is
isn't
at 35. That's what I meant to say, and you're quite right. You'd be at the level of all the red bits. You'd be going higher than Faversham because Faversham's 35%.
Yes.
Yeah, and you'd also be going higher on your approach, not only than those things, you'd be going higher than the assessed level of need in the SHMA.
Yes.
Okay. Thank you.
Okay.
We leave it there. We leave DM8 there, I say, with relief. Okie dokie, thank you very much. You can put DM8 away. And in fact, for now, you can actually put the development plan away, because obviously there are other policies, but DM8 was the one where there's a sort of proper interpretive debate between the parties. Most of the other ones are a bit more, it's more about how they're applied rather than what the words mean. So that's it on that topic, which is the development plan for now, the existing development plan. And the third of my 5 topics was going to be the emerging development plan, which I'm going to try and do a bit quickly because we have talked about this already, obviously, in previous sections of the cross-examination. So let's just start with the framework. Just to clear the decks, the inspectors mentioned this earlier on the inquiry, I've mentioned it before, but if we just start with the framework on page 14. So we're on the emerging development plan now, just to be clear. Changed tack from the existing development plan, which we've talked about a bit. Page 14 of the framework, determining applications. Thank you.
I see that.
Now, para 49 is the one about how much weight you give to relevant policies in emerging plans, and you give weight in accordance to stage of preparation, obviously extent of unresolved objections and degree of consistency. And long story short, we agree, don't we, that because there are no relevant policies that exist yet, because they're at that stage under 49A, because we don't even know what the objections are because the consultation hasn't started, etc. It's not possible to give any material weight to relevant policies in the emerging local plan at this stage.
No, that's correct. But the evidence base, and there's quite a lot of evidence, is capable of being a material consideration.
It is. But none of that evidence has been subject to, none of the more recent evidence anyway, has been subject to any none of it actually been subject to any public consultation.
Not public consultation, no.
So again, that means that even the evidence base, just looking at B about unresolved objections, obviously you can't know whether there are any objections or how resolved they may or may not be until you've consulted, right?
That doesn't mean that the evidence base doesn't carry weight.
I didn't say that. No. It's about how much weight. If you don't know whether there are any objections yet, and you don't know therefore whether they're resolved or not resolved or anything in between, that reduces the weight that you can attribute to the evidence base also. Obviously, doesn't it? I mean, if the evidence base had been tested through a consultation exercise and we knew that everybody broadly agreed, or it had been examined and we knew the inspector thought it was a good idea, you'd increase the weight to the evidence base. But we're not in that situation.
We're not in that situation. Just 49B talks about unresolved objections to relevant policies. The evidence base doesn't represent policies.
Okay, all right, fine. But anyway, so when it comes to policies in emerging plans, there aren't any. So no material weight to emerging policy under 49?
No.
Okay. Just a sort of note for the inspector, that is inconsistent with what you said about, you remember, was it yesterday? I can't remember now, yesterday or last week. You suggested that limited weight should be given to emerging employment allocations. And just to be clear, that's flatly inconsistent with the idea that, in fact, all the allocations, all the policies in the emerging plan get not limited weight, but zilcho weight because of the application of para 49 of the MPPF.
So I agree. So I ought not to have said that any weight should be ascribed to the emerging local plan. What I ought to have said is that weight can be given to the evidence base to the emerging local plan, which is a material consideration.
Thank you. All right. Okay, so that's 49. And 50 and 51 are the two policies in the framework that deal with prematurity. And I know this is something we agree on, but it's not something that everyone in the room agrees on, or that all the other parties to have spoken at the inquiry agree on. So I want to be clear on what the LPA's position is. 50 and 51 talk about the circumstances in which refusals can be justified of planning permission with reference to the concept of prematurity.
Yes, they do.
And just to be absolutely clear, none of those circumstances arise in this case. That is to say, neither 50 nor 51 are relied on by the LPA. It's not suggested by any stretch that these applications are premature within the language of the framework.
No.
Thank you.
I think can't think that the main party's view is that it's premature, is it?
I don't think the main part. I'm talking about people who
I
more
know that
members
there
of the
have been
public.
Objections
I wasn't meaning the council or even Kent or I think you're right.
I'm not. Kent wouldn't.
No. I'm just thinking through who the main parties are. What I'm meaning
I'm
is
talking about the action group and the 5 parishes. I don't think they've said it's premature.
Not within the language of the framework.
No. But it was more a response to the people who've spoken at the inquiry saying that the appropriate thing to do is to. But that's a fair. That's a good point. So the main parties aren't suggesting it's premature. Others have, which is more to say members of the public, really. But anyway, it's not the LPA's position.
No, do you want me to explain why, ma'am?
Well, if it's not between us, you don't. I mean, it's just because... Sure, go on.
Just in case people are listening and wanting to understand, there are two elements that need to be satisfied. The first is whether the development is so substantial that to grant permission would undermine the plan making process. But that's not the only limb. Two limbs need to be satisfied. The second limb, which must also be satisfied, the emerging plan is at advanced stage, but is not yet formally part of the development plan for the area. And ma'am, we've discussed the early stage of the emerging plan. It's been paused pending the outcome of the Highsted decisions so that the decisions can inform the direction of travel. So it's at an early stage, not an advanced stage. So it wouldn't satisfy that second limb of paragraph 50. So the borough's position is that there isn't a prematurity argument that can be sustained.
Thank you. Right then. So that's that. That's the position so far as national policy goes. Now, where are we in this process of the promulgation of a new local plan? Work on an update to, it was supposed to be a review of, as we know, the existing local plan, began pretty shortly after the adoption of the existing local plan, which was in 2017.
Yes, the adoption was 2017 and the work began 2018.
Yeah. And we've seen some of the early work that was instructed at that time by the council, including some studies by Peter Brett Associates.
Yes.
And if you just turn to one of them, one of those early pieces of work, the 2018 work that you've just referred to, it was late 2017 and it was published in 2018, called Document 18.32.
It's just taking a while to download.
No, of course, take your time.
It's not downloading for me.
Oh dear.
Just let me.
Oh no. Has the Wi-Fi gone?
Is it a very big document? Perhaps?
I'm honestly not sure. It's sort of colourful PDF, so it might
Maybe
be.
it is.
Okay. Yeah. Take your time. Yeah.
It's working on it.
It's working on
yes,
it.
Yes, it has.
It was super. Thank you. Yeah, I've got a feeling our luck on the IT is running out. This is a 20. It doesn't say on the front cover, but we know from earlier in the inquiry. This is a 2018 report from Peter Brett. You can see some dates on the second page. Talk about when it was prepared at the back end of 2017. It's published in 2018. We've been in it quite a lot. In earlier parts of the inquiry, just to put a couple of bits to you on the work that's been ongoing on the emerging local plan. There's Peter Brett's review turns to talk about transport and infrastructure on page 68.
You want me to go to 68?
Yes.
Yeah. I see that.
And again, a page that we've seen already. I think Mr. Wilde was talking about this, among others. There's a reference to on the left-hand side towards the bottom, there's some bullet points that start the number of new pieces of infrastructure have the ability to change our spatial strategy with regard to new settlements. And we're told here that the most influential proposed piece is the proposed link road, the A2, M2, the Sittingbourne Southern Relief Road and the Northern Relief Road. Unlock development sites, deal with infrastructure constraints that caused concern during the inspection process for the adopted plan, relieve congestion, air quality, all of that. And then beyond the bullet points, it says it's likely that the link in Junction 5A would create a step change in our ability to unlock land for new settlements. So we've concentrated on that proposal here. And then in the final bold text at the end, it's likely that these highway and rail improvements would only prove affordable if housing development was used to pay for them, in addition to major public subsidy. So the I'll show you one more page and then I'll ask you a question about all of this together. So there's that, and then that results in what's called the big picture analysis, which is blessedly short on PDF page 74.
The big picture.
The big picture, which summarises 73 pages of work that comes before, which I'm not going to ask you about. We're told that PBA's analysis is developments most likely to be environmentally permissible in the band of unconstrained land that runs from east to west through the centre of Swale. We've seen that. We've seen where that is before.
Yep.
2, developments most market viable in the area to the south and southeast of Sittingbourne and Faversham. Sheppey's unlikely to be popular. Subsidies unlikely to be available to make it so. 3, infrastructure change could have fundamental effects on the spatial approach to housing. In particular, the A2M2 link could unlock a large amount of development land to the south and east of Sittingbourne, solve congestion, air quality, etc. Now, this is one of the earliest pieces of work that was done by the council's consultants team in the build-up to its new local plan. And this is what it was concluding at the time. But it'd be fair to say that there's been no work that the council's commissioned since then from consultants that has said that any of this stuff's wrong.
So just bear with me. So I'm not a policy officer. I'm not aware of all of the studies.
Yeah.
With that caveat, no, I'm not aware of studies that have undermined or contradict this.
PBA go through, this was in 2018, but we've seen, I can take you back to, if you'd like, the 2019 studies. I'll just give the inspector the reference for time. There's one at 18.33 and there's another at 18.34. Which was the first was in March, the second was in October, where they go into, all the NS1 stuff. Do you remember? We've looked at it earlier.
Garden communities.
All that, exactly. And PBA's position at that stage, appreciating early stage, and boy, oh boy, we've had years worth of work from everyone that's been done since then. But PBA's position at that stage was that there were no showstoppers, that was the word they used, to prevent development emerging broadly in the location that's suggested here.
Do you want me to comment on that?
Do you accept that that's what they found?
That's
they found
what they
challenges,
found.
but they found no showstoppers with reference to landscape, infrastructure, heritage, you name it. They found no showstoppers. Do you? I can show you if you'd like, but do you?
No, I recall what they say.
Yeah.
I'm also aware that they didn't accurately reflect the objection from the Kent Downs National Landscape Unit, and that analysis that they undertook, and I'd just compare what evidence or what submissions they had and the level of detail that they must have had, because it's certainly a lesser amount of detail than the applications that I processed that benefited from things such as habitat regulation assessments, environmental statements, consultation responses.
Yeah.
They would not have said there are no showstoppers if they had had the sorts of objections from Natural England that I received through the application process. So clearly there wasn't that level of information or consultation undertaken by PBA at the time.
Not really a fair criticism of PBA, is it? I mean, they weren't judging a planning application. This was an early stage evidence-based work for it to inform a new local plan.
So it just goes to what weight you should give those PBA reports, because they were clearly high level and didn't touch on some critical issues. They didn't identify showstoppers, but nor did they have sufficient information to actually get to the bottom of whether there might be showstoppers, such as habitat regulations or Kent Downs National Landscape.
You referred to Natural England and habitats regs, because there's an objection, there's a challenge or whatever that comes in. But it's not a showstopper. That's the point. You've given an example of something that proved to be readily resolvable over the course of a planning application.
But it's not something that registered. That has been resolved. Yeah. But it's something that wasn't recognised at all by the PBA reports. But
that's just the point. That's supportive of their conclusion that there aren't showstoppers. I mean, are there any showstoppers from your point of view? Are there any? We'll come on to your detailed analysis. But are there any environmental impacts that simply, by showstopper, what I mean is, as a matter of principle, no scheme, forget about its merits or its scale or the benefits package or simply as a matter of principle, a showstopper, nothing can go forward because of X. You know, are we in that territory in your opinion here?
So describe what you mean by a showstopper.
I was trying to, sorry,
Yeah,
a bit
no, that's okay.
crudely. A showstopper, meaning we have a single point of objection that, regardless of any of the other planning considerations in the case, must necessarily lead to a refusal. That's what I mean by showstopper. A red flag that cannot be unwaved.
No, all of the issues, and some of them are very serious, need to fall into the planning balance. There isn't something, and I haven't come across something which doesn't matter what you think, whatever goes into the balance.
Yeah.
This trumps everything and cannot. So I haven't identified anything like that.
Nor have we, obviously. And so actually, I know you're sort of criticising the level of detail they had, but PBA were right. There are no showstoppers. It's a question of planning balance. I know we differ on the planning balance, obviously, but this is not a case where there are any showstoppers, any issues that must necessarily preclude development coming forward. It's a question of balance.
So I would say PBA were right by accident.
They were right by accident. That's a bit mean.
Fortunately,
Years of work on
it's
this.
transpired that they're correct.
Okay, well, as long as they got there in the end. Okay, so fine. So that was PBA. Oh dear, right by accident.
Not by
They were working
accident,
on this
but
for about
they
2.5
were correct,
years.
but not as a result of the level of detail that they
All right.
examined.
Let's just spin through the steps that have been taken during and since PBA did that work, so that the inspector's got a good handle on it. I'm sure he does already. If you just take out Mr. Bashforth's proof of evidence, and really this is just to pick out the key dates in one
And
handy.
close the housing choices.
You can.
Yeah.
Thank you.
Main proof of evidence?
Correct, which is 37.11.2. And Mr. Bashforth gives us a spin through the dates from page 17.
Yes.
And there's really, I'm going to go a little quickly, but just this proof has, and you've done it too, this proof has document references, so the inspector can sort of track these down if she wants to. I'm not suggesting you need to. Mr. Bashforth starts with the local plan inspector and the adoption of the local plan in 2017 at 4.9.
I see
It was
that.
in 2017. And then if you turn over the page, there was an early consultation and engagement document that was called Looking Ahead, which we've got in the core documents, and that's in April 2018. You see?
See.
And then, if you turn over the page once more. Oh, hang on. Where's February? Hang on. I've missed one. There it is, 4.19. Sorry, I was just looking for a date that I couldn't see. That this leads to he then summarises all the PBA work, and which goes on for obviously years of the garden community's submissions and the prospectus and the PBA analysis and all of that, and then it gets to a Reg 19. The Reg 19 comes in 4.19 of the proof.
I have that.
And that's notes that following a change in political control, there was a Reg 19 pre-submission in February of 2021.
Yes.
So we had a Reg 18 early stage in April 2018, a Reg 19 in February of 2021, and a further Reg 19 at 4.20 between October and November of 2021.
Yes.
And that's because, and this is all, we won't go through the legal challenge, but that was in part, it had to happen that way because of the Reg 19, the decision to press ahead with the Reg 19 in February 2021 without a further Reg 18 that had been promised ended up being, let's just say, retaken for whatever reason.
Yes.
Okay, so further Reg 19 done in October and Oh, Reg 18. Sorry. Reg 18, not Reg 19, excuse me. In October and November of 2021, this was a issues and preferred options local plan with 4 options, none of which includes Highsted Park. That was in October, November 21.
Yes.
And we note that concerns were raised even at that stage by Kent and others on highways grounds. If you just note for a summary of this, obviously Mr. Wild went into this a lot, but at 4.24,
yes,
it's noted that there were concerns of a fundamental nature. The council reported on some of these concerns in March of 2022, page 2 of the minutes, and has got document references to it, and then he underlines part of what was reported. Statutory consultees commented the need to clearly demonstrate why option 3 was preferred, and Kent highlighted the option appeared, based on current evidence, to have significant detrimental impact on road network, no obvious alternatives that could deliver the quantum required by the standard method within the timescale of the plan period without creating significant impact on traffic and air quality. You see?
I do.
And just to sort of state the obvious, at the moment, there is no answer from Swale to those concerns if these applications are refused. The highways work, such as it is, has not progressed to answer any of those questions to the satisfaction either of Kent or National Highways.
No, but you wouldn't undertake so what the council needs to do. Otherwise, if you take multiple growth options, you end up undertaking the highways analysis you end up sort of taking, rather than sort of undertaking a model, you undertake sort of like a dozen models. And so sort of testing each of the growth options and variations between them. So I think what they're trying to do is to understand what a preferred option is, rather than testing the highway implications for every iteration that could potentially be. That's
not quite right, though. We'll come into what has actually been instructed in the interim. You can't only do highways testing on a preferred option, because the highways testing will help you decide what the preferred option is.
Yeah, so that's understood. I think that there's that issue where you need to actually understand the different options and how the highway implications play out and amongst the different options.
That's right.
But in addition to that, there are many more options that are developed even before you get into the preferred options, and it becomes quite unwieldy if you're actually going to do detailed highway testing on them all.
Yeah, okay. At the moment, there are no options, and there's no... the question was, there's no highways answer, or no answer, if these 2 applications are refused. It's not like Swale's got some other answer at the moment that it can suggest to the inspector how OAN or LHN can actually be delivered without these significant impacts. It doesn't. You don't know if it can be done or how it can be done.
No.
I meant LHN, not OAN. That was a slip of the tongue. Yeah, LHN. So the situation to report to the Secretary of State then is last time Swale tried this, they were met with what we agreed to be fundamental concerns from the highways authorities. The highways authorities support the answer offered in this scheme to those concerns, which is to say the relief roads and all the rest of it. If that solution is to be refused, at the moment, we don't know if there is an alternative solution, and if so, what it might be.
No, we don't.
So, we are, just to sort of take stock, we are, is it eight and a half years or something after the last local plan was adopted? I think it was April, I can't remember. Anyway, it's 8 years plus since July, so not 8.5 years. 8 years plus since the last local plan. And we are 4.5 years since the deadline for the adoption of the early review. And where is the council? This is not a criticism. This is just trying to establish the facts. The council is about to, so it says, launch a high-level Regulation 18 issues and options style consultation. Correct?
Yes.
According to the LDS.
Yeah.
When I said about to, I meant, is it early next year?
It's early next year.
Early next year. No, the Reg 18,
No.
sorry,
Oh,
the
yes.
Reg 18 precedes this, but the Reg 18 will not set out draft allocations.
No.
It won't set out
No.
a preferred spatial approach. One thing the Reg 18 definitely won't set out is a spatial strategy that could both accommodate LHN and avoid crippling the highways network and ruining air quality without our scheme in place, because the council doesn't know if there is such a solution, or if so, what it might be.
The scope of the Reg 18 is set out in the local development scheme, and it's not full. It's a reduced scope Reg 18, if that makes sense.
Yeah. So it's
Do you
not
want me
actually
to
going
pull
to
up
offer
the
any.
LDS?
It's not going to offer a draft solution yet. That'll come at the Reg 19. It's more
Yes.
an exploration of ideas. Okay. So we know that we've been going 8 years so far. We know that we are going to get to Reg 18 next year. And if we just have a look at the LDS, which is
It's an inquiry document.
inquiry document, I think it's 100.66.
Just bear with me.
Thank you. 100.66, final page.
100.66.
I hope so, unless I've got it wrong. 100.66, final page of it. I think it's right at the very back.
And final page.
Yes, perfect. So actually we can see, just handily for the inspector, just before we look at the project plan going forward, the 3 consultations I've alluded to are listed there above, the ones that have happened before. The Reg 18, then the Reg 19, then the Reg 18 in 2018 and 2021.
Yeah, I see that.
Do you see the heading project plan going forward on page 7 of 7? LDS.
Sorry, we're in. Oh, sorry, I thought you were looking at the IDs.
Sorry. Yeah, it is the ID. It's ID 66.
Yeah, I've got that.
ID 66, final page 7 of 7.
Oh, I see. Project plan going forward. Yeah.
And so just to say, just for the inspector's note, those 3 consultations that we've just been talking about are actually handily listed there. The ones under previous consultations being superseded, there are 3 consultations listed, and those are the ones that have happened so far, as it were. Right then. So here we are, 8 years in, and this is the suggestion. The suggestion is that we do a partial high-level Reg 18 visions and objectives with some DM policies next year.
Oh, where does that say that?
I'm just reading. Do you see?
Left-hand column.
Left-hand column. Sorry.
Under project plan going forward.
Make sure we're in the right place. Do you have page 7 of 7?
Yeah, I have. Yes, I'm just looking.
Oh.
Vision objectives and DM policies.
Correct.
Yes.
That's what's happening in January and February. Now. Then the idea is we get to Reg 19, and that's a draft, obviously, but just to be clear, that your understanding is that's actually a draft plan. Once we get to Reg 19, we've got a draft plan for consultation.
Yes.
And that's happening in July. So that's happening a few months after the close of the Reg 18.
Well, yeah, March, April, May, June, July, 5 months.
5 months, yeah. Now, and then just so we're clear, that runs from July till September. And how many months does the council allow itself to review the outputs of that Reg 19 and to make any changes necessary in order to bring forward the submission version of the plan?
Well, October to December. So
No.
how many months?
How many months between getting all the Reg 19 stuff in, which would be the first time the council's actually consulted on whatever its strategy is going to be? How long have we got between the close of that consultation and the actual submission? How long is the council leaving itself?
So that when you read this, ma'am, this is back to back. So finish in September,
Yeah.
start in October.
Do you think you think that's realistic, Mr. Dygan? I mean, this would be, just to be clear, this would be the first time, the Reg 19 is the first time the council's actually, quote, showing its hand. It's the first time that the council's actually, that anyone's going to know what the allocations are going to be, what the housing number's going to be, what the employment number's going to be, where any of it's going to go, what the spatial strategy looks like. Forget about the, the detailed DM policies. You wonder whether people might have some things to say about some of this at Reg 19, and you wonder if the council might want to give itself an opportunity to actually think about any of it, or read it, let alone think about it. But in fact, the LDS has an immediate transition to submission.
It does.
That's totally unrealistic, isn't it?
I don't think so, and I'd be glad to talk to my policy colleagues and have them explain a little bit more what their strategy is for.
I think we know what their strategy is. We know what their strategy is to try and guarantee one way or another the submission of the local plan in time to avoid the transitional provisions that you talked about last week.
Yep.
But whether or not it's a realistic or even vaguely realistic strategy is another question. Just to sort of put this into context, the council so far has been trying to replace the local plan for 8 years plus.
Yes.
It's being suggested that the whole thing from Reg 18, Reg 19 up to submission is going to be done in under a year. I mean...
Well, so yes, that's what the LDS is suggesting.
That's what the LDS is suggesting, because it is transfixed by the prospect of achieving submission by December 2026, come hell or high water. But you can't support that as realistic, given the history that's been going on in Swale for the last, decade, but certainly 8 years. It's not vaguely realistic.
It's I think it is realistic. It's been prepared by the council's planning policy team.
Yeah.
These are professional people. I can discuss with them how it is that they are going to set about meeting these challenges, and ask them to explain that. But I'm certainly not suggesting that what they do is erroneous.
No.
In fact, they're a very professional team.
Oh, no, of course. I wasn't
they're suggesting that there must be some methodology. What they have said to me, though, is obviously the LDS, there are lots of things that could interfere with this, including the timetable, for example, for when a decision on Highsted might be taken. And if it is later than earlier, it may be that the LDS will need to be revisited.
Of course.
I understand the point about the transition window, but if it becomes impossible to achieve, that will be the reality. It won't be achievable.
Of course. Just trying to sort of test the realism. As you say, there must be some methodology that sits behind it, presumably. In a world where these applications are refused, in that world, the world that you're asking for, do you have any sense as to how far behind the council is at the moment in terms of the highways modelling that will be required to inform a Reg 19?
No. I could find out relatively quickly, but I don't have it to hand.
But you at the moment, you have no sense as to what modelling has been done, what modelling would need to be done, the issues to do with developing a new Swale-wide highways model, getting that not just developed supported by National Highways, and obviously Kent as well, forecasting, base models, local plan scenario modelling. Your current understanding is nil in respect of any of those things.
No, I'm not aware of those. But, ma'am, if you do want to know the council's position in relation to those things, I can go away, but I'd have to come back. I don't have those answers with me.
I think it will be. I would quite like to know what first of all, your local plans team thinks about the LDS timetable.
Yes.
That we were just talking about, and secondly, this point about highways modelling and how far that's gone.
Shall I tell you what our understanding is, and you can check it. This is from Mr. Wild. So this is you can then
Yeah. So it's just you said half a dozen things in terms.
Fair enough.
No, it was just if you repeat those queries,
Sure.
I'll attempt to find answers to them.
Sure.
Oh no. Well, Mr. Simons.
The first thing that the inspector was after was some understanding as to the LDS and why they think it can be correct, and then the second thing was under the sort of overall category of highways.
Yeah.
Let me just give you three things,
Okay.
three particular things: base model,
how long it will take to
Hang
create
on,
it?
let me just tell you what the three things are, and then
Yeah.
I'll just base model, forecast base, which is to say reference case model. So base model, forecast base, or reference case model, and then thirdly, local plan scenarios. So, just to expand on what we think, but you can obviously you check, and obviously if we're wrong, that'd be very important to understand. On the base model, the first thing, our understanding is that Kent have commissioned Jacobs to prepare a new model for Swale. As we understand it, the base model work is complete, but it's not been validated, or at least it's not been validated in the public domain yet, but has definitely not, we think, been signed off by National Highways as being fit for purpose yet. So that's the base model. You know, this is obviously for Mr. Dygan to confirm.
Yep.
That's the. Sorry.
It's not validated and National Highways haven't.
That's our understanding.
Okay.
Second thing is the reference case or the forecast base model. There isn't one. And work would have to be done to code Highsted in or out for this scenario. And that also, therefore, has not been agreed on by National Highways. So that's what we think, but you can check.
Yep.
And then thirdly, sort of as a consequence of 1 and 2, local plan scenario testing, there hasn't been any. Exactly. That's yes, exactly. So, but the point is that because there aren't any, and because there's no validated base model or approved forecast reference case model, nor have the highways implications of any local plan scenarios, which there aren't any, as you say, been tested yet. So, our estimate to do all of that is around 9 months to a year, best case. Just to do that work. So in order to inform a Reg 19, I mean, you can't, anyway, but because the Reg 19 is a preferred option. It's not issues and options. The Reg 19 is saying this is the plan. So if the Reg 19 were to be informed by robust transport evidence, which is an if, given what Swale did last time, but if it is, we think, many months away, even just from the highways component of a new a new Reg 19, let alone everything else that needs to be done, obviously. So yes, we think that. But anyway, that's the reason I've said all that, Mr. Dygan, is so that you can check and you can tell us if we're wrong.
Yeah, no, that's fair. I'm just not a policy officer, and I'm not best placed to answer.
Totally understand that, and that's not
answer the question about does the LDS work, and then in terms of the highway modelling, I'm not abreast of that.
Of course,
either.
no, I didn't expect you to be, and so it's really just to show our cards on the table as to what we've been looking into. It. We think that's the situation, and obviously most of these things are just questions of fact as to what has been done and what hasn't. So we'll be very happy for you to come back.
And it would be useful to know whether your what your local plan colleagues consider is necessary in order to inform the Reg 19 in terms of highways work, like that.
Absolutely, yeah.
To inform the Reg 19 consultation.
Yeah, I mean, how far do they think that the highways work has got to get in order to, before the Reg 19 can be released?
Yep.
And I suppose if we're doing that, the submission as well, if there's a difference between the two, because the submission is a couple of months later. The submission, of course, is the submission to the Secretary of State that the Council thinks is sound. Yeah. If there's a difference between how much, I don't know if there is, I would have thought all the highway stuff needs to precede the Reg 19, but if the answer is, no, we only need some of it before the Reg 19, I'd like to know whether or not the rest of it needs to come before submission, or whether they think it can just come later, if you see what I mean.
Okay, so just a question on, is there a difference between Reg 19 and Reg 22 in terms of what might be needed?
What might be needed to inform highways, if there is a difference.
Maybe one of your colleagues, maybe it would be useful for one of your colleagues to come and tell us.
Yeah.
Up to you, but...
well, I can certainly ask the question, but I've asked that question before.
Right. I mean, I would certainly welcome opportunity to be able to ask some, I know they've not got proof of evidence from them, but I would very much welcome the opportunity to ask a policy colleague these questions, because our own position, just for what it's, again, cards on the table, I'm sure it's obvious from our line of questions, we think that the LDS is absolutely, wildly unrealistic and totally without foundation. But it's all very well me saying that to Mr. Digan. He can't answer any of these questions. It's not his fault. It's not his job. But I'll leave it there. Obviously, if anyone can be persuaded to come along, that would be great.
Well, perhaps Mr. Pereira, you could have a think about that. I mean, it's your case, isn't it? Well, on behalf of the council.
Okay. Right.
Well, hang on. So it's
oh yeah.
time for a break.
Almost. If I just almost finish on the LDS,
sure.
and then that in 5 minutes, and then that's a good time for a break. So just on the LDS, I mean, you've said about as much as you can. We know that you called the LDS optimistic in your evidence in chief. I don't know whether you remember that or whether that was a slip of the tongue or you meant to say it.
I can't recall, but
Fair enough.
I'm not disputing. I may well have said that.
Do you accept it is optimistic?
Yes.
Okay. So I suppose the difference between optimism and unrealistic. But anyway, and just one thing.
Yeah.
If as you've explained, a number of things might happen. The Secretary of State could delay a decision in this case, or other things. Highways evidence could be quicker. Exactly. No, things could happen so as to make that December 2026 date unachievable, whatever those things might be.
Yeah, so having discussed some of this with my colleagues, particularly in terms of, we don't have certainty around when a decision on the Highsted applications would be made.
Yeah.
And therefore, if it's earlier, if it's later, are you going to hit the transition window?
Yeah.
And pragmatically, they said, well, obviously, if it's later, we would need to adjust the LDS.
Of course. Or other things might happen. It's not just about when the Secretary of State issues a decision here, that the Council might decide it wants a proper highways evidence base this time before it has a go. But whatever. Whatever the issues are, it may delay beyond December. As you say, December's optimistic anyway. But if here's my question, really. If it delays beyond December, which is possible.
Yes.
Obviously, if it delays beyond December for submission, then it's not like everything just gets shunted back a month or two. We're potentially into a fundamental reconsideration of the local plan because of the need to...
because of the different regime.
Exactly.
So I don't know enough about the different regime. I know, for example, that plans have to be updated every 30 months and so forth.
Yeah.
But I understand it is a different regime, and I do accept that with different plan-making regimes that have different requirements, particularly if they've just been newly introduced.
Fair enough.
If it's newly introduced, we won't be really experienced at dealing with that newly introduced regime.
Yeah.
And, when you do things for the first time, sometimes they take longer.
Yeah. Okay.
Perhaps that could be added to the... Well, I don't know. I mean, I don't have much to do with local plans these days, but I don't know what this new regime is.
Yep. Okay.
Useful to know. I expect the applicants know, but
we do, but absolutely. Well, if there's a local plan colleague coming, that would be perfect to ask them. And so, just sort of testing it all, we know because we went over this with the extant local plan. Work started in 2008 and progressed over many years, and it ended up getting adopted in 2017. Right.
Yep.
That was a 9-year period, or 9-year period, or thereabouts. This time we're already 8 years in, and we're back at the high-level initial Reg 18, and you're asking the Secretary of State, or not you, your colleagues are asking the Secretary of State to accept, notwithstanding that history, which is to say one new local plan since 2008, and here we are in 2025. You're asking the Secretary of State to accept the prospect of a new local plan, 2 years from now, without any highways evidence to substantiate that position. I mean, that's basically the situation.
Yes, it is.
Okay, that's it on the LDS, and thank you very much. Obviously, more on that if I don't know if a local plan colleague can come, great. But if not, then we'll make closings on that basis. Thank you.
Just before we wrap up, ma'am, because I think I've missed one of the queries that you asked.
Sure.
So the LDS timetable, and how does that work, particularly with the back-to-back?
yes.
The highways, and we're asking the question about base model, forecast base, and local plan scenarios.
Yep.
And then just the applicants explained they think that that might be about 9 months of work.
Yeah.
Ma'am, you had asked
9 months minimum, but
Minimum.
9 months plus.
plus.
Let's ask what they
What do they think?
thought
Yep.
is. I mean, whether they'll wait for it, or I think that was the point really. Are they going to rely on the highways modelling before they do the Reg 19, or even before they do the submission?
Yeah. And then there was
And the last thing, if that's what you want.
well, the last thing was the new plan making regime, but I thought there was a question in between that.
Was there?
Ooh,
Um,
I'm happy to be wrong.
I hope so.
I think that's about covers it, doesn't it?
Yeah, okay.
Yeah.
Thank you.
I think so. I think that would be, if they, as I suspect they probably won't want to come. I mean, if they do want, if they are prepared to come, you have to explain. They will have to answer questions.
Yes.
from Mr.
Even a note, if they won't come, would take a note, or I'd take as a fallback. I mean, obviously, best case would be that being able to ask them questions.
Otherwise, yes, a note would be
A note.
would be the second best.
Okay.
Looking at me, I mean, I'll need to take instructions, and Mr. Dygan's
You will.
my key contact on taking instructions.
Well, I mean, I don't see any reason why that you shouldn't, Mr. Simons. That's all right. I don't see any reason. I mean, Mr. Pereira has to take instructions about all of this if we're to have a local plan person coming, and obviously Mr. Dygan is in the witness box. But I wouldn't have thought there's any difficulty, would you, of him?
What, taking instructions on this question?
Yes,
Not at all. No, we'd be perfectly happy. Thank you for asking, but
And
no,
you don't mind if I talk to the policy team?
not at all.
Yep.
Not from our perspective.
Yep.
Not at all.
I don't want to second guess what the answer from the policy team might be. Sorry, I don't want to second guess what the answer from the policy team might be, but given we don't have a prematurity objection or anything of that sort, it may well be that the pragmatic answer to this is for a note on the questions, and then you can attach what weight to it and make submissions as you wish. I'm also mindful of time, to be honest.
Yeah. No, so are we, and there's no objection.
No,
Fine.
a note will be fine, but it's important.
Yeah.
isn't it?
Thank you.
All right. Right. We'll have our usual 20-minute break. I think we will. And actually, let's look at the time. 11:12. Oh, should we have till 25 to? Seeing as we've been going. Yeah, 25 to 12. Then. Thank you very much. So it's time for the inquiry to resume then. And would you like to carry on?
I will.
Mr. Simons?
Thank you very much. Thank you very much, and good morning again, Mr. Dygan.
Good morning.
We're getting there in terms of the emerging plan. There's not much more to say, obviously, about the emerging plan. But there's just one sort of almost point of detail that I did say to the inspector I would just check with you. And that, do you remember when Councillor Speed was giving evidence?
Yes.
And he was talking about what he thought would be the... we won't go over the detailed numbers because the inspectors will have a note from when he gave them, but he thought he was giving evidence on what he thought would be, if you like, the residual number of homes for a new local plan to find, if you like.
I do.
And the nub of what he was saying was that this scheme, or the scheme as a whole, both applications would exceed what he thought was the residual number.
Yes.
Just to be clear, you don't give any evidence along those lines at all.
I don't, but I think it might be helpful to explain where that came from.
Where what came from?
The overall housing target.
Well, he explained where it came from. I'm not asking about. I'm asking about your evidence. And so he explained what he thinks. You confirm that that's not what you think. Your evidence is not the same. That's Councillor Speed set out his approach. He thinks that we would exceed what a new local plan would have to find in terms of housing numbers, but that is not what you say, is it?
No, but I would like to explain where that comes from so that the inspector has some context as to...
Okay, sure. I mean, yeah, sure.
So there is two core documents, but it wouldn't take us particularly long to pull them up.
Okay, sure.
And they're not... they're factual documents that record...
You can obviously take us wherever you want. Just to be clear, what is it that you're using? What are you trying to use these documents to demonstrate?
To explain two things. Firstly, so, no, fair enough. I need to explain
I just don't,
what they
we
show.
agree, and I'm not... Well, okay, yeah, go on. So
the first is, in terms of housing options growth, there was a historic one from some time ago, and there was an option C. Then more recently, there was a ranking of 1 to 6, and the members chose a particular option. And then I was going to just explain where that had got to and where that has not been progressed. Now,
can't we just agree that there is no fixed housing option at the moment in Swale?
No, there's not. And ma'am, if you don't want to understand, or I can signpost you to that if that would be more helpful, and you can look it up at another date.
We can go if we want, but if we just agree, I mean, if we do agree that we don't know at the moment what housing options Swale may or may not end up pursuing in its new local plan, I mean, that's factually correct.
Yes, that's
so,
correct.
Isn't that sort of just all we need to know? We don't know how many homes Swale will be planning for in the future.
You want to explain how Councillor Speed got to that conclusion? Is that what
that was?
Oh, fair enough. Okay.
Yeah.
I don't want to stop you. Yeah, take it away.
I'll leave the bit about the housing growth options. There has been progression in housing growth options over the ABCDE versions that you would have seen, ma'am, but then that has been paused.
Right.
If that's of interest, I can give you the CD reference for that. But coming to the portion that Councillor Speed was referring to, and this is probably the easiest place to go is CD 14.27.
Okay.
14.27. which is it's a report to the Policy and Resources Committee. The reason that's helpful is there's a table in there that...
This is from September, is it, of 24? Is that correct?
Yes, that's correct. I'm just waiting for it to open.
September 2024.
Yes, that's right, 11th of September. Ironically, I've opened this document many times and it's never taken... So this is a committee document which covers lots of different things. So just to focus on what we're talking about, although it's 200 odd pages, we're only interested in one table. If you go to PDF page 211.
211. Okay. Oh no.
Just bear with me.
211. That's agenda item 12. I think.
Recommendations, is that what you're after?
I think.
And I'll go to the table in question.
What?
So
I haven't got a table on.
I think you mean.
yeah. So
you mean 217? Is it for the table? Is it or?
It's just so this policy committee follows on from recommendations from another policy committee. So to understand what the most recent committee are considering, you need to go to the previous one, which is PDF 220.
Hold on then.
Oh, okay. I see. This
Table 4.
Right.
Oops. Hang on.
Right. Yeah.
Okay.
So starting with A, so this is, you recall, where they work out the annual target, that 1,048.
I don't want to cut you off, but obviously the table's sort of self-explanatory. What do you seek to draw out of any of this? So
at the bottom it says dwellings requiring new land allocation, 6,287.
Yeah.
And can I just draw your attention to extant planning consents?
Yeah, and that's what he was talking about.
And while he's talking about the gap, which is a 6,287.
Yeah.
There are 3 live applications that the council's got. They're quite significant in size. There's the Duchy, around about 2,500 units, or up to 2,500.
Yeah.
There's another land west of Bobbing, again up to 2,500.
Yeah.
And there is another one which I know as Winterbourne Fields, and that's 1,800. They're live planning applications at the moment. They've not been determined. I'm not the case officer. I don't know what the ins and outs are, what the various critical matters are that need to be resolved or have been resolved in relation to those. But it is Councillor Speed is correct in saying that there are live applications that would deliver, if they are approved and then developed, and we're not at that stage where they've been approved yet, that there is potentially, over the fullness of time, schemes that are in the system at the moment that could potentially in the future be either deliverable or developable and contribute to the extant consents at some point in the future. Now, I guess, ma'am, it's
like that. No one would disagree with it. That's just saying there are schemes that might come forward later. I mean, that's...
So you're saying that there's 3 applications which are 6,800.
But they're not consented. I'm not in a position to say whether they would or would not be.
Right. Okay.
But they do exist. I can't say that they don't exist.
You can't say they don't exist. No. All right then.
We don't know what's going to.
We don't know what's going to
Are
happen.
they allocations or are they?
No. No, they're not allocations.
Oh, okay.
So these other ones coming forward aren't allocations. But it's all very interesting. But none of this actually helped. This is not part of your case. You're trying to help by explaining why Councillor Speed may have gone down the path that he did, but you don't support that line of reasoning because it's not part of your case.
No, it's not part of my case. I'm just explaining where Councillor Speed had derived his information from. He sits on these committees, and I do understand it's just what weight you would give to live applications.
It's not just that, is it? Though it's what, like I said to him, this table is wrong because it assumes that 7,047 extant planning consents are going to be delivered or developable, deliverable within the planned period. which is a proposition for which there's no evidence?
There are tables which set out, and so this is the extant planning consents that are deliverable within 5 years are the ones that have been counted towards the 5-year supply.
I know that. That wasn't my question. Just have another go. I want you to answer, and I want to move on from this, because you don't rely on this table in the same way Councillor Speed does. You're right not to, because you know that the table works on a presumption. It works on a presumption that all of these extant planning consents can be reduced, can be subtracted from a local plan housing need target, and that assumes, doesn't it, that they'll be delivered within the plan period. That's the assumption being made.
Deliverable within the first 5 years and developable
it's not about
beyond.
5 years. This table assumes, in order to adduce an overall plan target for allocation, it assumes that 7,047 extant consents will be delivered by 2040. That's the logic of the table. I'm not saying we agree with it. I'm just saying that's what it says. That's the reason.
That's the gist of it. And there is a difference between developable and deliverable.
I know, but put that aside for a minute. I'm not asking about 5-year housing land supply. I'm saying that that's the gist of it, as you say. That's the logic of the table.
That's the logic of the table.
But in fact, there's no evidence at all to support the proposition that 7,047 consents that are extant will indeed be delivered by 2040. Is there?
Well, this figure of 7,000, and so yes, I think that there is.
You think there is evidence that the 7,047 will be delivered by 2040?
So that the tests that are required in order to be able to count extant consents towards the 7,047, and this goes to developable, that has been considered by our policy team, which is why the 7,047 has been mentioned.
No. Try and engage with the question. There is no evidence, is there, that all of the extant planning consents listed on Table 4, or indeed whatever proportion of them, will indeed be delivered by 2040. There's no evidence as to what proportion of them will be delivered.
No, there's not a guarantee that all 7,047 would be delivered.
Forget about guarantees of all, because that would be totally unreasonable to expect that. There's no evidence as to what proportion of the 7,047 will in fact be delivered by 2040.
I think the policy team have looked at that.
Have they? Right.
Yeah, there are tables.
Take us to where that analysis is set out. Where is it? Where? Who? Oh, right. Do you have any idea, or are you just making this up?
No, I'm not making it up, but
it's
not in this document.
Where is it then?
Well, Mr. Simons, I wasn't anticipating you asking me that, so I haven't prepared it.
Why not? Because I asked it to Councillor Speed, and I said I was going to ask it to you. You took us to this table. This is a copy and paste of a question that I asked Councillor Speed. You are suggesting that this table means something. In fact, it means nothing at all, because it's based on an assumption for which there is no evidence, and the assumption is that the 7,047 are actually going to happen by 2040. I've asked you where's the evidence, and you have no idea.
I have seen the evidence in terms of what gets counted within the first 5 years and what gets counted towards the rest of the plan period. I don't have that to hand. I'd be glad to get that reference and to explain it to the inquiry.
It also assumes that all of the remaining 2017 local plan allocations are going to be built out by 2040, which is again something for which there's no evidence. And everything else. There's just no evidence at all. It's just a sort of theoretical exercise for which there's no evidence. And it assumes windfall allowances that haven't been tested by anybody, let alone consulted or tested by a plan inspector. It's a total finger in the air. We don't even know what the plan period's going to be, do we?
Well, this assumes 15 years
this is
through
2
to
years
2040.
old, whatever it is. Sorry, yeah, is it 2 years? It might not be 2 years. A year old? Is it a year and a half old? We don't know what the plan. We've talked about the slipping LDS. I mean, the LDS has changed since this table. We don't know that an inspector examining this plan is going to be happy with a 13-year plan period or whatever it is by the time he or she comes to examine it. One might rather hope that they'd ask for given that it's been so long since a local plan was adopted, a more strategic horizon for a plan than 2040. But anyway, the point is, we're not here to examine a new plan because it doesn't exist. You don't know when the plan period's going to run to. We don't know, do we?
No.
We don't know what proportion of existing consents the council will succeed, if any, in setting off against its local housing need. Do we?
No.
We don't know what approach will be taken to windfall by the plan inspector or by consultees.
No.
We don't know we don't therefore know how many dwellings the new plan will seek to make allocations for.
No.
So Councillor Speed's assertion that there'll only be a need to allocate, I think he said around 8,000 homes, but maybe it was fewer if I'm looking at this table. It's not a proposition that you, in fact, support with reference to any actual evidence.
No, what I would say
Thank you.
is that, ma'am, clearly we have live applications, what weight you put on them, but the council does have options.
How much weight do you put on them? How much weight do you put on them? Are you suggesting that the weight to be attributed to
live applications?
No, to our benefits should somehow be reduced because there are other applications that could, in theory, deliver housing in Swale in the future?
All I am saying
Are you saying that? Answer the question. Come on. Are you saying that the inspector needs to say, right, I would have given the housing, or whatever, X weight, but in fact, I'm going to reduce the weight because I've been told that there are some live applications in Swale. Now, I don't know whether they're going to be granted or not, but they might be. And if they were, I need to be careful. So I'm going to reduce the weight. Are you suggesting a reduction in weight to the benefits of the scheme?
No.
Thank you.
I'm simply saying that there is more than one option. It's not as if Highsted is the only option in terms of resolving 5-year housing supply and housing need.
Not just about housing supply, though, is it? You are not aware, are you, as we've been over, that there are any other options, in live applications, in local plan solutions, you name it, for meeting LHN in a way that resolves the highways constraints that were identified in the previous local plan? We've got one here, we agree on that, but we don't know if there are any others.
I don't. Now, just before the break, you asked me to communicate with our policy team, and part of those questions revolved around highways analysis, and I'm asking them to answer that question. So I don't know the question about whether the emerging local plan and options and so forth, what highways testing has been undertaken. That's because I genuinely don't know.
No, I know.
And it's just before I say that none has been undertaken, I do need to ask them because perhaps some has been undertaken. I'm not asking you to go back
over that, and that wasn't my question, and that's fine. I know we're waiting for a note on that. That's it on Councillor Speed. Thank you very much.
Ma'am, just in terms of the note that the policy team might produce, what sort of time frame would you want that in?
Jim, what you're saying is they're not going to turn up in person.
I haven't had any sort of confirmation from them, but if it was a note, rather than an in-person presence.
Any way of doing
it? Have it fairly quickly because
ideally before Mr. Bashforth is off the stand would be great. So this week.
In
the next
like
sort of
Thursday.
I think
Thursday.
in the next 24 hours. Really.
24 hours.
I mean, hopefully, as I say, it's all just factual. Okay. That's it on that, on the emerging plan. Next topic. I've called it benefits. I'm not going to go through them all, but I just want to, and I'm not going to ask you detailed questions about weighting and stuff, because obviously the inspector just will come up with their own weighting, and it's a game of diminishing returns and cross-examination to try and bang through it all. But I do just want to test your approach on a couple of the key ones, really to let the inspector calibrate her own judgments against yours, so she's clear on where you are and why on a couple of the biggies.
Yep. No, I'm just shutting down.
Shut it all down. Shut it all down. Well, don't get too excited. There's still quite a lot left, but after benefits, the final thing was balancing exercises, which takes in things like AOMB policy and that kind of thing. But we're getting there.
So yes, Mr. Simons.
Right then. So let's start then on the benefits. I'm going to ask you about market housing, affordable housing, and a few others, including employment. But so the first one I want to ask you about is the approach you've taken to market housing, specifically market housing, rather than affordable. So just to be clear, market housing. Let's just talk cumulatively to try and make it more straightforward. You've done it differently for just the north, obviously, but market housing cumulatively across the piece, you ask the Secretary of State to give significant weight to that.
Yes.
Which is to say, not top of your scale, but the next one down.
Yes.
Okay, and it's that. So there's not loads between us. We're at top of the scale for market housing, but you're not, and so it's that minor difference, you might say, but anyway, a difference that I just want to interrogate with you. Really, the fundamental question is, well, if this isn't top, what would be? But I'm not going to ask you that question yet.
Okay.
Can you take out my opening statement, which is core document 99.1.1, just as a placeholder for some other document references. So, core document 99.1.1.
Okay.
Okay. You let me know.
Just one tick. It's just
No.
Obviously have some imagery in it that's large.
It does.
It's open.
Some pretty pictures. Thank you. Oh no, sorry. It seems like a lifetime ago reading this out. It was, yeah. On page 2, the heading is the Secretary of State's called in these applications because we're in the most profound housing crisis in living memory. The reason for taking us to this is just because it quotes from and then footnotes a load of things all in one place that then are in other core documents that sit behind this opening. So
Okay.
we don't have to open them all up. I'll just read out bits from this. The Secretary of State, as I say, at 4 recognises an epochal challenge. At 5, you're familiar with the Secretary of State's describing, it's previous Secretary of State now, describing this as the most acute housing crisis in living memory.
Yes.
And you're familiar with enjoinder for those who work in the planning system who have not just a professional responsibility but a moral obligation to see more homes built.
I see that.
We know about in paragraph 6. Just again, this is just a placeholder for these documents. The plan for change and the government's committing itself to 1.5 million homes over the course of a parliament.
Yes.
We know at paragraph 7 about the Prime Minister's plan, which talks about the sheer scale of the housing crisis demanding a radical response, one in which we must do things differently. It will be, he said, by he I mean the Prime Minister, obviously. An almighty challenge, but one which we must meet by turbocharging house building and by saying to lots of people, you no longer have the upper hand. Britain says yes. You see?
I see.
And then the Housing Minister, who still is the Housing Minister, Matthew Pennycook, has called this an acute and entrenched housing crisis, and further down paragraph 8, committed to a radical approach reflecting the government's commitment not to duck hard choices, etc. The alternative is a future in which homes are, etc. I won't read it all out. Obviously, this was when we opened the case. There have been since then, including from our new Secretary of State in this area, many times this government and the top ministers within it have recommitted themselves to a radical response to deal with what they consider to be the most acute housing crisis in living memory. I mean, it's so obvious, maybe it goes without saying, but on that we agree.
Yes.
The importance of housing delivery to this government's priorities, expressed obviously through the MPPF of December of 2024 and the associated PPGs that we've come along. The importance of housing delivery to this government's priorities cannot be overstated. It is one of their...
Where are you now?
I'm just asking you a question.
Oh, okay.
You can put that away. The importance of housing delivery to this government's priorities, I mean, it's obvious, but it can't be overstated, is a top-tier objective for the Prime Minister and the relevant ministers.
Yes.
Okay. So when we're going to come to it, how all of this parlays into weight, because that's ultimately for the planning balance where it all boils down to. Weight, as we talked about when I started asking you questions right at the beginning, is not just about how important something is. It's about the scale of the benefit, the nature of the benefit, whatever. But here, when it comes to the nature of the thing that we're talking about, the nature, which is to say market housing, market housing in particular, it couldn't be more important. It's from the government's point of view, obviously set the parameters through their planning policy. This is an absolutely top tier matter of importance, is it not?
Yes. Could I qualify that?
Of course.
So, having agreed that there's a housing crisis, for the avoidance of doubt, it's not as if I approach a planning application with that in mind and disregard planning policies because housing is involved. And the matter of the housing crisis is actually complex. Like everything with the application, it's complicated. So you have within Swale and across the country houses which are vacant. In fact, there are organisations which are set up to try and bring vacant housing back into use because it's essentially adding to the supply of housing. So if you take, for example, the consenting regime, planning consents, there are consents in Swale and across the country for housing which haven't been implemented. Yeah. And part of the issue, I think, with market housing is that there's not really a financial incentive for private property developers to deliver housing in such a significant quantum that it floods the market to the degree that it reduces prices. And hence, I think that answers part of the reason why not all consents get built out.
Very interesting. And that's another good reason, isn't it, not to assume that a particular proportion of that 7,000 extant consents are going to come forward.
That's fair.
Yeah, okay. But I'm not, with respect, asking you about your thesis of the UK housing market. I'm asking you about your take on planning policy.
Okay.
The references to the acute crisis that we're in from our Secretaries of State, from the Prime Minister and all of that, feed into, don't they, policy and guidance, aka the December 2024 NPPF and associated guidance. And it's that we've obviously got to apply, obviously, don't we?
Yes.
Alongside the local plan, etc. What the government wants to achieve is many, many, many more planning permissions for housing development.
Yes.
So that's that. And on their list of priorities, I'm not saying that things like nature conservation, obviously, isn't up there too, or loads of other things, that they've got many priorities, but housing delivery and achieving planning permissions for many, many more houses is right at the top of this government's list of priorities expressed through policy. There's just no other way of interpreting any of it. That we agree.
So having said that it's right at the top, if it were housing at any cost, there wouldn't be footnote 7 within the NPPF.
Did I say it was? If our case was that it was housing at any cost, Mr. Bashforth's planning proof would be about 3 sentences long.
No, but you did say that it's at the top, and what I would say that above that are things like footnote 7.
That's interesting. So your interpretation of footnote 7 is that
housing doesn't override footnote 7.
Doesn't override. No, but the benefits of providing housing are relevant to striking the various balances that go into the footnote 7 policies.
Yes, I'm just saying that it is not. It's not the sole or the highest threshold that housing is of greater importance than anything else. Otherwise, there wouldn't be footnote 7 to the NPPF.
There you go. Let's just take a step back. I'm not quite yet asking about footnote 7. I don't think I am. Maybe I am.
No,
I think we agree, don't we, that housing as a freestanding consideration, as a benefit to be secured through the planning system, is one of this government's major priorities expressed through the NPPF. Yes. I think that's all I want to ask you about at the moment. We will get to planning balances and the way footnote 7 actually works. But as I've said, it's fair to say that all of the footnote 7 policies that you rely on themselves depend on weighing housing properly. So, giving appropriate weight to housing tells you whether or not you're impacts on the heritage, on the conservation area are justified, and on and on. That was one example. Same for the AONB, same for the ancient woodland. So we've got to get the weighting attributed to the scheme's market housing delivery right. That's the point. Right?
Yes.
So let's just look into a little bit of the context, and I'll use as a summary Claire Dickinson's proof of evidence, where this is all drawn together. If you could turn that up, it's 37.10.2. Do
you want me to leave the opening statement open, only because it's quite large?
You can get rid of it, and you can do whatever you like with it.
I'm there.
Okay, thank you. Page 7 is her scope of evidence.
I see that.
And 2.5, she sets out what her scope is, which is whether the proposed development, which comprises up to 8,400 homes, is consistent with the government's policies. Do you see where I'm reading from?
Yes, I do.
2.5.
Yeah.
Is consistent with the government's policies for delivering a sufficient supply of homes in the NPPF. See?
Yes.
And the reason she explains it actually in the next sentence, but I was going to say the reason that she's expressed herself like that is because she's responding to that particular question that's asked by the Secretary of State in the call-in letter. See?
Yes, I do.
You see, she sets it out in italics. One of the questions, in fact, the first question, is whether the proposals would be consistent with the objective of significantly boosting the supply of homes to meet market and affordable housing need. That was the Secretary of State's question. Do you see?
I can see that.
You knew that, didn't you, or not?
So are you saying that the Secretary of State's question was in your opening statement?
No, sorry, forget about the opening. I'm reading from Miss Dickinson's...
Yeah, no, that's fine. Yes.
So just to be clear, the one of the Secretary of State's questions specifically was about, was the thing that's in italics that...
Yeah, no, that's okay. I was harking back to your statement of case.
Sorry about the confusion.
I agree, this was in the call-in letter.
Exactly right. That's what I was saying. Exactly right. Exactly right. And just, we'll go into it, but we agree, don't we, that the answer to that Secretary of State's question is yes. So notwithstanding all of your...
Yes.
So
yes.
we agree, just to sort of nail this, that it's an agreed position between the applicant and the local planning authority that these proposals would indeed be consistent with the objective of significantly boosting, etc., etc.
Yes.
Okay, that's a start. So on that, there's common ground. In her section 6, Ms. Dickinson drills down into the state. I was going to say the state of the nation. It is the state of the nation, but also of the region. And these are all, some of these are familiar numbers. It doesn't make them less
housing
important.
Targets and delivery.
That exactly.
Yeah.
Exactly. So she explains, doesn't she, the macro context, some of the stuff that I've touched on in the opening. At 6.3, she talks about a significant boost. The country's been tasked with a 1.5 million target. At 6.4, she talks about previous delivery, and she illustrates the extent of shortfall in delivery. Do you see all of that stuff?
I do. Just two observations, an observation in relation to the 1.5 million homes over the current parliamentary term. It's debatable as to whether the Highsted applications, given everything between highway consents and so forth, whether they would deliver towards the current parliamentary term, acknowledging that if they don't, they would certainly deliver in later years.
Okay. So is the time scale for delivery, in your view, a reason to reduce the weight attributable to the benefits of market housing?
No, but I would say that if you're measuring it against whether it contributes to the current housing in the 1.5 million in the current parliamentary term,
You're dubious. I wasn't asking you to measure that. What I'm trying to get to is the reasons that you have for not giving higher weight to the delivery of market homes. But that's what we're going through. So that's the national context. She then has a section on the Thames Gateway context that starts on page 37, talks about the vision of the Thames Gateway, sets out a load of different numbers from different parts of the Thames Gateway. Which I won't ask you comment on, because I don't think you do. You don't either rebut or indeed say anything about any of these Thames Gateway numbers. It's all just uncontested.
No, I'm not debating the numbers. The only observation I'd make is the age of them.
The age of them?
Well, they're not
too
particularly
old?
up to date.
They're not particularly up to date?
I'm not criticising them. I'm just saying that, between 2012, 2013 and 14, 15, that's 10 years ago.
I see. Okay. Right.
But, I mean, if it was updated, it potentially shows, well, I don't know what it would show.
We don't know what it would show. All right, then. Anyway, fine. All right, then. So, but she says in the end at 6.16, before she moves on to Swale, that there's a crisis, it's accurate, a national priority to enable step change in delivery of housing, etc., etc. All of that stuff you agree with. You agree with her conclusions?
Yeah, just let me read it.
Oh, sorry, of course.
Yeah, that's all right. It won't be a minute.
No, don't rush. I want you to read it before you give answers.
Sorry, I've read through that. What was your query? Or what was your question?
It's all agreed.
I agree with that.
Thank you. So that's the Thames Gateway stuff. Swale she turns to next on page 40.
Sorry, if I just take a step back, just reading the last line, that Sittingbourne, and in particular the site, is the optimum area for strategic growth in the Kent Thames Gateway.
Which bit don't you like of that?
Well, the Thames Gateway is actually a very big area, and what you're saying is that the application sites are the optimum area. I mean, it's a big gateway area. There could be other areas which are even more
you're saying
optimum.
It's not... Your take is that it's not necessarily the best area in the Kent Thames Gateway for growth, for strategic growth.
Not that I've made any sort of a measurement as to what areas might be, but it's a jolly big area. So I think it's quite bold to say that these application sites are the optimum area.
Okay. So they might be in the strategic growth area, but they might not be, in your opinion. I mean, you haven't assessed, as you say, but you don't know whether they're the best in the business.
It's a very broad area.
Okay. Thank you. Righto. Swale, then. Ms Dickinson sets out the various numbers. We know about them already, the local housing need numbers. She explains how big an uplift the local housing need represents over the OAN that form the basis of the local plan.
I see that.
She sets out the 5-year housing land supply situation at 3.98 years as of December 2024, according to the council's calculations, obviously.
Yes.
Righto. She sets out under the heading housing delivery underneath so there's the 5-year housing land supply table that she extracts, and then there's a heading housing delivery underneath the table. And she demonstrates that measured against the local plan target, this is if you sort of read through it, and it's 6.21.2, the council is, in fact, no, it's measured against LHN, excuse me. The council has delivered 64% of the 1,048 need target.
Sorry, Mr. Simons, remind me the paragraph number,
sorry.
please.
So you see 6.21, I'll just take it a bit slower.
Yeah, I've got 6.21.
Council's position on delivery since 2017 was set out in a cabinet paper that we've got in the document.
Yep.
And it was noted that, and then firstly it was reported that 6,082 homes have been delivered.
Yes.
Increased to 6,700 to take account of some homes that came ahead.
Okay, I see where you are, yes.
And that's 670 homes a year, basically.
Yes.
Okay, so that's that. And she says at 6.22, there's no plan in place for how Swale will be able to increase and sustain housing delivery, not only to achieve this step change, but I think what she's talking about there is a step change up from where it's at the moment to where it needs to get to deliver LHN. That's the 64%. Do you see?
I do see that.
Yeah. But also ensure that affordable and homes need wider needs met as part of this. The council's self-declared housing emergency confirms this. I mean, all of that is all correct at 6.22 and at 6.21. It's all correct.
No, but only...
No what? No as in you agree it's correct?
There are some things which are incorrect there.
Take me through them.
The council's declared a housing emergency. We've declared an affordable housing emergency as opposed to a housing emergency.
Is there anything, we'll look at the housing emergency in a
Yep.
minute. Is there anything else that's incorrect?
No, just that.
Okay. So other than that, she's got it right.
Yes.
Good. Let me just see if I can find the reference. Mrs. Dickinson talks about the emergency in more detail at 2.9. Paragraph 2.9 on page 8.
Yes.
And she gives a core. Do you see at 2.9? She says the national housing crisis, clearly and consistently articulated by central government, is one which is directly affecting Swale. In April 24, Swale declared itself to be in an affordable housing emergency. She gives the reference in the core documents, stating it was looking to central government to urgently seek proper solutions to the crisis and recognition of the impact of shortage of housing and its wide reach, which affects affordability, growth and living standards. Footnote 1, the motion entitled Housing Emergency Motion was considered at the Council in 24, supported by a, quote, Housing Emergency Motion paper, all of which, and a supplementary paper, all of which are in the core documents. Right?
Yes.
So there is an emergency here that relates to growth, living standards and affordability. We can obviously look at them in more detail. I'm not going there just for time, but I do obviously urge, it's important. It's not a very long document. But in any event, there is an emergency which Swale itself has declared it to be in.
Yes.
Swale says we are in an emergency. And Swale is looking, or has been looking to central government urgently for a way out of the crisis that it's in.
Yes.
And so far things are getting worse since they're not better.
Well, we're certain. So yes. However, that's not to say that the council's not trying to do something about it.
I'm sure. I mean, even declaring an emergency in some ways is a step. So I'm not. This is not a criticism at the moment of the council. It's just trying to make sure our inspector and the Secretary of State know how bad things really are. So there's this obvious corporate priority of the council to make sure housing deliveries were working, and it's not at the moment either for market or affordable. There is an emergency, and at the moment the council's still presumably seeking some sort of answer from central government.
Yeah, I don't know how that has progressed.
Not too much, because looking forward, we still don't know, obviously, as you've explained, if and how the council actually intends to meet LHN into the future.
No, not yet.
What we do know is that it's not meeting LHN at the moment, looking backwards or looking forwards.
That's correct.
And meeting LHN as a minimum,
Yes, I understand that.
is an absolute central imperative of national planning policy, obviously.
I take your point.
No, hang on, it's not about taking points, it's about agreeing or disagreeing.
So I agree with that.
Thank you.
No, and obviously the 5-year supply is a minimum. The council doesn't have a 5-year supply.
Yeah.
It has a just under 4 years, so there's around about a year's worth of supply that we're short. I'm not suggesting that it's a race to the bottom. However, it is a year short. It's not worse than that. We perform well on the housing delivery test. We've got a local development scheme, and I know you've asked me questions as to whether that's realistic.
Yeah.
But the borough does have a way out of this.
What's the way?
Through the, well, I guess twofold. Councillor Speed has identified that actually there could be live applications that get determined and end up contributing towards future supply.
Like us.
And then
Live applications like this one.
potentially.
So we're one way out. What's the other way out?
With those other 3 applications that I was describing, and then progressing the emerging local plan.
Okay. So we either start granting applications like this one, or we wait for the local plan to come along. I think we probably accept that. as an analysis. I suppose the problem with waiting for the local plan to come along is we've got no idea if and when it's actually going to happen, and if it does happen, if and when schemes are going to come forward pursuant to its allocations.
No, yes, I agree with that. Which is slightly pessimistic, because you would hope that the LDS is adhered to and those timeframes are achieved. But I understand what you say.
All right. Ms Dickinson's evidence just touches on, while we're in it, if we're still in it, on page 12. The points about the inequality that exists within Swale, and how that is expressed. In particular, you'll see at 3.7, she talks about Sittingbourne's been identified as the focus for borough's growth for 3 decades. Growing Sittingbourne through coordination of investment of infrastructure, homes and jobs aligns with the government's ambitions today. A strong rationale, she says, for focusing the borough's growth on Sittingbourne, the west of the borough, is the opportunity this provides to address the inequalities and differences between the west and east of the borough, which benefit from the housing markets with higher values, i.e. Faversham. And she sets out how that looks in the next paragraph with some examples to do with the skilled, the level of skills of jobs, levels of deprivation, and indeed she talks about Faversham, distinct housing market characteristics, higher values, long established, forms the basis of the council's housing own assessments, etc. I won't go through it all, but I'm just reading it.
I see that.
See where I'm at. And none of that is disagreed with by you?
No.
Okay. And it might just be relevant, not just to this sort of evaluation of the weight to be attributed to housing, but I do just ask the inspector to bear this page in mind as being fully agreed when it comes to the correct interpretation of DM8 as well. Because here we have a very clear and agreed exposition of what the differences are between Faversham and Sittingbourne areas. Anyway, but we're not going back to DM8. Right. So, coming up with weighting, an amount of weight, an adjective to describe the weight for market housing, we've got a consideration that is of a very, very high order in terms of the importance attributed to it in policy. Market housing delivery, don't we?
Yes.
We've got a consideration not only at the national tier, but at the local tier, for which there is a profound need. That is to say, Swale, not least through its own declarations, is recognising the imperative of significantly boosting market housing delivery, isn't it? It's a massive corporate objective, long-standing objective for Swale, not least to try and address some of the massive socio-economic inequalities that Ms Dickinson explains in her evidence. So, correct?
Yes.
So, when it comes to the nature of the consideration, it's very important. I'm not saying it's a carte blanche or it's the only thing or whatever. I'm saying it's obviously a consideration of the very highest level of importance, not to exclude other things also being very important as well. I think we agree on this.
I think that it's significant. I would give affordable housing a higher level.
I'm going to come to affordable. I'm going to come to affordable. I'm just asking about market for now.
Yeah.
In terms of the nature of the consideration,
it's not the. I don't think it. If I just use the term, I don't think it's the top of the tree. I think it would be the next one down. The top of the tree for me would be something like affordable housing.
I know that's where you get to in your weightings, and that's literally what I'm trying to interrogate at the moment.
Okay.
So I can't understand why. We accept, don't we, that there's a profound need for more market homes in Swale.
Yes.
That's recognised and supported in planning policy at every level, including by central government, long-standing objectives, radical change, all the stuff I've taken you through.
Yes.
Right. And that's the nature of it, the level of importance of it. In terms of scale of the benefit, scale's also important to understand if you're going to reach a proper approach to weighting.
One of the important things.
One of the important things is nature. We've talked about that. But there's also scale. And have you ever in your career dealt with a scheme that offers more market homes than this one?
No.
So this is the biggest market housing scheme that you've ever looked at under a government that produced an MPPF to achieve a radical change in housing delivery to respond to the most acute housing crisis in living memory. Here we are with scale. It's the biggest one ever that you've seen.
Yes.
And yet, you do not, even nonetheless, you don't give top drawer weighting to market housing delivery.
No.
So let me ask you this. Would you ever, in any circumstance, come across a market housing a scheme that included market homes that you would attribute top-end weighting?
Yes.
Okay, and what would we have to do differently, in your opinion, to get up there? Why are we not at the top?
Well, it's not with it. So don't get me wrong. I'm not criticising what's being proposed in terms of market housing. I think if you were looking for a comparator that did achieve, let's say, in my weighting, very significant weight for the market housing, would be, for example, if let's say you take the 5-year housing supply, rather than it being 4 years, imagine a situation where we had 1 year supply of housing, in which case I'd say actually the market housing component here is very significant in view of. So
can we test that just before
sure.
you move on? But I thought your position was that only a small proportion, if any, of the market homes are coming forward in the 5-year period. Is that right? Is that your position?
None.
I think you said. Did you say none? I can't remember.
Well,
either
possibly
few or none, right?
Yeah,
that's your position. So on that logic, 5-year housing land supply is not an important metric in this case, because if we are delivering market housing, it's all going to come late, or vast majority of it's coming outside that period.
Yeah, so
is that correct?
So I agree that I don't think that the housing as part of the scheme is likely to be delivered within 5 years.
Therefore, it follows that the 5-year housing land supply metric is obviously it's important in some ways for the mechanisms of the framework, but it's not the most important metric in this case because of the timelines associated with delivery.
I think that it is important. The fact that the housing will come online beyond year 5 doesn't distract me from being able to use that as a gauge to say just how much of a housing problem does the borough have.
Yeah.
If we had a 1-year supply, it's quite apparent whether over the next 5 years or beyond, we're going to need market housing to a greater degree.
I see. But what's a bit weird, that I'm not at the moment following your logic, because on the one hand, you're judging the weight to be attributed to this scheme's market housing. You're judging the weight to be attributed to that.
Yep.
With reference to 5-year housing land supply number.
But the government does this as well.
I've not quite finished asking.
Okay.
Just on the one hand, and on the other hand, you're accepting that we're not going to make any material contribution to 5-year housing land supply. You're using a metric to judge the weight to be given us that on your own logic's not relevant. We're not interested in the 5-year number. We're interested in delivering housing over a decade, multi-decade long period to respond to strategic challenges that this borough faces. How can you downgrade the weighting on the basis that you've got a 3.8-year housing land supply? I mean, in some ways, who cares if it's 3.8 or 2.8 or 4.9? This is a much bigger exercise than that.
It is. I still think it's relevant that actually the borough's supply of housing is not compared to some boroughs which I am aware of.
Okay.
We've got less than a 4-year supply, but just less than a 4-year supply, which to me, in comparison to say if you had a 1-year supply, it's simply not as drastically
awful.
It's not as bad.
Not as awful.
But again, don't get me wrong, Mr. Simons, I'm not suggesting it's a race to the bottom. It's not a good thing that we have less than a 5-year supply.
No.
But you did ask what would it take to...
I did.
To get it up to...
Yeah. So now even though it's the biggest scheme you've ever seen in terms of the scale of the benefit, and even though you accept the very high order of the nature of the benefit, we only get one from top rather than top because of, on your approach, the fact that the housing land supply is 3.8 and not 1, basically.
So there's a matter of judgment here.
Sure.
It's not simply that the greater the number of units, the greater the benefit.
No, I know that. That's what I obviously, that's why I've said that scale is one of the things.
Yeah.
And scale's massive. And nature and importance are other things. And we went over how important this government's planning policy, the weight to which they attach to market housing delivery, all of which we're agreeing is all very, very high. And so the big sort of mystery then is how you compute yourself in your judgment the scale, the nature and the importance of market housing delivery on this unprecedented scheme, and you end up not at top level. But you've explained your answer is 5-year housing land supply, because there's nothing else that you rely on, I don't think, that would stop us being top end weighting. If the housing land supply if it was 2, would that be all right? Would we be very significant then?
I would say so, yes.
So the fact that you were at 3.8 5-year housing land supply, for what that's worth, and not say 2, is the difference there, and that's to explain your judgment to the inspector.
Yes.
Okay, thank you. We'll leave that one.
Ma'am, what I did is to say, what would it take to get from significant to, what would a scheme look like? What would it have to do? And I don't think it's just the overall number. It's kind of also reflective of how badly the borough needs the additional housing, which is why I was using the...
Yeah. But just to be clear, you accept that all of the market housing would be meeting needs, all of it?
Yes.
You accept that there's needs that would be met by all the market housing, and almost all of those needs are being met outside the 5-year housing period?
Yes.
So almost all of the needs that are being met are outside the period that you've used to reduce the weight?
So, yes.
Correct.
And what I do find interesting, for example, the government measure the 5-year housing supply as being particularly important in terms of, if you don't have one, it has the potential to engage the tilted balance.
Yeah.
Yet that is irrespective of whether the housing that's being proposed would actually address the 5-year supply. So it's not just me that think about the 5-year supply and the value of housing supply beyond the 5 years.
Okay, that's very interesting.
Something actually on this. So if it was a smaller scheme but didn't have all the infrastructure and so forth to provide, which obviously would take time, is one of the reasons why
Yes.
it might be pushed over into a longer time period. If it was a smaller scheme that would contribute to the 5-year supply, how would that play out in your logic?
I would need to have a think about them. I'm sorry, I just hadn't run that scenario in my head.
Why don't can you run it now? Or because it's important, I want the inspector to have a good sense as to why obviously we know what you're saying, but
yeah.
I want to try and test why you're saying it.
I mean, is it because it won't contribute to the 5-year period, whatever that is, rather than the size of it, or something else?
I was asking myself, what sort of situation would it require in order to go from what I think is significant? And because you say, well, if this isn't a scheme that's very significant, what scenario would make it very significant?
Exactly.
And so my answer to that is, if the borough was in a much worse state in terms of its existing position in terms of housing supply, then I would be saying, actually, we need that housing so much more that I would increase its weight.
But you'd need it more in the short term, which...
Well, if you have 1 year supply, it won't just, you'll have a deficit not only over the 5 years, but no doubt you've got a deficit over the whole plan period.
Come on, a 1 year supply that doesn't follow. A 1 year supply is measured against a 5-year period. We all know the way that works.
You might have strategic sites that are coming along later on.
Exactly.
It's
very regularly the
depends on
case.
trajectory, doesn't it? It's quite...
You're using as far as I can understand it, the only basis upon which you're knocking down our weight to be attributed to market housing is on the basis of a 5-year housing land supply metric that basically doesn't make much difference on the facts of this case, because we will be delivering the vast majority of our market housing well outside the 5-year period. So, And if the inspector took a longer view, not your view, but a longer view, and said, right, okay, what about a need over a 10-year period, a 20-year period, a 30-year period? How's LHN going to be delivered over those sorts of periods? The answer is the council has no idea at the moment. No idea, because it's got no local plan strategy.
Is that a question?
Yeah.
So no.
Exactly. So if we expand our horizon beyond the 5 year the 5 years that you're using, and look at the sort of period over which this scheme might actually be built, there's a profound need to be met to come up with a solution to deliver LHN in a way that doesn't destroy the local housing network and lead to major deteriorations of air quality.
Would you like me to talk about air quality?
Gosh, no. Just answer. You agree, don't you, that we've been over it? The council has no solution at the moment. Hopefully it'll come up with one eventually.
Yes.
But it hasn't got one at the moment.
No.
So if we start looking outside your 5 year horizon, well, the answer starts to change. Yes, okay, it's 3.8 years over 3.8 years supply measured against 5 years. Understood. That's the figure that we haven't challenged it for the purposes of this inquiry. Fine. But if one looks over the sort of horizon that this scheme will be built over, there's a profound need, and there's absolutely no way at the moment that the council has adduced of meeting the need.
No. So at this point, I can make reference to Councillor Speed's observation that you've actually got live applications which could come forward over that longer period and help to address that longer term
Doesn't
need.
answer my question, because I was asking you about ways you could grow without destroying the housing.
I said
the
no.
highways network. Anyway.
I've already explained that, Mr. Simons. I'd said no to that question.
Thank you. Now, that was market housing, and thank you for that. Just moving on to affordable. I'm going to be briefer on affordable. For affordable housing, the reason I'll be briefer is because although you use different terminology to Mrs Dickinson and to Mr Bashforth,
yes,
whether we've been over, actually, the substantive judgment is the same. It's to say that you're both at whatever the top end of whatever the weighing scales is. You're both attributing that top end weighting.
Yes, and probably something for Mr Bashforth to explain in terms of what his range and top of the range is.
Of course. I'm not going to ask you about his range.
Affordable housing is at the top of my weighting.
Yes, exactly. That's why I'm not going to ask as much about it, because we fundamentally agree on it. And it might just be worth the inspector noting that we've been arguing back and forth about DM8 and whether or not there's conflict with DM8. DM8 is about affordable housing delivery, isn't it? Obviously.
Yes.
And in fact, we all agree, whatever the answer is on DM8, whatever the answer is, we agree that what DM8's securing in this case is a benefit of the highest order.
Yes. Now, in relation to the northern scheme, just as an observation, there is less of it.
I know, but because the northern scheme's a fraction of the size, but and it has different viability challenges. But looking at across the piece, we agree that regardless of this very interesting sort of linguistic debate on what a local housing market area means or whatever, that actually the thing that DM8's about, which is to say affordable housing, in this case, it's a top level weighting benefit to be weighed in the balance by the Secretary of State.
Yes.
Okay. And I'm going to leave that there by saying, by recalling the agreement that we have, that on that first question from the Secretary of State, what's the extent to which the proposed development is consistent with policies and the NPPF for delivering supply of homes? The answer is fully consistent.
Yes.
Both applications would be fully consistent on an agreed basis with those government policies, and that is the answer to that question.
Yes.
Okay, thank you. Now, I want to ask just before lunch about one other area of government policy that the Secretary of State was keen to ask about.
Can I shut down the Miss?
You can. Thank you so much.
Dickinson's.
You can. Thank you. We are moving again on from affordable housing to highways and locational sustainability.
Just bear with me. Having shut that down, it's now Sorry, carry on.
No, MPPF, if you can.
Yep.
Section 9, page 31.
Yes.
Promoting sustainable transport. You see?
I do see.
Just, I mean, obviously, these are very well trodden paragraphs. But if we just take a couple of key headlines, just to sort of get us into the swing. Paragraph 110. In the second sentence, we're told that significant development should be focused on locations which are or can be made sustainable through limiting the need to travel and offering a genuine choice of transport modes, etc., etc., etc. You see?
Yes, I do.
And we're fully in accordance with that sentence and indeed everything in this paragraph.
Yes, subject to those things being secured through Section 106.
Assume a 106 for now,
yep.
And assume conditions as well. Subject to 106 and conditions, we meet the objectives of Section 9 of the MPPF. We're a sustainable location. We will act. I'm not going to read it all out, but all the things that we all know about that are in here.
That's fair. Yes.
And so when this is really just to nail down another one of the questions that the Secretary of State asks, because I think it's the third question, was to what extent is the proposed development consistent with the policies for promoting sustainable transport in the MPPF, which is i.e. Chapter 9? And the answer is, on an agreed basis, both applications would be, agreed with you, Swale,
yes,
the applicant, Kent, National Highways, so agreed between those parties. The answer is fully consistent. There would be full consistency on an agreed basis between the schemes, plural, or the applications, plural, and Section 9 of the framework.
Just before I answer that, I'm going to just quickly read through and make sure there's nothing that...
Sure, of course. You're going to read the whole section?
well, it's not very long, so...
No, sure. Well, there's three pages, but okay.
So, yes.
Okay, thank you. Righto. Okay. And that leads to, I mean, that furthers the government's objectives on the promotion of sustainable transport, all of that, maximising solutions and reducing congestion and emissions, improving air quality and public health. That's what I'm just reading from 110. That's what we're doing here. If we grant these applications, that's what happens. Oh, did you? Oh, sorry.
Yes.
With conditions in Section 106?
Yeah, the answer is yes. Okay. So that leads to benefits associated with the scheme.
Just, ma'am, one comment just in terms of improving air quality.
Yeah.
I mean, there would be benefits and disbenefits in terms of improving air quality. I wouldn't overstate the air quality benefits, but yes, I agree with paragraph 110 that the application would address that.
In what way? So you can just explain why you wouldn't overstate the air quality benefits?
Yeah, and when you do, could you remind me if you've actually produced any evidence on air quality to support diminishing the weight to be attributed to the benefits?
Well, it was the subject of a round table session.
Yeah.
And the air quality officer from Swale, or the environmental protection team, did arrive, and she did provide a comment during the round table session. So there's not formal written evidence on it.
Okay. Was the officer supportive or objecting?
No, she's not objecting,
Right.
subject to planning obligations. And there's just the environmental statements for both applications deal with NOx, PM10 and PM2.5. And if you look at the 78 receptors, I think 9 of them show a benefit, being from sort of like a slight benefit. The remainder show a negligible benefit. So no harm, but no real, negligible benefit. So it's just to say there's not an objection in terms of air quality, but nor are we saying that there's going to be game-changing improvements. So there's not an objection. It's just to recognise that, benefits for the large part are negligible.
We know, don't we, that, and we've seen countless references to the relief roads. One of the key functions of the relief roads will be to alleviate air quality problems around the centre of Sittingbourne. I mean, you've seen that, I think, or maybe not. Do you remember?
Well, this has been discussed in the air quality evidence and in the roundtable session, and the benefits aren't as significant.
All righty. So overall, though, taking a step back from whether the air quality benefits
Yep.
are big or small, and you accept their benefits, you just don't, well, I don't know, you've got quibbles
Well,
about how
they're certainly not disbenefits. It's just whether they're more than negligible.
Right, okay. Ooh. Overall, the accordance with every bit of Chapter 9 of the framework gives rise to benefits, doesn't it?
Yes.
And where are those benefits analysed in your proof of evidence?
Well, they're reflected. I've given the highway infrastructure. So you're talking about in terms of air quality benefits or highway benefits?
No, you heard what I said. I think I didn't just say air quality. There's all sorts of stuff here that flows from our locational sustainability, the reduction in emissions, reduction of congestion. Yes, air quality, sure. Public health associated. I'm just reading from 110. Public health associated with all of this, and all the other things that appear. My question is where do you analyse the? Firstly, I suppose you've told me that both schemes accord with Chapter 9 of the framework in full, right? You've just said that.
Yes.
That's not in your proof of evidence, is it? There's no analysis of Chapter 9 of the framework at all.
No, there's not an explicit. For example, you can have compliance tables where you'd have the MPPF and then describe. So I haven't done that. What I have done is to look at policies that are relevant to the application and compared them for consistency with the MPPF.
Yeah, I'm not asking about policies. I'm asking about compliance. Compliance with Chapter 9 of the framework. You've not assessed it explicitly in your proof, but even worse than that, you've actually not gone through the various benefits that are relevant to accordance with Chapter 9 and given them weight. Other than you've given weight to highways infrastructure. I'm going to come back to why you've given us moderate or whatever weight for highways infrastructure, because that's another change from your from your. I think was that in your errata sheet? I will come back to it. But yeah, there's no assessment, is there, of the various benefits that flow from meeting all of Section 9 of the framework in your proof of evidence?
There's not an explicit assessment, no.
Hopefully it'll be implied. I mean, you didn't talk about it in chief, so if it's not in your chief and it's not in your proof and it's not in your statement of case and it's not in your officer's report, it's not there. It doesn't exist.
Well,
we're not mind readers, Mr. Digan.
No, that's understood.
Good.
You will notice that within my proof, when it comes to the transport sections, that with Kent County Council and National Highways having removed their objection, and things such as sustainable transport now having been secured or will be secured through conditions and planning obligations, there isn't an objection from the council in relation to those matters.
Understood. But I'm not asking about your removal of your objection. It's one thing to remove an objection, it's another thing to deal with benefits properly. And that's what I'm asking you about now. But I'll come back to why you attribute, I think it's moderate weight, to the game-changing highways infrastructure that the council's evidence base has been supportive of for decades. Now, next, I'll leave Chapter 9 of the framework. I'm aware of that. I'll try and stop at about 1-ish if that is suitable. So just very briefly on the benefits. Open space. Oh, good question. I actually wasn't. If we could take up, there's a table that summarises all these things. It's at page 144 of Mr. Digan's. I think it's the proof. Yeah, Mr. Digan's proof has a table that summarises these different things.
Which page? Or rather, is there a paragraph number?
It's paragraph 18.8d is your summary table. And I think if the inspector's got that open, I think the one change that I've made that I think is reflected in the errata is the moderate for highways infrastructure is now a significant. So I think that's right, Mr. Digan, isn't it? It's gone up one, yeah. So
are you talking about the northern or southern scheme?
This is the cumulative one. It's cumulative one. 18.8d, page 144, Your errata corrects the moderate for the bottom one's highways infrastructure, and your errata, as I understand it, corrects the moderate to a significant.
Yes, that's correct.
So it's worth just making that change in manuscript if you've got it in hard copy. That's Mr. Dygan's position.
This is the southern scheme or the combined scheme.
Well, that's not,
the combined
it's not
scheme.
the southern, is it? It's the combined. And the northern scheme is a few pages before at
18.33, I think.
correct, exactly.
So which one are you looking at?
The combined.
Combined.
Yep. Okay. So have you got that one, Mr. Dygan?
Yes.
Okay. So for the combined scheme, you attribute moderate weight to open space and sports facilities.
Yes.
Right. I suppose we know, don't we, that, I mean, we can have a look back at Mrs. Brockhurst's table that explained what the different hectares were for different areas and all of that. But we agree, don't we, that in terms of the provision of open space, what's on offer is very, very significantly in excess of any policy requirement in Swale.
Yes, so yes, that's correct.
There's massive over provision, and it meets a strategic level deficiency in open space that's been recognised by the council for years.
But just to clarify,
is that correct? The thing I just said before you go off.
No, it's not entirely. So there are within the policy relating to how much open space you should provide, there are different topologies of space.
Yeah.
And in some cases, there is a generous over provision, and then in other cases, it either meets or just about meets the minimum requirement.
Yeah.
However, if you factor in what's being provided on site and off-site contributions towards things like swimming pools, as well as recognising that in some topologies there's an over provision, there's no objection which is being raised.
I'm not asking about no objection. I know there's no objection on open space. Obviously there's no objection. We provide 350 hectares of open space. It'd be the biggest provision of open space that Swales had for, well, on record. I mean, for many, many years. It's massively over-providing compared to what the policy expects, isn't it, overall?
Overall, in some topologies, there is an over-provision.
Overall, forget about the typologies. Just look at the whole picture, because that's what you're giving weight to. You're giving us moderate weight for 350 hectares of open space, of all across the schemes. What we would be achieving is far in excess of what policy requires overall.
And
Answer.
You are achieving over what the policy requires.
And so that supports bumping up weight, doesn't it? Because you're getting benefits over and above what your local plan, which itself is out of date anyway, it expects.
No, I don't think so. Would you like me to explain?
Sure.
Where are we looking?
For this, I would need 3 documents.
Oh boy.
Okay. Hold on.
If you take up 7.22, CD 7.22. Page 17. I'm going to ask that you open 2 further documents. CD 7.22, page 17. I'm just checking, ma'am, that I'm getting it right. CD 8.13, which is a structuring plan. And appreciate there might be a more up-to-date one than this, but it's going to be showing pretty much the same thing. The one in the CDs is from February, and I know there's one from September, but it won't be showing anything in relation to what we're discussing that would be different. Now that is, doesn't show the entire site. But let me explain it and see whether you want to open the Oakwood Village Development Structuring Plan. Okay. The whole thing doesn't give you the hectareage.
Okay, so just the Highsted one then.
We could open the Oakwood one as well, if that's of assistance, but let me explain it with this first, because that might.
Okay, and what was the third document that you were talking about?
9.2.33. It's an ecological mitigation strategy. 9.2.33. It's part of the ES, it's the ecological mitigation strategy for the southern site.
First one isn't opening for some reason.
Oh.
A minute. I think what I'm going to do is start again. That one. So that's 7.22. Let's just open that one. Oh, right, okay, and sorry, the third one then was 5.2.33.
9.2.
Oh, right.
It's all the nines of the environmental statement for the southern site.
3.33, right, just hold on, please. Right, I've got all those now. Thank you.
Okay, if I could start with 7.22 at page 17. Now, ma'am, what you have is the southern site, and it has the different areas of open space in the legend to the left. And that includes how large they are in terms of hectares. Now, it's just to highlight, if you turn to the ecological strategy at PDF page 59, it's another map.
Page
59. Did that bring up a multicoloured picture of the southern site? And it has sort of purple areas between the streets and so forth. Can you see areas of purple between the streets?
Yep.
Areas of green where the country park is, for example.
Yep.
And so if I just look at the legend on the right, you can see in dark green, minimal access zone. Now, the minimal access zone is defined within the ecological mitigation strategy. It's essentially areas where they're trying to control access for ecological reasons. So not to completely prevent access, but through the use of things like, planting, prickly planting and so forth, actually encourage people to sort of stay on the path. And you'll see that is, you can see the Northern Relief Road. If you look where the Highsted Country Park would be, north of the Relief Road, there's an area of minimal access zone. Sort of to the south of, and this is around near the Rodmisham Church Street Conservation Area, Church of St Nicholas and so forth at its centre. There's a large area of purple, and that's dedicated amenity space, recreation zone. So clearly there's a large area of open space there without restricted access. That extends through the residential areas, and of course that'll be of value where you've got street trees and potentially sort of grass verges and so forth. The yellow areas of either community gardens, and they're proposing orchards, allotments and the like within a community gardens context. And then there's the sports hubs, one which is near Rodmisham Church Street, and that would have formal hockey pitches as well as some other formal sports facilities.
Yep.
Do you recall going to that central chalk pit, Ma'am?
I do.
Now, the central chalk pit is coloured grey. That's restricted public access. It's intended, it's an outdoor pursuits organisation at the moment, and that's to continue. So it's factored in here within the site, but in actual fact, it'll continue to be used by Outdoor Pursuits Group.
Yep.
You'll notice that the other two chalk pits are informal recreation zone, and the proposal for those chalk pits is to be nature parks. Looking further south, there are other areas of dark green or green, and those are the minimal access zones, and I can see Highsted Wood, for example, and the applicant's proposing, for example, to have wardening to help control and mitigate impacts for ecological purposes. Then if you look towards the M2 at the bottom of the site, and woodland areas are proposed south of the M2, and I'm pretty sure to a degree just along the northern edge of the M2. But again, those are minimal access zones, and to be fair, they are quite far away, and you probably don't want the public visiting the junction anyway for highway safety purposes, human safety purposes. Mm-hmm. So it's just to note that there are portions of the site which are meant to be, dedicated amenity, and then informal recreation and minimal access and restricted access. And then you've got the formal sports facilities as well. And so I'm just mindful that for ecological and other reasons, not all of the open space is accessible.
Well, firstly, so what? Secondly, minimal access doesn't mean inaccessible, does it? You've told us it's space that you can walk through on footpaths that will be managed. There's all sorts of open space in this scheme, all sorts of different categories.
Yes, there is.
Do you really offer up the diversity of different areas of open space as a reason to reduce the weight attributed to it?
So you're counting with...
Hang on, no, you can't. All right, well, it's lunchtime. But it would really help from now on, and including into the afternoon, if you could try and answer my questions directly. So are you offering up the diversity of different typologies of open space as a reason for reducing the weight associated with its provision?
No, what I'm saying is that some of this open space is not really usable. So you're counting as part of your open space the area where the highway junction south of the M2 would be, and I just don't see that as being a place that future residents or residents of any other area would go to enjoy.
Have you ever, in your officer's report, statement of case, proof of evidence, or I suppose orally until this answer, sought to assert that the areas of open space we're showing aren't properly to be calculated as part of the open space requirement for the scheme.
They've been calculated.
No. Answer the question, Mr. Digan.
No.
Have you ever?
No, but you were
Year
asking.
in.
Mr. Simons, I've just answered your question. You've asked the question as to why I give the open space moderate weight.
Yeah.
And I've given you my explanation as to why I feel it's moderate and not to a higher degree.
You have. And my question to you then is, you've made the point about the stuff around the junction, etc., won't be usable by people, so it gets moderate. My question to you is this a justification that has ever been written down? Or that's my question. Have you ever actually put pen to paper on explaining that? Because the reason I'm asking it, just so you don't take this the wrong way, is that the questions that it's not supposed to be a sort of big surprise for everyone when you reveal what the justification is for your evidence. It's supposed to be part of an analysis in writing in your proof. And if the inspector goes through your proof or the officer's reports or the statement of case to try and glean that justification for knocking down the weight associated to the delivery of open space, she's not going to find it anywhere.
So I think you're right. You won't find it. This is when I come to look at the weight that I'm giving to benefits or disbenefits, that is towards the end of the analysis, as it were, and
doesn't always make it into the proof.
Well, clearly I haven't explained it in a way which is sufficient for you to be able to tell
No.
how I came up with that weight, and
Overall, the relevant policy in the local plan is not only met but exceeded. And
yes.
on that we agree. Okay, thank you. That's it on open space, and obviously leave the inspector to reach your judgment. So turning topics, and obviously it's past 1 o'clock now, so this would be a good moment to.
What are we going to next? Let's have a little...
The final one on the benefits list that I want to ask about specifically is employment and employment-related economic benefits, and then after that we're moving on to the final section, which is the approach to balancing under national policy.
So, do you think you'll finish?
Yeah. Well, we definitely. Mr. Bashforth won't be on today, but I'm hoping that with, say, 2 more hours or something that we could finish.
2 more.
Did you want to carry on?
Yeah.
And
we keep. Well, I'm not asking you to keep. I mean, we can keep going a bit longer if you'd like. But would you like to keep going till 1:30 or something like that? Or?
well, it doesn't really make any difference.
No, it doesn't
We've only
make
got
any
so much time.
No. I agree. I'm happy
That's
to
fine.
What
stop.
about? I thought you might like a break.
Yeah, no, it was just
Over and-
I'm mindful that we don't run out of time.
Of course, no.
Overall.
Whether we have a break
But if it's not
now
going to make
or
any
in half
difference,
an hour,
then
It won't
doesn't
make
any
any
difference, does it? Mr. Pereira, what do you think? How long do you think you'll be? Just about an hour, did you say?
Between 30 minutes and an hour.
Okay.
God, that's a big gap, isn't it?
I can't criticise him given what's
It's not very precise.
It's a range. What
It's a
can I
range.
say?
It's a target.
And it has a cap on it.
It's got a cap.
All right, and I'm going to go through my questions.
Of course.
Obviously, quite a few have been answered. Right, so let's just have a break. Shall we have a break till 2 o'clock? Is that all right with everybody?
Great. Thank you.
Thank you. We'll adjourn till 2. Thank you. It's now 2:00, so it's time for the inquiry to resume.
Thank you.
So, employment and economic benefits, I think we're going to do.
That's
that,
right.
are we?
That's right. The last particular mini category of benefits, Mr. Dygan, was employment and economic benefits. If you could just to remind ourselves, sorry to take it slow, but just if we could just turn up Mr. Bashforth's proof of evidence, which is 37.11.2. And page 3. You tell me.
I'm there.
Thank you. Page 3 in the blue at the bottom in the blue italicised is just a record of the questions, the A to G, that were asked by the Secretary of State.
Yes.
I've asked you about A. Right?
Yes, you have.
And we've agreed that there's full accordance with that chapter. I've asked you about C. Over the page.
Yes, you have.
And we've agreed full accordance with that chapter. See?
Yes.
Now, B, that's what I'm asking you about now.
Okay.
So, excuse me, B, the second of the Secretary of State's questions, B, is all about Chapter 6 of the MPPF.
Yes,
so
it
if
is.
we just turn to Chapter 6 of the MPPF.
Just bear with me. I have that.
Now, I'll just let the inspector find it. Page 24. Now, you might remember, although it has been some time, that I'd started going through these paragraphs, sort of one sentence at a time, with Mr. Pestle, and I was asking him about where in his evidence he'd considered accordance with, or extent of, what does the Secretary of State say? Extent of consistency with these various policies that we're going to talk about now. And he said, not his job, he said that it would be Mr. Dygan who would be the appropriate recipient of questions about this chapter. So I'm asking you.
Okay.
Paragraph 85 is about planning policies and decisions should help to create conditions where businesses can invest, expand and adapt. Significant weight should be placed on the need to support economic growth and productivity, taking account of both local business needs and wider opportunities. Each area should build on its strengths, counter weaknesses, address challenges of the future, etc. And then it talks about 86, what planning policies should do, different things that planning policies should do.
Yes.
You see? Number of different things that policies should do, including at Eve being flexible, not to accommodate needs not anticipated in the plan. And then 87 talks about things that planning policies and decisions should do. Do you see?
Yes.
Should recognise and address specific locational requirements, making provision for different things. I won't read them all out, but anyway. There's this corpus of policies that set out, that crystallise, I suppose, what the government's economic strategy is, so as to be achieved through the planning system. Do you address in your proof of evidence paragraph 85 or 86 or 87?
Not explicitly. So
not explicitly. So
no.
Do you do it implicitly?
I think what
if we're going to get through this afternoon in time,
agreed.
You're the only way it's going to work. So I'm genuinely, it's not your fault. It's my fault. I'm worried about time.
Yep.
You'll please try to answer the questions as straightforwardly as you can with a yes or no, and then I won't. I'll just move on and ask different questions.
Okay.
Okay. So have another go. The Secretary of State's asked questions about the extent to which the schemes are consistent with these policies. Have you addressed any of them in your proof of evidence?
No.
No.
Not explicitly.
So have you done it implicitly?
Not fully. What I have
you done it partially but implicitly? Is that what you're saying?
If I could explain what I have done, is to look at what I think are the planning policies relevant to the decision and compared them to the NPPF to see whether they're consistent. So in that way...
Okay. Have you considered the extent to which the scheme before the Secretary of State is consistent with these policies and supported by them?
No, not explicitly, but I think...
no, not explicitly. Isn't that a bit of an omission, given that one of the is it six things that the Secretary of State's actually asked for? Mr. Pestle said he hadn't done it. He said you were the person, and you've not done it. Well, what? But what does that even mean? That's you comparing. That's you assessing the degree of consistency with certain local plan policies with the MPPF. That's not what I'm asking. I'm asking whether you've actually assessed the degree to which as the proposed development is consistent with this chapter of the MPPF or not.
So, and I've answered that question. No, I don't. So
Right.
I could, for example, have had a compliance table with the MPPF in one column and the application in the other and actually gone through and made that explicit. I have not done that. What I have done, though, is to understand how consistent the policies. Now, I've used the policies to assess the planning applications. And what I have done is to understand whether those policies, and I'll give you an example, Regen 4, which applies to the Kent Science Park,
Okay.
as to how consistent that is with the MPPF,
Okay.
and then made an assessment of the application against that policy. But
you find conflict with that policy, and you give presumably weight against the scheme as a consequence of that.
yes,
But that's not. So that again shows why we've got this sort of analytical problem with your approach. Because I'm not asking you about all your conflicts that you assert.
okay.
I'm asking you about the extent to which economic and employment benefits that you recognise exist associated with the scheme should be given positive weight. You've given them moderate weight, I think. Have I just got that right? Hang on.
No, that's correct.
Sorry. You've given them moderate weight, which is your third one down.
Middle.
Middle
Yep.
one down, okay. But you've done that without considering the extent to which those benefits are actually consonant with and consistent with Section 6 of the MPPF. Haven't you?
No, that's not correct.
Where's the analysis then?
Well, sorry, if you... so that's not correct. I have done that, but there isn't an explicit table within my proof.
Keep talking about tables. I don't care if it's a table. I don't care
or
if
text.
a
It's not a
poem.
table or
I don't
text.
care if it's prose. It doesn't have to be a table. But if you're going to do an assessment of consistency of benefits with government policy, you've actually got to do it. You can't keep telling us that all this stuff is implied and then not point us to anywhere in the proof that it exists. Where in your proof of evidence do you assess weight to be given to economic benefits with reference to Chapter 6 of the MPPF and what it says?
I have not done that.
There you go. So then, when the inspector comes to report to the Secretary of State on the extent to which the proposed development is consistent with government policies in Chapter 6, which is the second of the questions, she's got our evidence, obviously, from Mr Dobson and obviously Mr Bashforth, that address that question with reference to what the policies say, and she does not have a countervailing analysis from the Council on that question, does she?
No, what I would hope is when she reads the between the statement of case, the statement of common ground, and my proofs of evidence or proof of evidence, that within that there is sufficient information for her to actually understand the council's position in terms of how the economic elements of the proposals meet the development plan policies which have been considered against the MPPF.
Not the question about the local plan. It's really
I
not.
answered your question. I was just expanding and explaining after having answered your question.
Right.
Now, one of the other things the Secretary of State did ask is whether the proposals comply with the development plan.
Of course she did. Of course she did.
I've tried to address that as well.
Not as well. You've only done that. That's my point. You've looked at through the prism of the local plan. Of course, I'm not criticising you for doing that. We've tried to do the same thing. We've looked at the local plan. Of course we have. That is the, I think, fifth of the Secretary of State's questions, the extent to which it accords with the local plan, right?
Yes.
But the question that she asks at numbers 1, 2 and 3 are completely different. They're about the extent to which the scheme is consistent with government policies for different things. Now, when it came to housing, you had no problem admitting and conceding freely that we are fully consistent with those policies. And the same is true when it comes to sustainable transport. You've simply not done an assessment. Well, you didn't do an assessment in your proof on sustainable transport at Chapter 9 of the framework. You admitted that. The same is true for employment. You've done no assessment of the extent to which the development's consistent with those policies, as you have now confirmed. So, is it your view that... What is your view? I don't know. Do you say that the scheme is consistent with Chapter 6 of the framework?
I don't see an inconsistency with that chapter of the MPPF.
Is that another way of saying that? Well, right, I think I'll take that and just move on. All right. Okay. So there's, on an agreed basis then, when it comes to that second question, there's no inconsistency with any of the government policies in Chapter 6.
Not in terms of the MPPF, but I do think that there's a difference between that and compliance with the development plan policy and the weight that you would accord the employment space.
I know that. You've said that. I wasn't asking about the development plan. I do get that. Let's move on. Right. You say many times in your proof, when you're attributing moderate weight to the benefits associated with employment space, particularly vis-à-vis the southern scheme, the cumulative scheme.
The cumulative scheme.
Yeah, you say many times that it may well be that there could be alternatives employment sites that could come forward.
Yes.
And you explained that. I think we talked about this a couple of days ago, before
yes.
the weekend. And as I understand it, you tell me, because Mr. Pestel's evidence is that our employment space would meet needs that he, as I'm summarising, would meet needs that he has identified going into the future.
Yes.
And
I think he goes through to 2040.
Yeah, exactly. I mean, we've got his tables. We can obviously turn them up. I'm just if we need to, sure. And I said to him, I tested with him these alternative sites, quote unquote alternative sites, and he accepted. You might remember that it's not possible for this inquiry to reach any evaluative comparison between our scheme and any alternative schemes, and he also accepted that the so-called alternatives offer no basis to reduce weight attributed to meeting the needs that he identified by our scheme. Do you remember?
Yes, I do.
So we agree that you put forward alternatives. We've agreed, I don't actually know whether you're at limited weight to them or no weight to them on the basis of your answers, but they're either at no weight or limited weight, these so-called alternative sites, aren't they? Given all the things we've been talking about.
Yes, they're not at no weight.
Okay, fine. So they're at limited weight. Either way, they don't offer any basis to reduce the weight to be attributed to the employment offer from this scheme.
No, I disagree.
You disagree with Mr. Pestel?
Yes.
You disagree with Mr. No, hang on. Slow down. Mr. Pestel was describing his own evidence and the way that it can be employed, and he confirmed, because I asked him about this.
Yes.
He confirmed that his evidence did not form a basis for reducing the weight to be attributed to the employment offer from this scheme. If you're using it that way, Mr. Dygan, you've got it wrong on Mr. Pestel's own account. This is not our evidence now, this is your own team. Were you in the room when he said that?
Yes.
So, just to be clear about this, and I'm just going to leave employment, because we're sort of slightly through the looking glass.
I'll be happy to explain.
I'm going to let you explain in a minute, just so we understand what your position is. Your position is that Mr. Pestel, who was the specialist witness in this, has misunderstood the implications of his own evidence, and that you, Mr. Dygan, although you didn't mention any of this in your chief, but you, Mr. Dygan, are correcting him. Is that the situation?
Yes.
Okay. Go. Yeah, but explain by all means. And
so
we'll obviously make submissions on this.
Yes. So the Employment Land Review 2023 identified alternate sites. It forms the evidence base to the local plan. It's capable of being material consideration. Those alternate sites do exist. I can't say that they don't exist.
You can't say that they don't exist.
They exist.
They exist. All right, well, that's good. Anything else?
Yes. So having looked at the employment sites within the employment land review,
Yeah.
the council's committees, 2 of them, have looked at those and agreed which ones, if they are to be taken forward into the emerging local plans, which they would be. That strategy has also been agreed by full council. I think that the evidence base, insofar as the alternate employment land sites go, carries weight.
How much again?
Limited.
Okay. Okay. Sorry. And you
Yes.
think that the evidence base which has been agreed is a matter to which you attribute limited weight? Is
Yes,
that
I think it's relevant to the decision-making process.
So what, these sites are limited weight, are they?
I think they would have limited weight, yes.
Okay. Have any of them been publicly consulted on?
No.
No. All right. So you're at limited weight, and is that it, or is there more?
No. So having said that, and we've talked briefly about the LDS and the time frame for an emerging local plan if one comes forward. Let's assume something like 7 or 8 years. I think the Highsted schemes would start, if they were to be approved,
What's 7 or 8 years?
to adopt a local plan, allocating alternative employment sites.
You think it takes 7 years to adopt a plan?
No, not sorry. No,
Well, on previous.
no, it wouldn't take that. What I'm saying is, if you looked at a 7-year period, now the reason I think that that's relevant, the borough has an 8-year supply of employment land.
I see.
So let's say that you, in order to meet demand, which has been identified in the employment land review, Mr. Pestel's done quite a lot of work to look at over the longer period, not the next 8 years, like through to say 2040, there would not be enough employment land in the borough to meet need. He's quantified that. It's around about 73 hectares. And so that would need to be coming online at or before we run out of existing employment land, which is around about the same time it would take to adopt a new local plan and for allocated sites potentially to get consent and start delivering, which puts them around about the same time as I could expect the Highsted sites to the employment land, for example, around the science park, to start delivering. So when I look at the two, they have the potential, and obviously there are levels of risk around the time it takes to adopt the local plan.
Yeah.
Equally, there's a level of risk as to how long it would take to get consent for the junction with the M2 and to build the roads. So I see, in terms of the time frame, that there is the potential that the Highsted schemes could be delivering at the same time as alternate sites if they were allocated in the local plans adopted.
Yeah.
Now, so looking at the two, I think that there's a level of parity there.
Parity?
Yes.
What do you mean?
In terms of the time, the amount of space and the time when it might start being delivered,
Okay.
relative to when we're going to start running out of employment land, which is around about
Can I
8
just
years'
test
time.
some of this thesis with you? So you then, I mean, you are, is this right, reducing the weight to attributable, this is without any reference to the MPPF, it must be said, but you're reducing the weight attributable to our scheme's delivery of employment space on the basis of putative alternative sites, correct?
Yes.
Okay, all right. Have you considered, or indeed been advised of, the case law that surrounds the circumstances in which one's permitted to have regard to alternative sites in a planning balance? Or not?
No, I haven't looked at the case law about alternate sites in the planning
Thought at all
balance.
about it? Have you thought at all about why it might be difficult to put weight on alternative sites that haven't themselves been tested through any planning process, which is to say local plan or a planning application?
I haven't looked through legislation. What I did do, ma'am, is to then just ask myself if the two Highsted and these alternate sites could be delivering the employment land need.
You've said that. Don't just repeat yourself because we're going to run out of time. I know you've said that. That's what you did do.
Well, there is a simple comparator between the two.
Yeah, but there isn't though, because these are schemes without planning applications.
I think that there is a simple comparator.
But answer my questions. Sorry, I don't know.
No, it's right. Go on.
There are no planning applications for any of these other theoretical
No,
sites.
there's not.
So they're not simple comparators. We're not in a position, as Mr. Pestel freely accepted, which is why this is quite a strange conversation. Mr. Pestel accepted it was obviously impossible for our Secretary of State or our Inspector to reach even a preliminary assessment of any of those alternative sites. Quote, he agreed. And so do you.
I agree.
You agree. You agree that it's impossible for us to reach even a preliminary assessment of the merits of any one of those so-called alternative sites. They have no planning status, we agree, don't we?
No, no, I don't agree. They've been identified in the, evidence-based.
Let me ask a more specific question. They're not even subject to applications.
You haven't let me finish my response.
Okay, what? Okay, go on.
So they've been identified as part of the evidence base.
Yep.
In addition to that, they've been considered by members on 3 occasions, including at full council.
Yep, I know that. Okay, so moving on from that, there's no applications are prepared or in for any of them. They're not subject to any draft or actual allocations.
No.
So if the inspector's interested in allocations or applications, they have no planning status.
Well, there are certainly no applications or allocations for them.
Yep. And we agree that it's impossible for us to assess them in a relative sense against one another or against the scheme that's before the Secretary of State.
I think it is possible to compare them to the Highsted employment
Mr. Pestel
space.
didn't, and he was the one who was giving detailed evidence on them. He agreed that it was impossible to reach even a preliminary assessment of any of them before this inquiry.
I agree he said that.
You disagree with him on that?
And I'll explain why. The simple comparator is that the Highsted employment land needs to be accessed from the M2, which involves a junction in the Kent Downs National Landscape. The alternate sites don't involve that.
You've done infrastructure assessments of all of them, have you?
No, but they are identified within the appendices to the Employment Land Review.
And you've reviewed all of them?
And I have looked at those, and they don't require highway infrastructure like new junctions to the M2.
And so you've done yourself a few comparative timelines for each one to assess the deliverability?
No, the comparator was... I feel that they could be coming online within 7 or 8 years, which puts them around about the same time as employment space would be delivered on Highsted.
Yeah. Well, as long as you feel that, that's the important.
Can I just ask something though? Because it's not really a static situation, is it? The fact is, I think what you've said is that the LDS is dependent on the Secretary of State's decision.
Yes.
And that the Secretary of State's decision will determine, if you like, to some extent, the spatial strategy that the council will adopt. So if that's the case, and if the Secretary of State were to grant permission, there would be all these employment sites at the Kent Science Park area.
Yes.
So presumably all these other sites would never come about.
Well, certainly some of them would not come about.
Well, whatever is needed
to
provide
the balance.
The, meet needs. So,
It's just to highlight that there is more than one solution to addressing the employment land needs beyond year 8.
But the same's true for housing. I mean, if this scheme doesn't come forward, there'll be other housing sites that come forward, won't there? Somewhere. I mean, there'll be like the one at Faversham, the one at Bobbing, whatever, and other sites, right?
Yes.
And you have not taken the same logic to your approach to downgrading housing.
They don't involve junctions in the Kent Downs National Landscape to access them.
Our scheme does, though, doesn't it? You're doing a thing with employment, which is to say you're knocking down the weight to be attributed to employment on the basis of your comparable timeline thing and alternative sites. But the same logic would apply the logic we say is completely wrong and it's not supported, in fact, directly contrary to case law on what you do with alternative sites. Put that to one side, because that's case law. The same approach that you take to both market and affordable housing, if you were to take the same approach to market and affordable housing, you'd be reducing the weight to that also on the basis that sites would come forward through a local plan.
I haven't reduced the weight to housing.
Mr. Geigen, you haven't, because you've ended up with a logical inconsistency in the approach that you've taken to housing on the one side and employment on the other. You've not reduced the weight to housing, and there's absolutely no reason to reduce the weight to employment just because.
No, it's not just because. I've given you an explanation about the alternate sites.
You have, but you haven't given us an explanation as to the inconsistency. You can see that you've done one thing for housing, you've done another thing for employment, and there's no explanation under the sun to explain taking different approaches to the two. You either reduce the weight for all of it, or you reduce the rate for none of it.
I don't see it as a binary argument like that.
Okay, good. All right, well, thank you. Does Mr. Pestle know that you disagreed with his?
Be glad to talk to him about it after this. I haven't actually, I've spoken to him, but I haven't discussed this point with him in any detail.
All righty, thank you. That's it on employment. And so ultimately, where we end up, you're at moderate weight on the basis of the approach that you've taken, which is to say you rely on alternative sites, notwithstanding what Mr. Pestle said about the rectitude of that. You rely on alternative sites to reduce. What if the alternative sites paper hadn't been signed off by whichever committee? What weight would you have attributed to our employment benefits?
I haven't given that thought, but it would be less because it would have been the
more, right? To posit a hypothetical, imagine just for a moment that your alternative sites analysis is wrong, or that just imagine that the paper with all the alternative sites on that you're relying on, just imagine it just didn't exist, or that the council hadn't endorsed it, or imagine it wasn't there. So put aside alternative sites, if you can, and then give us the weight without alternative sites, knocking it down. What would the weight be for our scheme's employment and economic benefits?
Yep, sorry, I misunderstood you before.
I'm sorry, it wasn't clear.
That's fine. It would be greater. What I would do, so I'm talking about moderate at the moment.
You are.
And I would increase that to significant.
Okay.
Can I just explain within that moderate what that includes?
Yep. Only if you feel you have to, but sure. I mean, I'm not asking that, but you can do.
Yeah, no, it's just to explain. This site involves junction with the M2, the Southern Relief Road, quite significant pieces of infrastructure that you don't see with other applications that would involve jobs and spending through the construction phase. I think that these are uncommon and would generate jobs and spending that you wouldn't typically see with a regular application. Whilst those are one-time construction benefits, they're not ongoing, I also give them weight, and that's been factored into that, right. the moderate.
All right, that's the moderate. It's the moderate, and without the alternative sites, it would have been significant, but alas, there we go. So we've got a dispute between us on alternative sites and how they play. And just to be clear, when the inspector comes to reflect on all of this, even on your case, the so-called alternative sites are only getting limited weight.
Yes.
Okay. Righto, that's it on the benefits part of the questions, although there will be bits of all this that come up again, because we're turning to the final heading, which is the various balancing exercises that need to be undertaken. Balancing. Okay. So, if we just get the framework back out and turn back to paragraph 11, which I think is where we began the other day.
Close down Mr. Bashforth's evidence?
Yes, for now, thank you.
The framework?
That's right. Page 6.
Paragraph 11?
That's the one.
Yes.
So we've been through this. Obviously, we know we're not in 11C, as we've discussed already. We know that we are in 11D on account of out-of-datedness. And so we know that under the framework... Let's let the inspector rearrange. Have you got it? Sorry. Under the framework, permission should be granted unless either D1 or D2 applies.
Yes.
Okay. And you rely, or you suggest that we never get to D2, either on the north or on the south, or on the cumulative schemes, because of the operation of footnote 7 in respect of both applications.
Yes.
And that's because in both cases, both the North and the cumulative, you say that there are policies in the framework that protect areas or assets of particular importance, footnote 7, that provide strong reasons to refuse.
Yes.
Okay, so that's your case. And just to be clear, for the North, if we just start there, you say that there is one relevant footnote 7 policy, which is the policies that relate to built heritage.
That's correct.
And really, this is just to kind of walk through the decision tree so that we're clear on the way your case works. I'm not going to try and push you on how much weight different things get, because it's, as I've said already, a bit of a waste of everyone's time. The inspector have her own view. So what that means is your case on 11D1 for the North depends on the operation of 215 of the framework on page...
It does. There's no substantial harm here.
Yeah, if we just turn there very briefly.
Sorry, to
215, it's on page 61. Okay.
Just bear with me. Yes.
Yeah, 215, page 61, and just so we're clear, we agree on, I hope we agree on the way this works. Less than substantial harm, we know that's been, the degree of it is in dispute, but we agree it's less than substantial. This harm, so the less than substantial harm should be weighed against the public benefits of the proposal, including securing optimum viable use. That's the test.
I see that.
And that means that for the Northern scheme, this is the only relevant footnote 7 policy on your case. And what's happening is we take the extent of heritage harm on the one hand, and we balance that against the full panoply of public benefits that the scheme offers. Is that correct?
Sorry, Mr. Simon, say that again.
We take the heritage harm on the one hand, and we balance that against the full range of public benefits that the scheme offers.
Yes.
And so those public benefits would include all the benefits associated with market and affordable housing, the strategic benefits of delivering both southern and northern relief. Oh, sorry, the northern scheme. So there's the strategic benefits associated with the northern relief road and all the other elements of the northern scheme.
Yes.
On this hypothesis, including, as we've said already, affordable housing, market housing, developments. Forms of development for which, as you've explained, there is both at the local level and nationally a profound need.
Yes.
Okay. So, your assessment, so the inspector can calibrate, is weighing all of those public benefits against the extent of less than substantial heritage harm. The heritage harm outweighs. That's your assessment.
Yes.
Yes.
Yeah.
Okay. And in so doing, in so weighing, you've not expressly analysed the employment chapter of the NPPF.
So we're talking about the Northern scheme?
Yeah. You have
There's not really employment space proposed on the Northern scheme.
No, I'm aware was what's proposed. I'm going through the things that you haven't done when you're reading a view.
Okay.
You've not analysed the expressly anyway the extent of accordance with Section 9 of the NPPF.
Sorry, remind me which 9 was?
That was sustainable transport and locational sustainability. Those policies.
Yes.
Okay. Okay, and you have reduced the weight associated with the delivery of market housing in striking your balance here because of the 5-year housing land supply position being 3.9, not 2 or 1.
Yes, I wouldn't say I've reduced it to that. I just haven't increased it from that.
Well, all right, fair enough. Yeah, okay.
I think it carries
Calibrated it at that.
I've calibrated it at that. I think significant weight is a significant positive. I'm not suggesting market housing's not a significant benefit.
All right then. And even then, anyway, it is what it is. Okay. And your take on it is that, in particular, when it comes to the conservation area, the Tongue conservation area,
yes,
harm, in particular this one, this is on this topic, which is to say the harm caused by the Northern Relief Road passing through the conservation area. On this topic, this is the one thing you told us on Friday, the one issue where you are at variance with Kent County Council, even though you didn't tell their witnesses about it during their evidence, or indeed you didn't mention
in highway terms or heritage terms. I'm only disagreeing with them in terms of the route of the
well, they're
Northern
not
Relief Road.
heritage evidence. The point is that Kent's position is that any deliverable route that delivers the Northern Relief Road is going to
go through the conservation area.
Yeah, and you don't think so?
No.
That was something upon which you've taken no advice from any highways professional, correct?
Correct.
And no advice from any flood risk professional, flood consultant?
No, I haven't.
Because, of course, there are flood zones 2 and 3 that run to the north of the railway, aren't there?
Yes, there are.
And you've not given any consideration on the deliverability or the costs of delivering a Northern Relief Road in a way that manages those risks?
No.
Great. Okay, well, that's helpful. And we know that Kent's position, I can take you to it, but if you agree, I won't need
Okay.
to. Kent's position is that the northern route, by that, but I'm putting that in inverted commas,
I know what you
which
mean.
is to say the route that runs
North of the railway
north
line.
of the railway
Yep.
that would avoid the Tongue Conservation Area, is unlikely to be deliverable.
I accept that. I mean, you'd have to take me to it.
I can take you to it. That's
Yeah.
fine. Did you know that was their position?
I'd not heard them say that it was undeliverable,
Okay.
because I haven't seen an options appraisal that actually compares and contrasts
Fair
them in
enough.
terms of
Fair enough. That's
deliverability.
There's a report, isn't there? Because it's
There's a report.
twice as much or something.
Exactly, yeah. So 15.14 is the report.
Hold on.
Ooh.
Minute.
If you tell me, Mr. Dyken, when you find 15.14.
I have that.
Thank you.
Oh, hold on, I haven't. 14. Is this the plan?
No, it's a report. 15.14. 15.14.
Yeah, it's got the plan with it, I think.
Oh, it might have a plan at the.
Yeah.
Oh, it does. Sorry, it's got plans at the back.
Yeah.
But it's got reports at the beginning. Have you got it, Mr. Dygen?
I do. Could you take me to the
I
page?
can. So just to orient, the first couple of pages are Swale's matter statement to the local plan. But then if you move beyond that, if you move to page, I think it's 8 or 9, there's a report from Kent from George Chandler at KCC, which begins on PDF page 8.
I have that.
Okay. And at 3.5 on page 10, there's an options appraisal, as it were.
I see.
And the northern route is how many? What
Top
is it,
one?
like 3 times more expensive than the central route. So it was £50 million. This is 3.5.1. Sorry.
I see that.
It's 3 times the cost of the one that we're doing, and the other one as well. It's got strong environmental impacts, whether over or under the railway. It's unlikely to be deliverable, according to Kent.
I see, yes.
Did you know that?
I have read this document before, and I've clearly overlooked that sentence.
Accepting that then, and you've got just to be clear, you've got no evidence that to the contrary of this. This is the best evidence we have on the deliverability of the northern route.
Yes, and it talks about unlikely. It doesn't say that it is undeliverable, but it does say it's unlikely.
Not with magic wands, no. But it's unlikely to be deliverable, but primarily due to high costs. And you have no evidence to suggest that this is right. In fact, you accept this is right.
Yes, I do.
Okay.
Just noting it's quite old.
Oh boy. But all right, have you got anything more recent to suggest that
No,
things
there
have improved?
isn't. There's nothing more
Fine.
recent.
Well, then, are we really arguing about this? Your point, I think, is, if I try and formulate what you're saying, I think what you're saying is it is theoretically possible to deliver a northern route, but you also accept that in reality, although it might be theoretically possible, Kent don't support it, and indeed the best evidence is that it's unlikely to be deliverable. And that's even before we get into dealing with the flood zones and the costs and the technical challenges and the land ownership issues and the fact that Kent support our route. Have I got this right? You say theoretically possible, even if in reality unlikely to be deliverable.
Yes.
Okay, great. Which means that looking in the real world rather than the theoretical world, there's going to be a road. If this council's going to achieve the aspirations in its own local plan, there is going to be a road that goes through the Tong Conservation Area. You get that. I know you've not dealt with it or accepted that in your proof or oral evidence, but it's the likely state of affairs if the aspiration in the plan is to be achieved. Correct?
No. If you had a more up-to-date options appraisal which costed and looked at the feasibility and were able to come back and say that has been discounted, I would agree, but it's saying it's unlikely to be deliverable. Unfortunately, through the life of the application, further work wasn't done to look at the different options.
You accept that it is unlikely to be
I do
deliverable.
accept it's unlikely.
And therefore, so you just think about what you're saying, Mr. Dygan. If we agree that it's unlikely to be deliverable in the north, it follows that we agree that it's likely to be delivered, if it's going to be delivered, it's likely to be delivered somewhere else.
Unlikely doesn't mean that it's precluded.
It doesn't mean impossible. I know that. Come on. I know unlikely doesn't mean impossible. Listen to the question. If you accept that the northern route's unlikely to be deliverable, which you have done like 4 times, it follows that if the route is to happen at all, it's likely to happen somewhere else.
Yes.
And the somewhere else inevitably passes through the Tong Conservation Area, as I have said, sort of 3 or 4 times. And you agree?
So, Mr. Simons, I don't agree. What you're essentially saying is that any other route is precluded, and that's simply not the case.
I didn't. Okay, I'm done asking. So, can I ask it? Put it this way. I know. But you. Okay. You have not considered whether it's likely that the conservation area would be infringed or would be driven through or would be passed through by any realistic scheme to deliver the Northern Delivery Road when you're assessing your Northern Relief Road, when you're assessing your heritage balance. You've not considered any of this stuff. Your take is that it's theoretically possible to avoid it, and so this harm's not inevitable. And in reaching that view, you have avoided any assessment of the likelihoods of delivery.
I haven't looked at the likelihood of delivery.
Okay, thank you. Well, we have, and Kent have. Thank you. That's all I'm going to ask you about for the heritage balance in the north. Obviously, there's more to say,
okay,
but I just want to pick out a couple of headline points. Now, in the south, the relevant footnote 7 policies that you assert are the heritage one. I'm not going to ask you about the heritage one just because I've taken you to the balance. Obviously, it's a different balance, but we've agreed on the methodology for striking it, if you like.
Okay.
We know what it says. The ancient woodland test, which is to say 193C, I will ask you about that in a minute.
Okay.
And also the national landscape balance or test, series of tests,
yep,
which is 190.
190.
All right. Now let's just be clear about these, all of them really. And it might sound obvious to say, but if you're going to strike these tests properly, you've got to make sure that you assess your benefits properly and your harms.
Yes.
You've got to make sure that the benefits have been robustly and fully assessed and that you don't miss out important things. Obviously. Yes. All right then. Right then. Let's talk about the national landscape. National landscape. So this is what I'm looking at, 189 and 190 of the framework.
On there.
Thank you. There we go. And in particular 190, when considering applications for development within national landscapes, you make sure this bit's got it, page 55. You refuse permission for major development other than in exceptional circumstances. That's the first thing, exceptional circumstances. And where it can be demonstrated that the development's in the public interest. Consideration of such applications should include an assessment of the three things that you have your appendix that looks at them all. The need for the development, including in terms of national considerations, the impact of permitting it or refusing on the local economy. That's the first one. Second, cost and scope of developing outside the designated area or meeting the need in some other way. And third, detrimental effects on the environment, landscape, recreational opportunities and the extent to which it could be moderated. So that's the core test for the,
Yes.
as far as national landscapes are concerned.
Agreed.
So let's just walk through the elements of it together. Exceptional circumstances. Exceptional circumstances. Now, at one point in I think it was your evidence in chief, this word unique came up, and the inspector said, unless I'm misremembering, something along the lines of, well, is unique really, or I don't know who said it, I think the inspector said, is unique really the test or something like that, or is the test uniqueness? And you said, no, it has to be exceptional, but that you then, I think, qualified to the effect that you thought that exceptional suggested something that was, quote, quite similar to unique, basically. I mean, I say basically, you used the words quite similar. Is that your take?
I should not have said that.
You shouldn't have said that.
Yeah, unique means one thing, and no, it wouldn't. Exceptional, I don't think, means one singular thing in the world.
Got it.
Okay, so
fair enough. Okay.
I don't know. I can't recall exactly what was said, but
it's fine. It's not a tripwire. That's fine. So your take is that exceptionality is not similar to uniqueness. It's a different idea.
yes.
Okay, thank you. Right, that's the first thing. Second thing is that you suggested, repeatedly actually, that by allowing, in fact, let me ask something else first. When we're assessing whether or not exceptional circumstances exist in a given case,
Yes.
one is considering the totality of circumstances that exist in any given case and asking yourself in the round, are they exceptional or not?
Yes.
So it's not simply a question of taking it element by element and kicking each one out as being perfectly everyday or unexceptional. One looks at the package and you assess the package. It either is exceptional or it isn't, but you look at it as a package.
You'd have to.
Thank you. All right. So that's an important thing we agree on. Next thing. For schemes that involve housing, we're a scheme that involves housing, but obviously
Yes,
we're not limited to housing. We've got other things too. For schemes that involve housing, you suggested that you had a problem with finding that housing would be contributing to exceptional circumstances because, and I'm summarising here, but you tell me, you'd almost be saying that housing is acceptable in principle on that approach in the Kent Downs in all cases.
Can I?
Do you remember saying that, or words to that?
Words to that effect.
Yeah. Okay. Is that your view? Is it your view that if you let one through, if you like, with housing forming an exceptional circumstance, that you'd essentially be waving the white flag for the national landscape as a whole and just be saying, well, carte blanche? Is that what is that your fear?
No, what I'm saying is if by default or if by definition, housing alone, without any other, just housing by definition is exceptional circumstances.
Yeah, that wouldn't work.
No, I don't think so.
Okay. So just to cut it short, we agree with that. So
yeah, okay.
You don't need to go further. So your issue is by housing on its own being an exceptional circumstance by definition, that must be wrong.
That's my view.
On that we agree. Fine. So tick. But what about this? What about housing in certain circumstances contributing to a package which is exceptional. We've got no problem with that in principle.
If the if the package is exceptional.
Obviously, but this starts to become circular because the housing will...
I'm certainly not saying that housing couldn't contribute to a package that was...
There we are. So we agree then.
There's nothing offensive about housing.
Oh, good.
Yeah.
Good. That's nice to hear. Meeting housing needs in principle, then, we agree, can form part of a package of exceptional circumstances for the purposes of 190.
Yes.
Good. Okay. And there's no magic formula for exceptional circumstances. I'm trying to avoid going to any cases on it. I don't think we need to, given what you've said. We agree that housing can make a contribution, other things can too. Whether or not they're exceptional is just it's a question of judgment for the inspector and the secretary.
It is.
Fine. Okay. Now, that's the test of exceptionality. Okay. You say in your proof in section 19, if you could turn up section 19, and in particular,
Bear with me.
page 161.
Could you give me a paragraph number?
Yes. So 19.8d6.
After public interest?
Yes. Yes. So 19.86. You're accepting that we've got a number of benefits there,
Yes.
and you accept that they amount to public benefits, but that doesn't automatically equate to a benefit being in the wider public interest. So you're drawing a distinction between benefits that you say are public benefits on the one hand and benefits that are in the wider public interest on the other.
Yes.
Okay. And your explanation at 19.8d8, a couple of paragraphs down, whilst the proposal would provide public benefits, you see?
Yes, I do.
Whilst the proposal would provide public benefits, it would not conserve or enhance the natural beauty of the national landscape. Valued landscape wouldn't be protected. It is not considered that proposed development would be in the public interest. Do you see?
Yes.
So what's happening here, if I understand what you're doing, and I suppose this is my question, is you're saying, yes, okay, there are benefits. They are public benefits.
Yes, they're public.
The public interest within the language of 190 of the framework is not served, and the reason that it's not is because the valued landscape, to cut a long story short, is not protected. To summarise your logic.
In summary,
Yes.
what I'm saying is, because it's in the national landscapes, it is in the nation's interest to protect and enhance them. The benefits, therefore, to be in the public interest need to be greater than the public's interest in protecting, the national landscape, the nationally important public interest.
Yeah.
Because we're talking about something which is nationally important.
Okay.
So just looking for a level of equivalency there.
Let's try and think about this, though. Let's try and think about it. 190 is a paragraph that envisages that it is possible to bring forward developments in national landscapes and national parks, etc.
Yes.
And so and sometimes those developments are not going to protect the valued landscape in full if they're supported by the things that 190 is asking for. 190's relied on in appeal decisions to grant housing schemes, normal housing schemes, of a couple of hundred homes in AOMBs, national landscapes,
Yes.
or all sorts of things. And those housing schemes are not protecting the valued landscape, that the inspectors are finding in those cases that the level of benefits on offer justify through the operation of 190, granting planning permission. Do you get 190 as a mechanism through which impacts on a national landscape can be justified.
Yes.
So it makes no sense at all, with respect to you, to say that 190 must be failed because the national landscape's not protected. If that were the test, the way you've approached it, you'd never grant permission for anything in the national landscape.
You
see what I'm saying? You see the problem? You've said that we're not in the public interest because we failed to protect the valued landscape. But the fact that there's a failure to protect the valued landscape is a premise of 190. That's what you're doing in the first place. Major development coming forward. And let me put it another way. What sort of a scheme, in your view, what sort of major development would be supportable in the national landscape?
Obviously it's not the same as the Highsted scheme, but if you go down to Junction 5, that was accepted as being in the public interest with exceptional circumstances.
And did that protect the valued landscape?
Well,
come on. No, there was a change.
It can't have.
No, obviously it didn't. So the litmus test for whether you're acceptable in the public interest can't be whether you protect the valued landscape or not.
It's whether the benefits outweigh the national benefits, the national interest of protecting and enhancing the national landscape. In that case, at Junction 5, they felt that actually the public interest was met.
Why? What sort of things were adding up to an interest that was capable of outweighing the national interest in preserving the national landscape there?
So, it is within the CD list. If you go to that decision, there are references to pre-existing highway safety issues, including reference to fatalities and fatalities that would be avoided with the delivery of the Junction 5. And there were other things that were mentioned as well.
So we know that serious highways issues are capable of adding up to matters of public interest in exceptional circumstances.
Certainly at Junction 5. That's what is referenced.
Not just at Junction 5, though.
No, not just Junction 5. I'm just talking about one that I've got information on, which is relatively nearby.
So there are cases then where serious situations like prior highways problems can give rise to matters of benefits that are in the public interest that outweigh harm to national landscape.
Yes.
190. Okay. And so the litmus test is not whether the valued landscape is protected or not. As you suggest, at 19.88, it would be wrong to suggest, as you do, that the litmus test for whether something's in the public interest is whether the valued landscape is protected. The issue is whether the benefits are in the public interest or not. You get me? You agree?
Yes.
Okay. And we've got serious existing highways issues in the area here as well.
There are no pre-existing highway safety issues that need to be alleviated by.
Well, there are, but I didn't say safety. Major strategic highways constraints of a sort that we've spent weeks debating at this inquiry that exist here that would be solved by this scheme, as you've accepted. Correct?
Yes.
Major other things too, major growth requirements and employment and housing, all the things we've been over. There's no analytical difference why there can be exceptional at Junction 5 but not exceptional at Junction 5A.
No, I don't agree. I think there's a very big difference between the justification for Junction 5 and the current application.
This is important because obviously it goes to your understanding of what an exceptional circumstance is.
Just by way of example, the highway safety concerns that would have been alleviated or have been alleviated by Junction 5.
Okay, what about our highways concerns? Kent has been telling us all about them, and we've heard from Mr. Wild, and we've heard from you about your support in principle on the highways, link road and junctions going forward from a highways point.
Just by one comparator, there is an accident black spot which is resulting in fatalities that needs to be alleviated by the new junction.
Are you really
It's just one example.
I'm
right,
just saying that there is are you suggesting that in order to get over this hurdle, yes, we might have serious decade-long standing highways concerns that would be alleviated by this scheme, but unless there's an accident black spot, there's an analytical distinction. I mean, are you really saying that it has to be a highway safety concern and not just a highway?
I'm not saying that it has to be, but that gives you an idea about what has been accepted elsewhere as being exceptional. Mm-hmm. And when you think about it, it's like, well, if that's exceptional, I can understand it because you're talking about life safety issues. And then it's, in my mind, from a highways perspective, yes, that really does factor into exceptionality. Now, there could be many other exceptional reasons. You asked a question about what other exceptional circumstances, what might exceptional circumstances be, and there's a junction within proximity of the proposed junction where this has been explored and accepted before.
Okay, just to be clear, try and put a pin in it. Are you saying that the reason that you accept there are serious highways concerns that this scheme would alleviate, that hence the need for
highway congestion concerns?
Just congestion?
Well, so Kent County Council has agreed that there is a benefit from the relief roads connecting. No, I'm not disputing that.
Okay, air quality concern. I know we've been over that. So your position
I just don't think the air quality is as profound. No. Certainly, I don't think it represents an exceptional circumstance.
No, I know you're saying it doesn't, but it's that I'm seeking to test. You said that again and again in chief. I just don't think it's exceptional. Okay, but what is the framework against which you're reaching that judgment? And I've got to say, it sounds awfully close to me like, unless we can identify a road safety concern rather than all the other highways concerns that are live in this case, your take, Mr. Daigan, is as well, it might all be very nice to solve, but it's not exceptional. Are there any other sorts of highways concerns that could meet this exceptionality threshold, in your opinion? Or does it have to be highway safety?
It doesn't have to be highway safety.
Right. So what's stopping the highways concerns in this case from getting there, in your opinion?
I don't think that the benefits
are exceptional. That's circular. You've got to actually address the question.
Well, they're not so great as to represent an exceptional circumstance that outweighs the impact to the Kent Downs National Landscape.
That again is circular. I'm asking you to actually address head on what is it about these. Let's just take a step back. Kent have told us massive strategic, I'm summarising obviously, massive strategic highways concerns that have been going on for years and years. The local plan inspector told us that we're not going to be able to grow in Swale unless you solve this problem before 2022. We've been over all of that. We know that Swale is stuck with a massive strategic highways issue that even now it doesn't have an answer to. Your take is, well, not a highway safety concern. That's not an exceptional. Solving that, which I accept there's a strategic need to do in highways terms, that's not an exceptional circumstance. My question is, why not? Is it just because it's not a highway safety concern? How much more big would it have to be for you to get it over the line?
Well, it's a package of measures, isn't it? It's not just the highways representing exceptional circumstances, which it really was. Well, not entirely, but the larger part of Junction 5 was because of highway matters. Here, there are other issues.
Okay, so it's sorry, go on.
So the highway works. So they provide access to the jobs that are proposed on site.
That's not. Yeah, but they do an awful lot more than that, though, Mr. Daigan, don't they?
It's one of the things that they do. And
what about providing access to the entirety of the west of the borough? How about that? How about opening up the A2? How about providing access connections between the A2, the Eurolink, and the Isle of Sheppey? How about avoiding the centre of sitting? How about the massive strategic benefits Mr. Wild was talking about? It's a lot more than just access.
Well, if you look at the comments from Kent County Council, they do talk about benefits to the eastern side of the borough.
I meant east, I said west.
When you look at the Northern Relief Road and you look at the commentary within the local plan, it talks about its function being as a local distributor. The Southern Relief Road would then connect to it and certainly provide more resilience. If there were issues on the M2, this would give you another way to travel between the A2 and the M2, so it adds another connection, providing resilience. But with those benefits, I don't see them as being exceptional. I don't see that they reach that level of benefit as to be exceptional.
Because this is what I'm trying to drill down. I mean, I know you don't, but that is to just continue to repeat your conclusion. And what I'm begging you for is to engage with the analysis that leads to that conclusion. There's a suite of benefits. Mr. Wild spent literally 3 days talking about them in chief. We know what the benefits are. They're wide-ranging and not contested by you.
I think they're significant
benefits. You say that
benefits.
They're not exceptional.
But I don't think they're exceptional.
You don't think they're exceptional? No, you've said that. Okay. You accept that they were exceptional at junction 5 up the road because there was highway safety involved. Okay. So I'm desperately trying to get you to engage with, all right, they're exceptional there, not exceptional here. Why not? And I keep putting to you, is it just because there's no highway safety concern? What is it? What is it that means that serious highways issues at junction 5 meet the threshold and serious highways issues at junction 5A don't? This is what I'm trying to get you to engage with,
Just
rather than just repeating the conclusion again.
The level of benefit is not sufficiently high to be exceptional. Relieving congestion, providing additional resilience, relieving congestion to the east of the borough. I think that those things are
future growth of the borough. Would that be any good? Unlocking the ability of Swale to grow.
Those things are all of benefit. I just don't see them as being so significantly beneficial as to fit within what I would view as being exceptional. I've put significant weight, positive weight, on the combined southern and northern relief road. I just think that is different from saying that they're exceptional and justify impacts to the Kent Downs national landscape.
Thank you. All right, no more questions on that. Just a couple of questions though on 190 A, B and C, just so that we're, again, really it's just a question of just trying to illustrate where you are and why you're there so the inspector can calibrate your evidence against that of Mr. Bashforth and obviously reach your own view. 190 A, B and C.
I see that.
So when we're deciding whether there are exceptional circumstances and whether it's in the public interest, these are things that we've got to be considering, the things at A and at B and at C. Right? Not exclusively, but we've got to include an assessment of these things. And you've given us an assessment in your one of your appendices. Yeah?
Yes.
Okay. Need for the development is the first one at A. Need?
Yes.
And I think we are on the same... There's a need, isn't there? You agree, for every element of our scheme. The housing market, affordable, the employment, as Mr. Pestle explained, we're meeting a need there. We've agreed that the northern and southern relief roads are supported in principle as well, in highways terms, because they meet strategic needs that Kent's evidence identifies. All of the major elements, anyway, you accept meet needs.
They do meet need, and I'd qualify that. It's just the weight that you would put on that. I think that there are alternate sites where the employment space could be located.
Been over that one.
Housing, and you've heard the Rule 6 party, they've highlighted there is a gap in our ability to meet the long-term need, the forecast need, around about 6,000 units.
No,
certainly
we've been over that, and you've accepted that that's not a number that's supported by any evidence in terms of the proportion of the 7,000. That's also not part of your case, Mr. Dygan. You've jumped on it from what Councillor Speed said. It's got nothing to do with your evidence, that 6,000 figure, and you've accepted that it can't be right because we don't know the proportion of the 7,000 which is actually deliverable.
It's just, is the housing exceptional if you have other options which might come forward?
Well, I know you don't think any of this is exceptional. I'm struggling to see what you accept would be exceptional unless it involves highway safety concerns. I'm asking you about the need, and it is true, is it not, that you agree there's a need for all of the major limbs of our development?
Yes, and I would qualify that because I think the weight given to that need, there are factors that would reduce the weight.
I know. We've been over them. But anyway, is there a need? Yes. Is there a need for all of it? The roads, the houses, the employment, all of it? The answer is yes, so far as you're concerned.
Yes. Now, just to explain that some of the development, and I'd just sort of say such as sports hubs, the need for them is generated by the future residents on the site.
Exactly.
So there are some elements which...
Where the need comes from the need
comes
itself.
from the development itself.
But the development itself is something for which there's a need, so we accept ultimately that everything that's being put forward is needed.
Yes.
Great. So is there a need for the development as a whole, the whole thing, north and south, is it all serving needs that exist? Swale, as local planning authority, said, yes, it is. Yes, it does.
Yes.
Okay, that's the first thing.
Noting that I've said that the weight given to that need needs to be taken on board.
Meeting needs for the reasons that you've explained, the alternative sites that get limited weight and the 6,000 housing number that you've accepted as unevidenced. Including in terms of any national considerations, we've been over what some of those are. We've talked about national considerations, haven't we, in respect of what's in the NPPF and what the ministers are saying? And
yes.
Okay. All right. And the impact of permitting it or refusing it upon the local economy. Now, this is one where you hedge a bit and you say, well, there'd be some pros in terms of permitting it and there'd be some cons in terms of the rural economy. And so here's what I'm asking you. Overall, net, there'd be massive economic benefits associated with this scheme, which outweigh the extent of any impacts on the rural economy. Correct.
There wouldn't be a rural economy.
Yeah, come on. I know the economy would change. I know you've not assessed this part of the NPPF, but think it through. The net impacts economically of this scheme are positive on the local economy, aren't they not?
On the local economy,
Yeah, that's the one.
it would replace the local economy.
Have a go at answering it, Mr. Dygan. Have a good old go, because boy, oh boy, am I running short on time if I have to keep asking every single question 5 times. Do you see the impacts of permitting or refusing on the local economy? The local economy would be significantly boosted in terms of local GDP or GVA as a consequence of granting permission. We would be bringing in much more money than would be going as a consequence of the change in the local economy. By many, many factors, obviously. Right?
Yes.
So when it comes to 190A, we agree there's a need and we agree that the net impact of permitting the scheme would be positive, which means that the net impact of refusing it would be negative on the local economy.
No, that's not the case. The local economy currently functions. There's certainly no evidence to say that refusing the scheme would harm the local economy.
Okay, but permitting it would improve it. So refusing
It would displace it.
Oh, come on. You've said this. All right, I'm done asking that. All right, that's A. We agree that permitting it would bring about a benefit, a net beneficial impact on the economy. You agreed that before you kept going on about displacing. And we agree there's a need. On B, the cost of and scope for developing outside the designated area or meeting the need in some other way. We're talking here about the bit that's within the national landscape. Obviously, that's the premise of 190, that you're in the national landscape. And so we're talking about the junction, to the bit of the junction that goes south of the motorway.
Yep.
And we agree, we've been over this already, but if the Southern Relief Road is to be delivered, it cannot be delivered outside the designated area.
No, I agree. There are some other things I could say there, but I'll leave it at that.
All right then. So we agree there's a need, we agree that permitting the scheme would be beneficial to the local economy, and we agree that the development can't be done outside the designated area if it's to happen at all. All right. And on C, detrimental effect on the environment. Now, I'm not going to ask you about the detail, as I said, because I went over the detail with Miss Miller. Ahern and Miller, I think, as well, at some length. So I'm not asking about the extent of detrimental impact on things like the special qualities. I've been over that. But I suppose here's the planning-y question, which is that you're not suggesting, are you, that the Southern Relief Road could be delivered in such a way as to cause any less harm on the environment or any fewer effects on the environment than we are? Also, as far as the national landscape is concerned.
Yeah, so you're, just so I am clear, you're asking me whether you think the junction works and everything associated with it could be smaller.
No, I'm not. I'm saying you've got no evidence to suggest if the Southern Relief Road's coming forward that it could be delivered in such a way as to cause less harm to the special characteristics of the national landscape.
Is that question assuming that the junction 5A is to be built?
Correct. On the assumption, obviously, if it's not built, no effects. So if it were to be built, we've agreed that it has to go in the AONB, the national landscape, CB. On C, if it's to be built, and we also agree that there's a strategic need for it to be built, such that it should be supported in principle as far as highways go. But on C, you've got no evidence that if it were to be built, it can be built in such a way as to cause less harm to the special characteristics of the national landscape than we're causing.
So I agree. It results in residual harm that can't be moderated.
That's not quite the question. You're not suggesting that we've missed a trick and it could be done better. You're not suggesting that there's an alternative way of doing this that would lead to less detrimental harm than you say we're providing.
And I'm just recalling back to the evidence from Miss Miller, and the conclusion was that there would be residual harm that can't be mitigated or moderated.
No, but do you remember, can you listen to my question? Miss Miller, you will remember, is just interested in the AONB unit.
Yes.
She's not interested in whether there's a strategic case for the link road at all. All she sees is harm, and she explained that. She's not interested in a balancing exercise. That's your job. You're the planner. You're not just looking at her evidence. You're looking across the piece, including at the highways evidence, and you've accepted through the highways evidence that there is a strategic need to deliver this southern relief road in highways terms. So I'm asking you about the consequence of your view on that. The consequence is that, if it's going to happen and meet that need, it can't be done outside the AONB, the National Landscape, C190B. There's a need to do it, C190A. And on 190C, you are not suggesting, are you, that the impacts could be lessened to the national landscape lower than what we are?
No, I'm not saying that there is something that you should do to make it better that you could do.
Thank you. Okay.
Ma'am, what I am saying is that the effect on the environment, the landscape and recreational opportunities would be harmful, and I think no more could be done to moderate that. There would be residual harm. But I agree with Mr. Simons. I don't think that there is something additional that they could do in terms of whether it be planting more trees or moving the junction one way or another.
Thank you.
Yeah.
Thank you. I'm not going to ask anything more about AONB planning balance. I'll leave that one for the inspector. All right. The only other planning balance I wanted to touch on in this cross-examination as a whole, which does suggest we're getting perilously close to the end, which I don't want to get too excited yet, is Ancient Woodland. And again, there's not that much more to say about it, but at page 56 of the framework, please.
Yes.
Page 56, para 193.
Yeah.
Okay. So, 193C is the policy, isn't it? I think this is the relevant footnote 7 policy. Yep. And really, again, this is calibrating. We could go on back and forth all day long on whether there really are, wholly exceptional reasons, etc. But you've explained what your take is, and the inspector's got to evaluate it. But just looking at 193C as a whole, and trying to just get a sense of your take. So development resulting in the loss or deterioration of irreplaceable habitats like ancient woodland and ancient veteran trees should be refused unless there are wholly exceptional reasons. C70, it gives an example of infrastructure projects.
Yes.
Where public benefits would clearly outweigh the loss or deterioration of the habitat. Not all, unless there are wholly exceptional reasons and a suitable compensation strategy exists. That's the test.
Yes, it is.
All right. So, and we can put to bed the second bit, the final few words, because we agree that a suitable compensation strategy exists.
Yes.
So that bit of the test is met in our favour.
I think so. Yes.
Okay. And we are talking, aren't we, about the loss of you did tell me the other day, 0.21 hectares of ancient woodland, subject to that suitable compensation strategy and the ratios that you were talking about and all the rest of it. Right?
Yes.
So this is your evidence then to the inquiry, to the Secretary of State. The benefits of delivering, this is going to be the cumulative scheme, isn't it now? Because it would be, yes. Southern, so it's the whole thing. So the benefits of delivering 8,400 homes, 2 strategic link roads that, as we've been over, would unlock growth around Sittingbourne and have all the benefits that Kent say that they would have. providing all of the employment space on offer, providing 350 hectares of new open space, subject to all the caveats that you've been over, all of those benefits, the totality, right? That the totality of those benefits are outweighed by the loss of 0.21 hectares of ancient woodland, even when there's a suitable compensation strategy for that loss. That is your evidence.
It is. So just to talk about the suitable compensation strategy, that's not taken into account at the point when you're examining exceptional reasons, wholly exceptional reasons.
Correct, yeah.
You're talking about irreplaceable habitat, which is why they use the word wholly exceptional.
Yeah. And
what I'd be looking for is an equivalency, something wholly exceptional to justify the loss of the ancient woodland. And
let me ask you this then.
Yeah.
What scheme could ever meet the bar that you're setting? So we're talking about 0.21 hectares of ancient woodland being lost. We've got all the stuff that I've described very briefly on the other side of the scales. You say the loss of the ancient woodland outweighs because they're non-exceptional. So just theoretically then, how many houses would we need to be? How many motorway junctions would we need to be offering up? How many 100,000 square foot of employment floor space? How many hundreds of hectares of open space? What would be enough to meet your threshold?
I think just to explain.
Well, just
sorry,
answer.
Just wasn't a yes/no question.
Do answer.
So if it was a situation where there weren't alternate employment sites that could be delivering, if so you've got the benefits of the Northern Relief Road. It's described as a local distributor. I don't see that as being wholly exceptional. I don't think the employment space is wholly exceptional, given that there are alternate sites.
Yeah, alternative sites.
We've talked about housing, and I think if you were saying, and this is similar to whether you think housing is exceptional, I think does it go from significant to very significant in terms of a benefit? If the borough was in a worse position, in relation to its 5-year housing supply, its housing supply was much more dire, then you'd be putting greater weight on the housing. In terms of open space, I've described the benefits of that, and I'm not undermining the benefits of sports hubs and so forth. I just don't see them as being wholly exceptional.
I know you don't, and you're, again, with respect, you're repeating yourself, and you're not answering my question. So my question was, I think, straightforward. You don't think our scheme's exceptional. You've told us many times. Huh? Wholly exceptional. Sorry, not or wholly exceptional. You don't think that we are that. So I've asked you, what would we have to do? What would be a world in which you'd be sitting here saying, yeah, there's a scheme here, and you know what it is? Wholly exceptional reasons, I think, have been met to lose 0.21 hectares of ancient woodland. I think the test is met, actually. Tell me what a scheme like that would look like. What would it have to do?
Well, you asked what sort of world would it be. I think it would be a world where there were no other options in terms of meeting employment supply beyond the 8 years, where the borough was in a far worse position in terms of housing land supply, where potentially if there were highway safety issues that needed to be alleviated by the highway infrastructure. Okay. And then I would be saying, actually, these are wholly exceptional reasons.
Fair enough.
But there are alternatives.
No, I know, don't repeat yourself. Yep. I know, you've said it. Yep. So the reason that we're not, just to try and crystallise your logic, the reason that we're not at wholly exceptional reasons is because the scheme could have got there, as in the scheme has elements that are capable of getting there, you say, but they're not there in this case. And the reasons that they're not there are because, number one, alternative sites for employment, not for housing. Correct?
Well...
Boy, come on. You've just said it. I'm just trying to crystallise your logic. You say... This is right, isn't it? You say that there is a world in which this scheme could actually meet the wholly exceptional reasons threshold, but it doesn't. And there are reasons that you've literally just given for why it doesn't. And the first is that you say there are alternative sites for employment. Correct?
Yes.
even though we've been over that anyway. Okay, fine. The second is that the housing land supply situation is 3.8 and not lower.
And there are other options. This isn't the only option the borough has to address its housing need.
So in order for a housing scheme to meet this threshold of wholly exceptional reasons, it would, in your view, have to demonstrate that it is the only option to address housing need in an area.
You would need housing to represent wholly exceptional, like, a level of equivalency.
Circular, answer my question. You've just said that we're not wholly exceptional here because there are other options. You said it for employment, you said it for, now you're saying it for housing as well. So answer my question. Is it your view that in order for a scheme to get to wholly exceptional reasons, it's got to show that it is the only option that an area has?
Not the only option, but in
Right.
addition to that, I'm also suggesting that the housing land supply position, and I've talked of this before, I'm not suggesting that there be some sort of race to the bottom.
No.
But nor is a 1 year shortfall as significant as other boroughs have it.
So there we go. That's what I said. So housing land supply is one issue that means it's not wholly exceptional in your take, even though it's 3.8, not lower. And another one is alternative sites, even though we agree that you don't have to show a lack of alternative sites in order to get to wholly exceptional reasons. Correct?
Yes.
Great. And just to test it one step further, do you see wholly exceptional reasons and examples given in that footnote? And it talks about infrastructure projects. Do you
Yes.
see? This has got an infrastructure project in it, hasn't it?
Yes.
I mean, it's more than an infrastructure project, obviously, but it's got a lot more going on than just infrastructure, but it includes a significant infrastructure piece to it.
Yes, it does.
And for infrastructure projects, there'll be exceptional circumstances if the public benefits clearly outweigh the loss or deterioration of the habitat.
Yes.
And so it follows that your evidence to the Secretary of State is that the public benefits associated with the scheme on offer here don't clearly outweigh the loss of 0.21 hectares of ancient woodland.
And that's within my planning balance. So having considered the benefits of the scheme and then having considered the impact on ancient woodland and looking at those benefits, I don't consider that the public benefits outweigh the loss and deterioration. Well, not deterioration, it's loss.
Loss of ancient woodland.
Yep. There may be some deterioration as well at the edges,
Okay.
but
All right then.
it's the
Fine.
2.1 hectares
Loss.
that's being lost.
All right. 0.2, 0.21, not 2.1. Okay. All right then. Thank you. Almost there. Just a couple of now. That's basically it. There's just a couple of extra things that I just wanted to check with you before I hand you back to the inspector, obviously, and to Mr. Pereira. This SANG thing.
Yes.
The SANG transfer document thing, in respect of the area in the northern. I don't know what the right way of describing it is.
They call it the country gap.
Stones Farm country gap thing that it came up about SANG. There's something, I think we're still waiting for it, but we're going to get maybe the transfer document where.
I can update you to a degree as to what I've found.
Go for it, yeah. Sure.
It's not particularly helpful, that's all. Well, to anyone who's trying to understand it. So the I'm still very much and I've had about 10 emails today which I haven't gone through. A number of those, they've looked at the title itself. This is of the land which is being transferred to the council, and it's got sort of more than one title, and they couldn't find any reference to SANGs in relation to that. I was like, well, how does that work? Because if it's being transferred to the council with the covenant must be coming from somewhere. And I have emails from, so I've got a hold of the correct person within the legal team who's dealing with this. So it's just, I've been quite busy over the last couple of days. So So I am making progress, but I don't have an adequate answer for you yet.
No, that's obviously fair enough. I suppose let me just ask this then. I mean, I appreciate obviously I appreciate the effort that you're making to work it out. In any event, as far as we can tell, it's something to do with a covenant on it that's recorded in a transfer document.
It is.
So there's no planning conditions, planning obligation, planning policy, planning permission, that requires it to be used as a SANG.
Not that I can find.
No.
And it's difficult because we are in an inquiry. I don't want to be saying things which are supposition. I'm trying to give you things which are hard facts. No, of course.
But so far as you're aware, it has no planning status as a SANG. There's a covenant that for some reasons described it as a SANG, even though there's no policy conditions. So far as you're aware, that is correct.
Yeah. So the bit that concerns me is the SAMS payment was reduced by half because they were doing on the SAMS payment.
Yeah, well, exactly. Okay, but there's no SANG payment.
No, so SAAMS.
SAMS, which is different.
Which is different.
Right.
That was reduced by...
No, there's no SANG. Exactly, that's my point, is that there's no SANG, there's no planning basis for the planning system to regard this as a SANG. It's all very well a covenant calling it a SANG, but there's no permission policy.
No, I'm just explaining what I found. So normally they ask for the full contribution. Yeah. They ask for half of the contribution on the basis that there would be this on-site suitable alternate natural green space. Uh-huh. And SAMS payment quite separate. Then you've got this on-site SANGS requirement not embedded in the Section 106 or in the conditions. Natural England understand that it has been secured though, and it's within the transfer. So I did mention that what I've found is not particularly helpful. You might need to give me more time. Just continue to look at it.
More time's fine, obviously.
Yeah.
Well, I'll say it's fine. We are running out.
Oh, no,
of time.
I know.
So far as you're aware, there is no planning that any SANG idea. We still don't know whether it's in the transfer document, but we're waiting to see it. There is no planning status associated with a SANG on this site.
I think there must be.
Now, hang on. So far, there's no policy, permission, condition, obligation. Nothing in the planning system points to this being a SANG.
Apart from this covenant, which is on the title and the link back.
It's a private law. Do you get the difference between a private law covenant that for some reason's called it a SANG, which is fine, and something that the planning system recognises?
Well, it came out of the planning decision where they agreed that, subject to the on-site provision, they could take a reduced cash contribution, and then.
What proof have you got of that? I don't honestly.
It's in the subsequent committee reports and the response from Natural England.
Right. Okay. We're going to have to leave it then. And
I will do my utmost to try and join the dots.
Can I put it like this? The planning system has not secured that land as a SANG.
No.
That's sort of what I was trying to ask. Okay. So the planning system has not secured it as a SANG, which means it has no planning status. It might have status in we don't know. It might have status in private law, but it doesn't have status in the planning system. It's because it's not secured by the planning system.
It's not secured by the.
Right, fine.
Yeah.
That's it on that. Next, there are those who have made the suggestion that it's inappropriate as a matter of principle for these applications to come forward in outline.
I have heard that.
You have, I've heard it, but it's not your position or Swale's position as an authority, because we agree that it's acceptable and appropriate for these schemes to come forward in the way that they have done.
There's no objection to the format of the application.
Thank you. And last, acute care, contributions for it. Now, there's a back and forth in written correspondence between Quad on the one hand and the Trust on the other hand, going over the arguments for and against there being a contribution. You've not addressed any of those arguments in any detail, well, I think at all, in your written evidence, or indeed in your oral evidence, have you?
This is just within my proof, and section 16, which is page 117, I touch on this.
Go on. Page 117.
Section 16.
Yeah. Yeah, national landscape, and then you turn to acute care from 119.
Yes.
Yeah, I think what I'm saying is that you're summarising there what the NHS have asked for, and you're summarising what's in a statement from Mr. Dovey and Ms. Brooks Sykes, but that's not what my question was.
Okay.
Have you read the quad response to the NHS requests?
There's more than one, but I certainly read the one from July. Is that the one you're referring to?
Yes, I have.
Yep.
Sorry, yes, I have. Excuse me. Yes, I am. And that sets out a number of points that include the extent to which the funding issue within which the NHS finds itself is a systematic issue to be solved by central taxation rather than a development control issue for the planning system.
Now
hang on. Are you familiar with that line
I am
of debate?
familiar with that.
Now, that is not an issue that you've actually given any airtime to in your proof of evidence or indeed in your oral examination in chief or whatever.
No.
No.
What I would say, ma'am, is that there is a comprehensive response to the July letter by the NHS in August. It's either the inquiry document before or after the applicant's July letter.
It's after.
And it will be like the very next one. And I mean, Mr. Simons, if you wanted to go through sort of what was sent in July and
I'm going to leave it for the.
That would be
your position, nonetheless, is that. So this is not my point. Is that the arguments there, one way or the other, are not arguments that you have actually grappled with as a planner. Which is to say, you've not taken on yourself the job of actually deciding or reaching a view on the extent to which the systematic issues are indeed matters to be dealt with through the planning system versus matters to be dealt with through central taxation. You've left that job for the NHS and Quad to sort out.
So
is that correct?
No.
Okay. Where do you deal with this point about the systematic challenges of
within the silk compliance statement?
I meant in your evidence.
No, not in my evidence.
All right. Okay. There's loads of other public services that aren't getting any contributions out of this scheme, aren't there? Like the police, for instance. There's no 106 contribution going to the police.
No.
Why do you think that might be?
We've approached them and consulted with them, but they haven't given us any request for funding or demonstrated that they have some sort of additional need that would be driven by the application that they couldn't meet without additional capacity.
Money, yeah. And also the police is funded out of central taxation, like the army, like the NHS. Have you thought about what services come forward under 106 and which ones don't? Have you?
So I'm not sure that this scheme would generate a demand on the army that would exceed their capacity to be able to cope. The two are quite unrelated.
No,
but healthcare needs are derived from residential populations. In this case, there would be additional new and not everybody, but there would be some new and additional people on the site that would need acute care. And what the NHS have calculated is that actually they'll have reached a breaking point and they'll need to expand facilities.
I know that's what they're saying. And obviously, Quad have responded and they've responded. But my point is that you have not actually. You've accepted what the NHS say, and you've gone along with them.
I've tested that. And
have you? How have you tested it?
Not within my proof.
You've not tested it in your proof?
No, but we've been looking at this for some time, like well over a year. Okay. And I've had to put together a full compliance table sort of explaining how it meets the various tests.
All righty. Well, we'll leave that for the... And your view is that, if need be, acute care should be funded, even though the NHS is funded out of central taxation, acute care should be funded by this developer to the detriment of affordable housing. If push comes to shove, and there's a sort of set pot within which the scheme could come forward viably, then affordable housing should take a hit so as to provide for acute care.
It's not an easy decision.
I know it's not easy. That's not my question.
No, it's just that we've been put in the borough.
Is that your view? Is that in a nutshell, the logic of your position, to the inspector is that acute care should be funded in preference to affordable housing?
No.
No. Then what's the 106 blue pencil clause all about then? You're saying that if the...
Mr. Simons, if you have a look at what we're saying, the borough has tried to strike a balance, understanding that acute care needs are very important, as is affordable housing. The borough's declared an affordable housing emergency.
Thought it had, yeah.
What we've said in relation to the Northern scheme is that we would reduce the acute care contribution to ensure at least 10% of dwellings on the Northern site are delivered as affordable housing.
Mm-hmm. Why 10%?
That allows some money still to go to the acute care. We're trying to strike a balance.
What's the policy basis for that 10%?
Well, there's not a policy basis for 10%. There is a policy basis for reducing the social infrastructure to keep a scheme remaining viable.
Okay.
We just want to ensure that the growth is accompanied by appropriate infrastructure, and have tried to strike a balance between affordable housing and acute care.
When you say strike a balance, what you're meaning is your planning judgment is that the appropriate way forward in this case is to accept the NHS's request and thereby to reduce the quantum of affordable housing that the schemes brings forward. That's the appropriate balance that you think should be struck.
Well, on the Northern site, we've actually reduced the acute care and increased the affordable.
Huh? What? Let me just have another go. Your judgment is that these sums should be paid to the NHS for acute care, with the result that affordable housing is reduced below that which would otherwise have been delivered.
So,
yes. Answer the question. Thank you. That's your planning judgment. Your planning judgment is that acute care is that providing these payments for acute care are more important than the full quotient of affordable housing being delivered. That's your planning judgment.
Yes, that's my planning judgment. Now, just to note that we haven't said actually acute care should always result in the come at the expense of affordable housing. What we've said is we're going to try and strike a balance. On the Northern site, actually the NHS won't be getting the acute care contribution that they've requested. They'll be getting less than that. But we also have an affordable housing emergency. So at the very least, we're seeking 10% of the dwellings on the Northern scheme to be affordable. But it's not the case we're deliberately trying to, we've got an affordable housing emergency, which is why we have said to the NHS, we need to strike a balance here. You've asked for these sums of money. They have a knock-on impact in terms of affordable housing provision, to the extent that we're not going to be able to give you everything that you've asked for in order to maintain at least a minimum level that the borough finds adequate for the Northern application. We're looking for 10%.
Is there a basis in the statutory development plan to support the acute care contribution?
Certainly, primary care is mentioned in policy CP6.
Yeah, I wasn't asking about primary care.
And then, sort of as an extension for that, in 2020,
Please
23, 24. Sorry,
do you remember what the question was?
I did say CP6.
No, but you said primary care. I was asking about acute care. The primary care is not something that I'm asking you about.
Yeah, so in terms of acute care, that wording is not used within the local plan.
So is that another way of saying no, there's no support in the statutory development plan for these?
Well, there's certainly support for social infrastructure.
I see.
Acute care is social infrastructure.
Okay. And which policies do you have in mind?
CP6.
Oh, right. Okay. Let's just have a look.
So I just need to open that. Bear with me, Mum. That is PDF 112 and page number 104 of the local plan. That's the policy itself, and obviously the supporting text is above that.
Thanks. And which bit did you have in mind?
Bear with me, because I think it might be useful to look at the definition of infrastructure, which is at Page 102, PDF 110. It says statement 6, so it's after paragraph 5.5.11. There is a blue box.
Definition of infrastructure.
The second bullet point is local healthcare facilities.
Mm-hmm. Mm-hmm. Do you think it would fall under local health facilities?
Well, Mr. Simons, I had mentioned that it talks about primary care.
I know it does. I'm not asking about primary care. Come on, this is the last thing I wanted to ask you about. Acute care. I'm asking about what support we've got in the local plan for the payment of acute care contributions. Because let's just call the spade a spade. Have you ever sort of signed off on an acute care contribution in a consented scheme before this? Has this come up before?
No, this
is a first for you, right?
Yep.
So it's not something that. And how long have you been working at Swale? I know you've worked all over. You've worked all over.
23.
London. Since when? Sorry.
Sorry, 2023.
This is the first time they've come asking, and the first time this has come up, so far as you're concerned.
As far as I'm aware, this is the first time the NHS and Kent have sought acute care contributions.
Exactly, that's what I'm saying. So that's why I'm asking about the local plan, because we are in a novel situation so far as Swale are concerned, and so it might just be worth asking ourselves, all right, have they got any? I mean, they've got their arguments. Quad have got Quad's arguments. We'll come back to it at the 106 session. I'm not going to go into them other than to just ask you as the planner what you consider the best case you've got, if you like, for a local plan policy that supports the acute care contribution being payable. So that's why I'm asking.
Yep. So I take the point, ma'am, that there is not an explicit reference to acute care within policy CP6, but there's clearly reference to healthcare facilities. The NHS have identified since the plan was adopted that actually there is an issue that has arisen where they're not their capacity to cope with additional patients for acute care has now reached a point where they know they're not going to have capacity to look after people. That's the necessity point.
You're moving into, you mean like necessity in terms of Reg 122? And, yeah.
No, in addition, so I'm just talking about necessity for a moment.
Yeah.
We know that there's additional population. The population need acute care. Well, a portion of them will do. Mm-hmm. And you can work out what the net additional is. You can then look at the capacity of the acute care facilities to cope with that additionality. Yeah. The NHS have been able to confirm that they don't have capacity to cope.
Can we just pause there? Because I specifically said I'm not asking you at the moment to go into the detail of the merits arguments. Because we've got the Quad letter, we've got the NHS letter, they've all got detailed arguments. I'm asking about policy.
Yep.
There isn't one.
No, I understand what you say. So there is not a policy within the local plan that explicitly mentions acute care.
Therefore, or not therefore, but it's providing this payment may be many things, but it's certainly what the NHS are asking for, though they've never asked before. But it's not necessary to make the development acceptable in planning terms, because it would not lead to any conflict. Failing to provide it, not providing it, doesn't lead to any conflict with the development plan.
So I don't know that. I'd need to look.
No, that's your judgment as a planner. This is the bit where this is the bit where we put aside what the NHS are telling us.
Oh, that's right.
Even what Quad are saying, and actually this is the bit where you actually get to give a judgment as a professional planner on necessity. So if failing to pay something doesn't give rise to any conflict with the plan, then it's not that payment's not necessary to make something acceptable, because there's no conflict that would arise by failing to pay it.
I'm just looking at the policy about implementation and delivery of the plan.
Look wherever. Just do answer the question. I mean, I would have thought, with respect, Mr. Duggan, I would have thought that you would have had an answer to my question, but without having to think about it now. I mean, obviously, look. But you're the one who's telling us that this payment is necessary to make the scheme acceptable in planning terms, and I've suggested to you that you haven't got any policy basis for making that assertion. That you appear to be agreeing with me.
Well, it's not explicit within policy CP6, but it does refer to healthcare facilities.
There'd be no conflict then with the plan by failing to pay it, would there?
So,
just answer.
well, there are references within the MPPF and the PPG for healthy
development plan. I've asked you a specific question. It's a fair question. You can qualify it with reference to the MPPF. Of course you can. I'd never stop you. But if you don't answer my question and continue not to, I mean, we're never going to finish. So I have suggested to you there's no local plan policy that would be conflicted with. The answer is no, there wouldn't. And therefore, so far as the local plan goes, there wouldn't be any conflict by failing to make this payment, would there?
I think there would be a conflict with CP6.
Because which bit of CP6?
Bear with me. Well, the policy doesn't actually specify a requirement for planning obligations.
I've got no further questions. Thank you very much indeed, Mr. Duggan.
I've got a few questions, but I think we need to have a quick break, just comfort break, don't we, really?
Have you got a broad estimate?
I mean, I haven't got much, maybe half an hour.
Okay.
I mean, we're not going to we'll get, are we finishing at 5:30 today?
Will we?
No, are we? Is that when you're planning to rise?
Oh, yeah. I would like to finish this witness if we can.
Yeah. We'll finish the witness.
Mind getting a cup of tea first.
We can. There's time for a cup of tea and to finish the witness and be gone by 5:30.
Well, you don't know how much I've got to ask yet, do you?
No, but I'm confident that.
Oh, good. Well, look, everyone can bring their cup of tea back. Certainly will. But I think we will just adjourn till. Would it be all right if we just adjourn till 4:05? Thank you. Just under quarter of an hour. Yep. Thank you. To resume. So I'll ask my questions and then you do re-examination, sorry. Right, Mr. Dragon, I've got a few things, but some of them are just clarifications, so we can whiz through those. First of all, what's happening about the Duchess Faversham applications? Could you give me an update, please?
Yes, just
Yes,
so I'm not the case officer for that application.
no.
So I don't know all of the ins and outs, but it is a large application and involves things like, consideration of the habitat regulations. And as I understand it, some of those types of issues still need to be bottomed out. And talking to not the case officer who's closest to it, but to my manager, he's indicated that there is an aim to take that application to the planning committee in the next few months.
Next few 2 months. Sorry, do you want to have a drink first?
Yeah. So a few months, I'm not saying 2 months.
Oh, sorry.
But in the next few months. But I'm not in a position to tell you what if any outstanding issues there are and what the recommendation might be. It would also need to obviously go to the committee, so I don't know what the recommendation is.
How far?
Just for what it's worth, it's a question of fact. I think there's a holding objection remains from National Highways.
Okay.
MAML committee are quite robust. They have been very clear with officers not to take things to committee if there are outstanding issues, so it won't go to committee until everything's been sorted out.
Right. Thank you. Just one or two points of clarification. If you could just got your proof. Page 12. These aren't quite minor things, but on page 12 you've got a list of the policies, haven't you?
Bear with me, I'm just getting to page 12.
Hang on a minute. Yeah, local plan policies. And if you just turn down to DM24.
Yes.
I wasn't aware that there was a valued landscape on the northern application site.
No, ma'am, there's not. DM24, and I take your point, that's what the heading is, but it also, within that policy, it encompasses situations where the landscape is not designated.
Right, okay, but there isn't a valued landscape.
Within the northern site, no, there is not a valued landscape.
Thank you. DM25.
Yes.
So this was in relation, you said, to the southern application. This is a gap policy, important.
Yes.
You said southern application site only. Well, actually, there is an important local countryside gap on the northern site, isn't there?
Yes, there is, ma'am. I think the difference is that built form, I mean, whether you call the road built form or not, but buildings are not proposed in the gap on the northern scheme. And just looking at what the gap policy seeks to do is to prevent the amalgamation of settlements. Mm-hmm. I take the point that there would be a road proposed in the gap, but notwithstanding that, I don't see the amalgamation of settlements, the erosion of the gap as a result of the road. I just, given that it's to spatially separate settlements, and it just anecdotally, in between settlements and Sittingbourne, it's quite frequent to see roads in between the villages. In fact, that's quite often how you get from one village to another is on on the highway.
Thank you. And finally, DM34. You said about these, you pointed out about the southern application, but there is, of course, the Causeway site, isn't there, and the northern.
Yes, there is.
So that DM34 would be relevant to the northern site as well, wouldn't it?
It is. I think the difference being that resolution was reached with Kent County Council Archaeology in relation to the northern site as part of the application, and various things were fixed such that it really became an issue that is taken care of subject to conditions and the parameter plans reflecting what they do. So unlike the southern application, there wasn't because it was an agreed matter, it didn't feature heavily within the objections to the scheme. It's not an objection. In fact, I think the archaeologist is quite happy with the northern application.
Okay. On the Northern Relief Road,
Yep.
I don't want to go over all that again, but can you just confirm that, or whatever, that you're talking about the northern route, and you said, although it's not likely, I think that's what you said.
It's certainly in that document we looked at, it said it's unlikely.
In the document.
Yep.
But there, if it were to go the northern route,
Yes.
is it likely that there'd be any means of funding it?
I would say highly unlikely. I wouldn't say impossible, because there can be sources of funding. It's something that I talked to the highway officer at KCC about, and he described various sources of funding that can come about.
Such as?
The sort of like LIP funding and so forth. But
Sorry, the what funding?
Kent County Council is able to apply for funding for highway works.
Oh, yeah. Mm-hmm.
But it's not easy to come by. I think they have already applied for it and not got it. So I'm not dismissing it as being impossible. I think it highly unlikely.
But I mean,
But probably a question for Kent County Council to answer better than I.
well,
Do you want me to ask them, ma'am? I can do that.
no, not particularly.
Okay.
I was just thinking about that. The report that we looked at. I can't remember what the CD number was now. If you remember.
Yes, I
and
do.
Basically said, I think Kent County Council indicated that it was unviable. So
Unlikely to be deliverable as opposed to unviable.
I thought they said something about viability.
So just for reference, it's core document 15.14 was the one, and it's on that. It's 15.14, and it is PDF page 10 was the bit that I went to.
Yeah. So if you could just. So what does that say?
3.5.1.
Yeah. So what?
The final sentence of that paragraph, it is unlikely the scheme is deliverable due primarily to the high costs. I'm just going to do a word search for viability, but I didn't think it mentioned.
Okay. Okay.
I mean, that's not exhaustive, but I've done a word search and I can't find the word viability.
Okay. Thanks. Okay. Did you say? I think you did when you were asked about Stones Farm, and you were talking about a sang. I think. Are the councils now the owners of that area of land?
As I understand it, no, not yet. It's still imminent.
It's what? Sorry.
Still very close, but not there yet. I appreciate this. I've said the same thing to you some weeks ago.
Yeah. I mean, any ideas when it's likely to happen? Is it just a matter of getting all the legal documents sorted out?
I don't think there's anything untoward. It's more that there's been a series of unfortunate events where administratively that's prevented it from being finalised.
I see.
Wrong plans, that sort of thing.
Now, I want to ask you a question which I think I asked probably Miss Bonney, actually. And I want you to imagine, just for the sake of this question, that
Yes.
the Secretary of State were to grant planning permission for the northern site.
Yes.
Okay. So if that were to be the case, obviously one of the things that would have to happen is that the relief road would, part of it would be going over land which one would hope by that stage is in the council's ownership.
Yes. You assume that by then.
Well, one hopes so, but
Yeah.
who knows? I
Yeah.
don't know. But anyway, let's all right. Let's take that additional assumption that it's in the council's ownership. Then.
Yep.
Because that seems quite likely, doesn't it? Given what you said. So obviously, Swell is a responsible public authority, and the Secretary of State will have weighed everything up and considered that the delivery of the Northern Relief Road is a matter of importance, I would imagine, and would have taken account of all the negatives that might arise because of that.
Yes.
So, do you think that, bearing all that in mind, that the and bearing in mind also, of course, the policy objective
Yes.
in the local plan, and all the things we've been talking about in terms of, if not viability, the high costs and the other issues with the northern route. So do you think that the council as a responsible public authority would, as a matter of principle, object to the Northern Relief Road going onto that line, if you like, which is within their ownership?
So I completely understand the question. Mm-hmm. It's particularly difficult for me. It's not. So the delegated authority for land transfers and that sort of thing sits within the legal department, mm-hmm. and that delegation, which sits with the requisite person within the legal department, in I think it says something like in discussion or in agreement with members. Mm-hmm. So when it gets to that stage, Mum, clearly the delegations will apply and decisions will be made in that forum as to whether they would agree the transfer or not.
We're assuming that transfer's taking place for this question.
Sorry, but let's say the conveyancing from the council to the applicant, for example, that would be a decision for the legal team. The relevant person in the legal team with delegation and members would then make a decision on that. It's just difficult. I'm a town planner and I'm allowed to assess planning applications, mm-hmm. but not comment on things that actually sit within other departments.
No, I mean, it was a more general question than that, really. It was really whether if planning permission were to be granted, I think there was the implication that the council, that there would be an impediment because the council might basically, because they objected to these applications, they might basically sort of raise all sorts of objections to that land being, the agreement between the applicant and the council being made difficult because of...
No, I'm sure that there would be no... the council's not spiteful, but at the same time,
that's really what I was
so I take your point, and I can see what the concern is. Mm-hmm. It's just,
I know you can't say for sure.
Yeah, I'm not. No, it's not my decision, and so I fully understand the question. I can't really answer that. I mean, it's a professional body. The executive are very professional. Members understand exactly what the issues are. However, I'm not in a position at all really to speak for any of them.
Okay.
Any of the people that would be making that decision, it doesn't sit in my department. Be a decision for members in the legal team. At that time, now the KCC and the applicant are aware that that could go really well, or it could be that it doesn't go well. And it may not be because the council is being difficult. It could be that there genuinely isn't a deal on the table which is acceptable.
Deal?
Well, if there was a land deal where the land was to be sold by the council to the applicant, for example, but it wasn't on reasonable terms, why would the council is not beholden to do something which is not in its,
I see.
in its reasonable interest. So I couldn't comment as to whether the council would or wouldn't agree to sell the land, and it will be some time away before that decision would need to be made. I don't see the decision probably wouldn't be made until after the decision's been made on the applications.
No, but the Secretary of State's obviously got to consider, one of the arguments was that there could be impediments to the completion of the Northern Relief Road because one of the points was it's going across the Tremport land, but I'm not asking about that because they're obviously private. They're a private company, but it would also go across the council's own land.
Yes.
And I suppose all I'm saying is that the Secretary of State would sort of need to reach a sort of what the Secretary of State considered was a reasonable conclusion on the level of impediment that might happen. That might cause unwarranted delays or even mean that it couldn't come about at all, if you see what I mean.
Yeah.
So, obviously you can't say what the council do, but
I do take the point. The borough has opposed the applications.
Yes, that's
so I do understand what you're saying. I'm just not in a position to to voice a view on it.
I see. Okay. All right. Okay. I don't think I'll ask that. DM32, paragraph 610. DM32. DM32. Just have a quick look at that. And it'll be CD 13.1, won't it?
Yes, it is. Page 291. That's the policy. Was it the supporting text, Mum?
No. Well, I don't think so. So what page? Page 291. Oh, yeah. 291. I just wondered whether you consider that was consistent with the framework. 291. Oops, David.
Bear with me.
Have you got that?
I do. I was just going to have a look at my appendices to remind myself what I said about it.
Yeah. Because it's a sort of permissive policy, isn't it? So it doesn't really tell us what would happen if there is harm. All it says is what would happen if, how it would approve things that affect this listed buildings. So it doesn't say anything really about if there's less than substantial harm, anything about a public benefits test or anything like that. And I just wondered whether you consider that the way it's worded, which is, as I say, in a permissive way, accords with the framework.
I mean, looking at it against the framework, I thought it was consistent with the framework. It seeks to address harm, loss of significance of designated heritage assets. But, Mum, you were saying because it doesn't make reference to less than substantial harm and substantial harm, is that where you're thinking there is a shortcoming?
Well, I'm thinking it says what it will do if everything's hunky-dory, but it doesn't say what it would do if if harm is found. I don't think, and therefore how you would deal with that, does it really? I don't.
Well, I mean, just reading the first line, development proposals including any change of use affecting a listed building and its setting will be permitted, providing that if they don't do those three things, then it won't be permitted.
Right, okay, so does that accord with the framework then? Because it doesn't mention anything about balance with the public benefits, does it?
No, you're right. It doesn't then go on to say if there's harm found that needs to be weighed against the public benefits of the scheme.
Well, I mean, basically it says if it doesn't accord with those three things, it's going to be refused. Full stop, doesn't it?
Yes, it does.
So do you think that's consistent with framework?
I had said that it was consistent, and
Well, do you think it is?
well, no, I take your point. It doesn't then require a balancing exercise. A number of the policies do, this one doesn't.
Mm-hmm. So what's your conclusion?
Well, not fully consistent. So I'd say, there's a significant, not a very significant amount of consistency with the MPPF.
So is it inconsistent then, do you think?
Well, no, not fully inconsistent, but it's not. I wouldn't say it's inconsistent with the MPPF. It's just not fully consistent.
I see. Okay. Okay. Thank you. Paragraph 7.43. You've mentioned this in a couple of places. So you say that the southern relief road is not needed to access the housing proposed as part of the northern application. So then you go on to say that proportions of the housing proposed in Oakwood and Highsted Village North could be accessed from the A2 or Highsted Road without the need for the southern relief road. And you're talking there about the loss of the ancient woodland, but I mean, there's no evidence, is there, that that could be the case? We haven't got any highway evidence to show what the implications of that would be, have we?
No, if I could, with the Highsted North Enclave, access is a reserved matter, so we don't have the access details for all of these. But that Highsted North Enclave is only accessible from Highsted Road. It doesn't rely on the relief road at all.
No, okay, but you did say villages. I was presuming you meant slightly wider than just that.
Backchild and
that blob at the top.
Yes, so just given the proximity to the A2, I'd made an assumption without consulting a highway engineer that in actual fact, in all likelihood, you would be able to access those communities from the north.
I see.
But I do accept that there's not highway evidence to show how that would occur. But nor is access a matter for determination at this stage.
No, but the transport assessment has
it does make an assessment
considered,
of that,
hasn't it? How, the traffic generation, all
yes.
the rest of it, and it certainly hasn't made any consideration without the Southern Relief Road, has it?
No.
Okay. But I'll take the point about Highsted North. It said villages, so I was assuming that you meant other parts of the Highsted area, but did you just mean that bit to the north?
Yes.
I see. All right, thank you.
Thank you.
Oh yeah, paragraph 10.2, just a minor thing. Yeah. Yes, that should read noise rather than air quality, shouldn't it? Impacts. You're dealing with noise there rather than air quality in that first
Yes.
section. Is that right?
Yes, I am. And unless I was dealing with noise and air quality, but I'm not, am I?
I don't think you are.
No. Okay, that mum's an error. I'll be glad to update the errata sheet.
Well, do you need actually do an update as long as I know what?
Yeah. Noise, 10.3, topic-specific statement of common ground in relation to noise is being produced.
So you're dealing with noise in those two paragraphs, aren't you?
Yes.
I would have thought.
So this is at 10.1. What does your heading say?
I'm saying 10.2, you say, relays the last line, raised in relation to either the north side.
No, sorry, I thought it was the title that was erroneous, but it's that last portion of the sentence in terms of should be noise impacts, not air quality.
Right.
Yeah.
Right, okay, thank you. Okay. Oh yeah, we'll start with that. Yeah, one of the things that you raise is the concern about the loss of rural workers' jobs, and that can be found at paragraph 13.2. And I just wondered, I think, perhaps it isn't that one actually. It isn't there actually, is it? Somewhere you're talking about...
Something about the rural economy, perhaps?
Oh, maybe I meant that, did I? Oh, yes, I did, sorry. Yes, 13.12, sorry. You talk about the rural workers and the loss of jobs.
Yes.
I just wondered whether you had any idea about the scale of that loss that you think might happen.
At the time of writing this, no. Subsequently, we have the evidence from Mr. Dobson. Actually, maybe it's not Mr. Dobson, but there's certainly a report that's been produced looking at employment density on farms, and that quantifies the number of people that would turn out that whilst they're quite large areas of land, the worker to hectare ratio is quite low. Do you want me to find that?
Well, yeah, I just wanted to get some idea what you meant, really.
I think it's mentioned in Mr. Bashford's evidence.
Yes.
And
just for the reference, in case it helps, in Mr. Dobson's proof of evidence, which yours, core document 37.9.2.
Yeah.
The number given, and it's paragraph 5.25 on page 35. Number given is 25 agricultural jobs.
Being lost on the southern site or both?
Yeah, I think that's across the. That's across the piece. That's the totality. Is 25. He explains the basis. He explains all the. I won't read it all out. But
okay.
There's a standardised DEFRA ratio applying to a hectareage of active farmland that leads to that.
Thank you. And that was what you had in mind, presumably.
Yes,
since you wrote it, I know it's...
Yeah, but so subsequent to writing it. So when I wrote this, I didn't have that employment density to hand.
Yeah.
I haven't got any figures in my proof as to what the actual numbers are.
But you don't disagree with that?
No.
Thank you. Okay. Yes, 13.38. Now this is all about town centre uses. And I didn't think the council were objecting on this ground, but you say, though, that if the employment were occupied by town centre type uses, then the proposals will be subject to town centre first test.
Yeah. Yes.
And the town centre uses will be out of centre in the location proposed, etc., etc. There's the potential to adversely impact, well, vitality and viability, basically.
It's just two things, ma'am. There are mixed-use centres have quite a broad range of uses that could be undertaken there, and that's quite logical given that they'll be surrounded by residential communities.
Mm-hmm.
There's also a town centre in the Highsted East development, which is kind of north of the science park.
Mm-hmm.
But if all of that space surrounding the Kent Science Park were to be used for town centre uses, rather than sort of serving a local community to meet their everyday shopping needs and mean that they don't have to drive down the road to even buy a pint of milk, it all makes quite good sense if you have a community to have a corner store that you can visit within
That
walking
wouldn't be
distance.
on the Kent Science Park, would it? Are we not talking about offices and things like that here?
Well, it's just if they were, the range of uses around the Kent Science Park could include shops. And it's just to say that that wouldn't be something that the council would be encouraging employment space, not retail space.
Right, well, I'll ask Mr. Bashforth about that then. But so you think that the in the employment area they could include shops?
We're not encouraging shops.
No, I know you're not,
it's just the range of uses.
Because it's Class E, is that right?
I'd have to go back to the range of uses. Bear with me. Okay. B2, B8 and use class E. Now, there are sub-use classes within E,
Yeah.
but we're not delving into the sub-use classes. We're talking about everything in class E.
Well, quite. And don't they include shops?
It includes all sorts of things, including shops and...
So I suppose my question really would be, would it not be important to preclude that? A bit, in other words, I know the reason was flexibility, but on the other hand, it could very well conflict with the town centre first principle, couldn't it? Because
well, if 170,000 square metres of it, the illogical conclusion being if all of it went to retail, yeah, that'd be a problem.
You could have a, I don't know, instead of a logistics, you could have a, I don't know, a out-of-town shopping centre, couldn't you?
Yes.
I mean, not that.
If it helps, the development specification we can go into, it does control it beyond just Class E.
I thought it didn't.
Okay.
Right, okay. Well, we'll talk about that.
Obviously, we will talk about it, but just so everyone's
okay,
clear.
right, in that case, that's all right then, thank you.
And there's a condition session as well. I guess if they're, in addition to the specification, if the concern still exists, then we could look at potentially a condition.
Yeah, okay. So you're saying that this is in the legal agreement, or is it in the...
It's the development specification to be controlled by conditions.
Be a control.
Development specification, which will be baked into conditions, obviously, and within the dev spec, it breaks down. It says Class E, but then it says specific things, and it says the bits where you can have shops, etc. But we'll to be returned to.
Right. Okay. Well, we'll sort it out then. Thank you. Okay. Next thing I just wanted to ask you about was paragraph 14.26. This thing about seeking a higher proportion of affordable housing than the level of need if development viability is not compromised.
Yes.
Now, I know what the policy says, but if they were, I mean, I know again there's a disagreement about what is the policy level, but just supposing, for the sake of argument, that it is 40%, as you think, and so if they were providing the 40%, then there would be no justification, would there, for a review or a higher level if viability is not compromised, would there?
And so, no, we wouldn't be seeking, it's not as if there's no upper limit.
So, I
mean, the wording
really
is as if there is no upper limit, but I don't think it should be interpreted in that way.
Well, but I mean, if you say or higher, I mean, I just can't see how that complies with Regulation 122, really, because if they are meeting the assessed level of need, and I know this is in the Section 106 agreement, or I think, or the condition, or whatever it is, if they're meeting the level of need, then how can it be necessary to go higher?
I guess it's that point of assessed level of need or the target which is set out in policy DM8, like the 40%.
But is that, is DM, I don't know, DM8, it actually complies with Regulation 122, does it? I mean, do you usually do that? Do you usually put a clause on that they have to go, if you have a review, they have to go as high as possible, providing it's
No.
viable?
So the way it's done is, let's say the target is 35% in Faversham, they can't afford to do that, they can only afford to do 20%. The viability review would go to 35.
Yeah, but not all higher.
No, not all higher.
I think that needs to be looked at when we come to the session then. Okay.
To be clear, at the moment, the 106 does not, that you'll see on the 13th, has not got a 40%
No, I know.
option in it, but it's got a 27.7.
But it's still it's the
But it's the logic is the
higher,
same, or higher. It's the logic, exactly. No, understood, and we'll come back to it.
And I don't understand how that can be justifiable. Oh, I see. Right. Okay. Well. Okay. Now, hang on. Oh yes. Just a small point on this care, the acute care, Mr. Steigen.
Yes.
I'm presuming that when the local plan was being before it was adopted and with all the background and so forth, there would have been an assessment, wouldn't there, of the to ensure that all of the funding was available for the amount of housing need that in that local plan, all the funding for acute care and all the other things,
So,
wouldn't it, in the bearing fruits?
yeah, so we have talked to the NHS about this. That I think what has happened is that at that point, they weren't seeking funding for acute care because they either hadn't realised that they had a capacity issue or they didn't have a capacity issue. But since 2017, they have realised that they've got a capacity issue and no funding to address it.
But you said that they hadn't ever asked for funding from any of the other developments that have been approved.
As far as I'm aware, the first request for the acute care funding related to these two applications. Since then, the NHS, I'm not aware of every application in Kent, but what they advised me is that they are consistently seeking the acute care funding in relation to all schemes of a large nature, and indeed they let me know regularly whenever they secure that funding.
And when you say of a large nature,
I'll need to go back to their SPG, but there is a threshold of size when they will seek the funding.
so which SPG would it be in?
Oh, it's not an SPG, but they have a guidance document, and I'm just going to see if there's a CD for it. This is CD 32.4.
So that would, I see. And that's one of their documents. It's not, is it
Yes, so it's one of their documents.
not one, it hasn't got any statutory or...
So, no, we haven't adopted it. We do use it. Now, there had been a previous guidance document from about 2009 that the council had been relying on previously, and that set out various matters in terms of...
Just so everyone's clear, that document that's been referred to was produced by the NHS in March of this year over
Yes.
the course of the duration of this inquiry in response to correspondence from us.
Yeah, but we've been told that since 2017 they've realised they've got an issue.
Yeah, no, I'm saying that I appreciate that. And I'm just saying, just as a matter of fact, the document that's been referred to, just so you know what it was March 25, i.e. this year,
Yeah.
and it was not consulted on. It was produced by the NHS as part of the back and forth over this inquiry.
Okay. So just you said you're not aware of other schemes in Kent, but just as far as Swale's concerned,
Yes.
so this was the first scheme that they asked for the contributions.
Yes.
And I think you might have said, or someone said that the Faversham, the Duchy scheme, they've also asked for it, haven't they?
So they've requested it on the Duchy scheme and in relation to Winterbourne Fields, and I'm pretty sure they've requested it on the bobbing scheme as well, and there are others.
What was the second one you said?
I can either give you the planning I know them as sites with a particular name, and they may have 2 or 3 different names.
Right,
It's kind of like Stones Farm and...
Oh, I see. Okay. Well, Stones Farm, they weren't asked for any.
No, that was well beforehand. It was just to warn you that I'm giving you names of schemes, and people might call them by different names.
Well, okay. Well, so there's Duchy scheme, and then there's a few others that have come up quite recently. Is that right?
Yeah, it's just been... What I'm going to hope to do is give you some...
We don't need to give me at the moment those.
Okay.
No, thank you. Okay. So presumably, what happens then with the new local plan? How's it? Presumably, there will have to be some sort of a. I mean, this would be something, would it, that would be expected to be addressed through SIL? Would it? Are you?
I'm not sure that we don't have.
No, I know you don't.
SIL at the moment. No. So the approach to acute care that's going to be taken through the emerging local plan has been paused pending the outcome of the Highsted decisions, because it rather determines, depending on what the outcome of the Highsted decisions is, if they're approved and the Secretary of State includes or excludes the acute care, that will dictate the approach to acute care within the emerging local plan.
I see. Okay, thank you. Yes, paragraph 18.40. Nearly finished now, you please know. 18.40.
Yes.
Just a minute. Yeah, you said there, you said further discussions are necessary to understand highway costs. If these have been underestimated, the level of affordable housing which can viably be provided may reduce, and this would alter the weight afforded to affordable housing. And this would alter the weight.
So I've got two words repeated there.
Yeah, I know, but it still doesn't quite make sense. But, alter the weight afforded to affordable housing would need to be reconsidered. So my question is, if, because of viability, less affordable housing can be provided because highway costs, for example, are higher, or it could be the acute care, all sorts of things, does that then affect the weight that you give to the affordable housing? Are they linked, do you think?
So affordable housing is very important.
Yes.
However, if you had only one affordable housing unit amongst 7,150, I think you would recognise that that unit is particularly important, but it's not going as far to addressing the need as it would be if there were 500 affordable housing units. So I'm not saying that more or less affordable housing affects weight, but if you have a fairly sort of significant change to the point where you're either delivering a lot more or a lot less, then I think it could have a bearing on the amount of weight.
Even though there is provision, as things stand, for viability review.
Yes, so just to put this in context though, at this point we weren't aware, we were aware that the Highway Authority were considering costs, but I didn't have any idea as to whether they would find anything out about that, whether they would find that there's an issue with highway costs or not. I was just flagging that they were looking into it. As it transpired, we heard quite a bit of evidence about highway costs.
Okay. But I mean, we're not talking about one affordable house, are we?
No.
I mean, that's a bit extreme, but
just if
I mean, I suppose if only one was viable, then, that would still be important.
it would still be important. I just think quantum.
I'm sure this is understood by everyone, but obviously the only reviews are upward. So even if highways costs, I'm sure this, I've said this before in the inquiry, there is no prospect obviously of them going down.
No, no.
But just to be clear.
But I think when he was talking about one, it was the sort of
Yeah, no, sorry, I'm not.
scheme
It was
going
just
one.
to illustrate. I think that
Yeah.
there is a difference between 1 unit and 1,000 units.
Okay.
They're all important, but if there was a wild swing, then that might be relevant.
But the policy does specifically refer, doesn't it, to viability?
Yes, it does.
Right, paragraph 18.15 next.
1.5.
Sorry, we'll go. Oh, well, actually, we could go forward because you said it again in 1853, 18.53. You say here. Oh yeah, you said about the jobs, and I think you're saying that the weight that you give to the benefit would be reduced because this would be the case with any development. So you're saying really, I think, that because it's ubiquitous, i.e. it's applicable to any scheme, that it's not as important. Is that what you're saying?
So this is in relation to household spending, and it's just to recognise that the relative benefit of household spending by future households on the site would be very similar to other housing developments. That it's not as if there would be more spending from the Highsted households than other schemes. And similarly, like other schemes, there are benefits during the construction phase with jobs and spending associated with the construction. Mm-hmm. And in this case, though, I think that there is a difference. The scheme involves a junction with the M2 and 6 kilometres of relief road, which are not typical of most developments and are over and above the level of construction, jobs and spending that you would see. So I've put additional weight on that benefit.
See. So you're saying that just because something might happen somewhere else, it's not really as big a benefit as it might be, are you?
Well, in my mind, it doesn't attract the sort of weight that you would see from something which is, you can expect some benefits to be associated with any housing development, whereas with this one, this housing development would be associated with a relief road that would generate
I can see
more
your point
jobs
about the relief
than
road,
usual.
but I'm just talking about the other things. It's a bit like the, whether it's unique. I mean, you're saying that they've got to get any sort of decent amount of weight, they've got to be unique. It's a bit like the national landscape.
Well, I'm not suggesting that the relief road is unique,
No,
but
let's
it's
forget
certainly
the relief road.
yeah.
But the general construction,
Household spending or
all of that stuff.
So they are of benefit. I think it's the weight that I give to that benefit.
Yeah. But your argument is that they would be this would be a benefit experienced by any development, and therefore you're giving it less weight. But I mean, it's still,
It's still of benefit. I just don't see it as attracting more weight to take it from, say, moderate weight to significant. I see it as being contributing to moderate weight.
All right. Council tax funding, just looking at that as a possible benefit. So in terms of council tax funding, I suppose you'd say that's another one that they all attract. But is the council tax funding in this authority ring-fenced?
No.
So it could be spent anywhere, could it?
Sorry, could you just direct me to the paragraph number, ma'am?
Oh, sorry, 1831.
Local finance considerations. What I was reminded of by my legal colleagues is that, in actual fact, we should be taking into account local finance considerations, and I have done so. At the same time, I take your point, and limited weight has been given to that as a benefit.
But regardless of that, I just really wanted to know whether council tax, if there's any council tax that goes from this development that will go to the local area, or whether it's all just goes in a big pot and gets shared around the...
As far as I'm aware, it goes to a central fund.
I see. Okay. So it's not ring-fenced then, locally ring-fenced?
No.
Okay. Yeah. Just to make absolutely clear, I understand. The LDS,
Yes.
the new LDS, in terms of the Regulation 18 stage, none of the allocations will be considered, will they, including the employment ones?
No. And just by way of update, ma'am, I have asked the policy team to produce the note and let them know that we're looking for it within the 24-hour time period.
Okey-doke, thank you. DM, and the last thing is 19136. I was just wondering whether you could just explain to me why policy DM14, which is sort of general policy, is not fully consistent with the framework. You can turn it up if you want to. DM14, which is
bear with me now.
Oh, hang on. Oh, anybody got a page number? DM14.
You're looking for the assessment in terms of consistency with the MPPF?
I just wanted to know why.
DM14 is PDF page 248 of the plan.
I just.
So I'm just looking at my appendices, Mum. I'll just read. The policy is quite high level, conforms with the general themes running through the MPPF. However, not all policies, documents and guidance are up to date, and therefore criteria 1 and 3 should be considered on a case-by-case basis. Furthermore, the Council now has its own adopted vehicle parking standards, and reference to the County Council standards in criteria 10 is also out of date. I've given the policies a moderate level of consistency with the MPPF.
Sorry, could you just tell me what page it was again, please?
It was 248 of the plan in PDF.
Right. Okay. So sorry. Can you just So you're talking about supplementary. I see. So some of the supplementary planning guidance isn't up to date. You're saying?
That's correct. Which I think is criteria 1 and 3 need to be considered on a case-by-case basis.
Well, 1 is just in accordance with the development plan. I see. So you're saying that's not up to date. I see. Right. Okay. Is that what you mean?
Yes. And then, where are we? DM14. So,
Yeah, okay.
the final sentence of Part 10, it talks about parking and servicing facilities in accordance with the County Council standards.
Yeah.
The borough's adopted its own standards, yet we're referring to the county standards within the policy.
So I mean, really, it's not. Well, that bit anyway isn't inconsistent with the framework, is it? It's it's not consistent with the council's own standards, is it really?
No. I just felt that, it's a very useful policy we rely on for design purposes, and I have used it in the assessment of the applications, but I was just a bit cautious about how much weight to give it,
I see.
given that.
Yep. Okay, that's great. Thank you very much, Mr. Dygan. Sorry, it took a bit longer than I thought it would. Sorry.
That's all right. Mr. Dygan, I've got very little for you, just some points of clarification. I'll take them in the order that they arose. If you can think back that far, delivery and viability of the schemes.
Yes.
There was a point put to you. Well, first of all, to be clear, obviously the council doesn't take a point on viability, but there is an issue about its relevance that's before the Secretary of State. So it's
Yes.
now. It was put to you that since the emerging plan didn't carry any material weight, so what was the question, or the point being made? And in answering, you drew a distinction between the weight to be given to policies for development management purposes and deliverability causing difficulty with the plan.
Yes.
What is that distinction about? Can you explain, please?
Certainly. At this stage, policies haven't really been formulated, and as such, given that there aren't policies, you can't sort of put weight on the application of any policies. You know, if you're trying to make a planning assessment, you can't use the emerging local plan. So I've sort of said no weight in terms of that part of decision making. You know, how do you make an assessment of a particular element of a scheme against a policy that has not been written? But just to contrast, so that's if you were to try to use the emerging plan to assess an application, you wouldn't be able to do that, which I think is very different from saying that the evolution of the plan being frustrated by including within it a consented scheme which is not deliverable. That would then mean that the plan doesn't deliver on what it sets out to do, and it would start to become dysfunctional. And so it's just to highlight there are sort of two things going on. I don't give weight to the policies in the plan for making an assessment of the applications, but I think it is relevant to consider delivery in the context of the emerging local plan, and whether in its formulation it starts to be informed or dictated by the outcome of the Highsted applications. If they're included as allocations and they're not deliverable, there is an implication in terms of the functionality of the plan going forward.
Thank you. And again, the context is that the council doesn't have a viability objection, but what's the request that you make to the inspector and to the Secretary of State in the light of this point that you've made? Just
to make it very clear what their conclusions are in terms of deliverability, so the borough understands where it is. If it does have the Highsted schemes consented and it's quite clear that that they're deliverable, that's one scenario. But if they're consented and it's ambiguous, or there's something even less clear than that about deliverability, it puts us in a very difficult position. So it'd just be to make it clear what the Secretary of State's view is in terms of deliverability, as opposed to being ambiguous about it.
Thank you. Next point, please. Do you remember you were asked questions about the error you'd made in your initial analysis about the location of the sites within the high growth area? Do you remember?
Yes.
And you said that it hadn't affected your analysis or your conclusions, and you were challenged on that view. Do you remember?
Yes.
And one of the things you said was that the policies relating to the distinction between these two areas had fed into the policies of the plan.
Yes.
And that you had applied the correct policies that are related to the correct area.
That's correct. Again,
can you just explain, please, what you mean? You said at one point that you could go through the policies in the plan to explain that. You weren't invited to. I'm not inviting you to go through all the policies now, but could you say something to the inspector so she understands the point that you were making, please?
So you've got the area of high growth, the area of low growth. The policies that I think are most relevant for assessing these planning applications have been created with that background that you've got an area of high growth and an area of low growth, but the policies themselves that are relevant to the determination of these applications don't make a distinction between the two areas. So you don't get a policy saying, if you are in the area of low growth, here is the standards that apply. If you're in the area of high growth, here is another set of standards. The application of the policies that are relevant to this application don't distinguish between the two areas in terms of their detail. So when you make an assessment of the applications against the policies, it's not as if I've mistakenly assessed one as being in the low area and therefore it's failed on a policy test because it's in that area, or vice versa. So the overall analysis is sound. I understand the position I've made in error, and that's in my corrections sheet, but it doesn't make the overall assessment unsound. It doesn't change the way the policy should be interpreted and applied in relation to the two planning applications.
Thank you. Next, you remember you were asked about policy ST5 and the question of adjacent.
Yes.
And there was a suggestion that you hadn't dealt with this in your proof, and I just want to take you to a couple of references in your proof and then ask you about that, please. So if we just turn up your proof, paragraph 17.15.
I'm there.
Just remind yourself what you say there, please. And can I take you to, could you also look at 17.44, please, as well? I think 17.15 is the northern scheme, isn't it?
Yeah.
17.44.
Yes, I see those.
Okay, now you've expressed your conclusions quite pithily there. Could you just explain to the inspector, please, how, if at all, that has a bearing on your adjacent point, please?
So ST5 makes it clear that the Sittingbourne town is the principal urban centre and focus for the main concentration of development in and adjacent to the town. The extent of the development outside the area, and if you think about it, the northern scheme is actually the development, the housing, the buildings are set quite far from Sittingbourne, closer to Tenham, and certainly the southern application, with the exception of that Highsted North area, the small enclave of Highsted Road, are really actually set quite a long way away from the from Sittingbourne, and to the extent that I don't think it would be, if it's across the valley and very far away, it's not adjacent. So it wouldn't prioritise directing development to within the town or being adjacent to it. And so, yeah, from my perspective, it then has other impacts in terms of the erosion of individual settlements and the loss of agricultural land, which are other elements within the policy. I don't think that these schemes would accord with policy ST5.
Okay, thank you. Finally, I think you were asked questions about NHS and acute care, and we know that there's a Section 106 session coming up.
Yes.
And you touched upon the SIL tests, and you said that you'd made a SIL compliance statement.
Yes.
And you were also asked about the development plan. Can you just clarify, please, what the policy basis is, do you say, for the acute care provision, if it's to be sought?
So within the local plan,
Yeah.
again, I'm still relying on policy CP6. But we discussed this at length during the cross-examination.
Yep, thank you. Good. Thank you, that's all. Thank you.
Sweet, wasn't it? Thank you. Right, good. All right then. So, well done, Mr. Duggan. We've finished with you now. Thank you. Thank you very much. And tomorrow we're going to start with Mr. Bashful. Is that right?
That's right. That's right.
Okay. Is there anything else anyone wants to raise before we go?
No, thank you. Not on our side.
No. Okay. Right. Well, we will now adjourn till 9:30 tomorrow. Thank you.